Buongiorno a tutti. Diamo inizio ai lavori di questo importante, convegno che è stato organizzato dal nostro dipartimento, dedicato al tema appunto dello space law e dintorni, diciamo. Il titolo è un bel titolo, devo dire, è stato scelto, non a caso, Comparative Visions in Space Law, dall'idea del comparatista che appunto, assunte le vesti dell'astronauta, diciamo, si erge e riesce a guardarsi al di là dei sistemi nazionali per dare una prospettiva di sviluppo al tema del diritto spaziale, che è di estrema attualità per le nostre materie. L'idea di organizzare questo convegno è frutto della riflessione del professor Zolea, di Sirio Zolea, e poi condivisa da tutto il Dipartimento che ha sostenuto quest'idea. E la ragione è duplice, la ragione per la quale il Dipartimento ha voluto sostenere questa iniziativa è duplice. Da un lato, ovviamente, per l'interesse per l'attualità dei temi che verranno sviluppati nel corso delle diverse sessioni del convegno, temi che impongono chiaramente una diciamo una risistemazione, se così possiamo dire, dei concetti tradizionali dei concetti giuridici o degli istituti giuridici tradizionali, proprio in questa prospettiva di rivisitazione nell'ottica del diritto spaziale degli istituti tradizionali degli ordinamenti nazionali, e quindi la capacità di questi temi di coinvolgere anche diversi settori delle nostre i diversi settori scientifici del nostro dipartimento, e quindi questo è certamente l'interesse più immediato. E poi c'è un interesse anche proprio di prospettiva di sviluppo del dipartimento, perché l'idea che stiamo maturando è all'atere di questa iniziativa di istituire un centro di ricerca internazionale all'interno del Dipartimento su queste tematiche. Un centro di ricerca internazionale in grado di raccogliere i contributi, ovviamente, di studiosi, non solo nazionali, ma evidentemente anche internazionali, che ci diano una mano per sviluppare questo filone di ricerche, e anche per mettere a frutto, ovviamente, le riflessioni che emergeranno anche nella giornata di oggi. Quindi in realtà l'iniziativa di oggi dovrebbe essere l'inizio, diciamo, di un percorso che abbiamo immaginato di sviluppo del Dipartimento nella sua interezza verso questo ambito di ricerche, che come dicevo prima, pensiamo possa essere non solo fruttuoso, ma anche in grado di mettere in gioco anche l'interdisciplinarietà che noi cerchiamo in tutti i modi all'interno del nostro dipartimento, ovviamente, di rafforzare il più possibile. Quindi non mi resta ovviamente che ringraziare anzitutto il professor Zolea, che ha avuto l'idea e ce l'ha proposta e poi ha seguito passo passo l'organizzazione di questo incontro insieme al professor Zeno Zenkovic e al professor Giorgio Resta, che sono i comparatisti, diciamo, del nostro dipartimento, il gruppo dei comparatisti. Quindi ringraziare anzitutto loro e ovviamente ringraziare gli illustri relatori che hanno accettato di contribuire alla buona riuscita di questa iniziativa, appunto e augurare a tutti voi una buona permanenza presso il nostro dipartimento, ma soprattutto buon lavoro per la giornata di oggi e di domani, perché i lavori del convegno ovviamente come sapete si proseguiranno anche nella giornata di domani e sono stati organizzati in modo che la prima giornata sia una serie di relazioni su temi, appunto, attinenti al diritto spaziale, e poi domani c'è invece è stata fatta una call, e quindi, ci saranno dei paper, dei relatori che hanno presentato dei paper e quindi, la giornata di domani sarà dedicata proprio alla illustrazione di questi papers. Quindi grazie e buon lavoro. Do la parola al professor Giorgio Resta, che è prorettore per l'internazionalizzazione del nostro ateneo. Prego Giorgio.
Thank you very much, my dean. I have the privilege to say just a few words to welcome you in Rome, also on behalf of our president, Professor Massimiliano Fiorucci, who could not be here today, but he asked me to bring his own remarks for this very important conference. As Professor Carratta said, it is a very important occasion for our department, but I would say more generally for our university. I think it's important to note that in this conference, I counted 12 foreign speakers from several countries and continents. There is China, US, Canada, UK, Uzbekistan, India, Netherlands, and we might also count some other institutions. So this is very important. This is exactly online with our effort to bring Roma 3 more and more global, and both at the level of research and at the level of teaching. And the second point, which I would like very shortly to make, is on the same line as Professor Caratta, the importance of the interdisciplinary perspectives. So this is not only one of the most important topics for legal, institutional, and geopolitical development of the future, but it's also very important to represent in the analysis of space law not only the traditional international law perspective, which has been, of course, the orthodox dimension of space law, but also private law perspectives and other perspectives. And here we'll be discussing about property, contract, insurance, liability, which are all dimensions that are becoming more and more important. Personally, I think that whenever we talk about space law today, what is happening, it's something like the moment in which we Europeans were colonizing other parts of the world, the other terra incognita. So it was the creation of corporation, the East India Company, trying to get more and more territories through various legal tools and legal categories. The idea of terra nullius, the idea of vacant lands, the idea of occupation, which are very important categories that come from the old Roman law traditions, but are somehow used in order to realize dimensions that are more closer to sovereignty, more closer to imperium than to simple dominion and property. So what is happening today with Elon Musk and all other enterprises brings me back to the era in which Europeans were colonizing the world. Today it is the run for the outer space. So this is one of the reasons why I'm particularly interested to be here and to listen to the distinguished speakers. And once again, I would like to thank you all who are coming from all other parts of the world and also from Italy, of course, to be here for these 2 days of very important discussion. Thank you very much, and I wish you a very fruitful discussion.
E la parola ora alla professoressa Elda Turco Bulgherini, che è vicepresidente dell'Agenzia Spaziale Italiana. Grazie. Prego, professoressa.
Okay, thank you. for the conference invitation. I represent the Italian Space Agency at this conference. In consideration the fact that my speech on the agency is technical, I ask you the permission to swap to Italian. L'Agenzia Spaziale Italiana, come molti di voi sanno, è stata istituita nel 1988 e ricopre un ruolo di primo piano sia a livello europeo che a livello mondiale, in un campo molto vasto che va dalle scienze spaziali alle tecnologie satellitari, allo sviluppo dei mezzi per raggiungere e per realizzare l'esplorazione del cosmo. Come tutti sanno, purtroppo i trattati internazionali che governano questa materia sono particolarmente datati, perché risalgono tutti alla fine degli anni 60, agli anni 70 e nella previsione che l'utilizzazione dello spazio sia di esclusiva competenza della sovranità degli stati e che quindi tutti i benefici che si traggono dalla utilizzazione dello spazio debbano essere a beneficio dell'intera umanità. Ora, che cosa sta succedendo in questi anni? Si sta verificando un profondo cambio, scusate, di visioni. Quindi dalla esplorazione dello spazio alla sua utilizzazione originariamente riservati alla sovranità dello Stato è seguito un progressivo ingresso delle attività private con concrete, ovviamente, aspettative di profitto. Si tratta ovviamente di una vera rivoluzione, non a caso si parla di New Space Economy, proprio in relazione a questo cambio di passo nelle attività spaziali. Ora, sappiamo che le attività spaziali sono legate finora sostanzialmente alla tecnologia, alle scienze, alla sicurezza. Pensiamo all'osservazione sulla Terra, pensiamo alle telecomunicazioni, alla meteorologia. Quindi tutto è cominciato a prendere coscienza e che esso rappresenta anche un rilevante volano di natura economica. E quindi si assiste ad un profondo mutamento di prospettiva che formalmente è stato anche riconosciuto da alcune legislazioni, pensiamo a quella degli Stati Uniti, pensiamo a quella del Lussemburgo, della Francia e di alcuni paesi europei, in contrapposizione proprio a quanto stabilivano i trattati a cui ho fatto cenno. Quindi oggi i decisori politici si trovano di fronte ad una realtà completamente mutata a cui devono dare delle regole precise per affrontare il problema della sostenibilità dello sviluppo economico del settore. Ora, le risorse finanziarie italiane, adesso passiamo a capire qual è la situazione economica. Le risorse finanziarie italiane dedicate allo spazio sono in crescita da più di un decennio. Più di 3 miliardi di euro sono stati sottoscritti per i prossimi 5 anni al Consiglio ESA ministeriale del novembre 22. 2,4 miliardi sono il PNRR fino al 2026, 1,8 miliardi di euro per il piano pluriennale dell'ASI fino al 2026 e poi tutte quelle risorse indirette che arrivano dall'Unione Europea, dalle varie ricerche che vengono finanziate, pensiamo al Space Program, Horizon Europe. Si stima quindi che nel 2030 si possano raggiungere i 1.000 miliardi di dollari di valore. Questo vi dà la dimensione di che cosa stiamo parlando. L'Europa in questo momento possiede sistemi spaziali, basti pensare a Galileo, a Copernicus, di livello mondiale, con più di 30 satelliti in orbita e l'intenzione è quella di raddoppiarli nei prossimi 10-15 anni e con una previsione di spesa di 14 miliardi di euro nel periodo 21-27. E l'industria europea poi tra l'altro ha un numero di addetti pari a circa 230.000 persone, con ricavi complessivamente di 60 miliardi di euro. Quindi il volume degli affari europeo è inferiore solo a quello degli Stati Uniti. In questo contesto, l'Agenzia Spaziale Italiana, che ho l'onore di rappresentare, ha costruito uno stretto e continuo rapporto di collaborazione con l'Agenzia Spaziale Americana, con la quale partecipa a moltissimi dei più interessanti progetti scientifici negli ultimi anni, tra cui quello della costruzione della Stazione Spaziale Internazionale. Proprio in questi giorni avrete visto dai media l'operazione di Villa Dei che ha raggiunto la Stazione Spaziale Internazionale per procedere ad alcune sperimentazioni. E quindi qual è la mission dell'agenzia? È quella sostanzialmente di coordinare la comunità internazionale del settore al fine di favorire tutte quelle forme di sinergia tra gli enti di ricerca, le amministrazioni pubbliche, le strutture universitarie, il mondo dell'impresa, promuovendo la valorizzazione e la partecipazione dell'intera comunità scientifica nazionale di riferimento, in particolare con due strumenti: un tavolo permanente delle imprese che costituisce il forum per un dialogo strutturato e continuo con il mondo operativo ed industriale, e l'altro strumento è quello della collaborazione con le regioni, anche attraverso sinergie con i 13 distretti tecnologici che sono localizzati nelle regioni italiane. Ecco, una delle eccellenze italiana è sicuramente il fatto di avere in tutto il territorio italiano questi distretti di attività di piccole, medie e grandi imprese che sono di altissima eccellenza. Ma veniamo ad oggi, veniamo alla legge dello spazio. Il 2024 sarà un anno decisivo per la società che operano nel settore aerospaziale. Tra i collegati alla manovra di bilancio 2024-2026 figura un disegno di legge in materia di politiche spaziali e di sostegno all'industria spaziale, che non è stato ancora presentato in Parlamento, ma che dovrebbe approdarvi nei prossimi mesi per diventare legge entro sicuramente l'ottobre del 2004, in concomitanza con l'International Astronautic Congress che avverrà a Milano a metà ottobre. Come sapete, la delega allo spazio è di competenza del Presidente del Consiglio dei Ministri, che a sua volta l'ha delegato al ministro del MIMIT, al ministro Urso. E il ministro Urso ha nominato una commissione di cui faccio parte per redigere il nuovo disegno di legge che si prefigge l'obiettivo di incentivare e sostenere l'industria aerospaziale italiana, regolamentando le attività svolte da oltre 300 aziende di varia dimensione, piccole, medie, grandi, occupando oltre 7.000 addetti e offrendo ovviamente nuove opportunità di sviluppo nell'ambito della space economy. Come sapete c'è un vuoto legislativo, non a caso c'è l'esigenza di questa legge. Il vuoto legislativo proviene appunto da quelle convenzioni internazionali a cui ho fatto cenno, che sono assolutamente datate e insufficienti a regolamentare soprattutto le attività di diritto interno. Quindi il vuoto legislativo riguarda in particolare l'assenza di una norma di attuazione dell'articolo 6 della Convenzione del 67 in merito all'autorizzazione e al controllo delle attività spaziali svolte da soggetti privati. E questa lacuna non è stata neanche, colmata dalla legge 153 del 2005 di ratifica della Convenzione del 75 sull'immatricolazione degli oggetti lanciati nello spazio. Allo stesso modo, parlando sempre di vuoto normativo, faccio riferimento alla responsabilità per danni derivanti da oggetto spaziale dettata dalla Convenzione del 72, questa ratificata dall'Italia con la legge 426 del 76 e successivamente integrata con norme di attuazione del 93, rimangono aperte, dicevo, allo stesso tempo numerose questioni interpretative anche in relazione a questa Convenzione del 72, con riferimento sia alla tutela dei soggetti eventualmente danneggiati da oggetti spaziali, sia ai profili di responsabilità civile dei soggetti privati per danni causati nello svolgimento di attività spaziali. Il compito della nuova legge, quindi, sarà quella di dare organicità al settore e quello di colmare queste lacune normative, regolamentando aspetti rilevanti come ad esempio i requisiti e le modalità per ottenere l'autorizzazione allo svolgimento di operazioni e attività spaziali da parte dei soggetti privati. Fondamentale sarà anche l'introduzione di norme volte a tutelare l'ambiente spaziale sotto il profilo della sostenibilità nello sfruttamento delle sue risorse, come la gestione, per esempio, e il riciclo dei detriti spaziali. Cosa sta avvenendo nell'Unione Europea? Il 17 ottobre dello scorso anno la Commissione ha avviato la consultazione degli stakeholder, ovvero di tutti gli operatori satellitari, fornitori di servizio, di localizzazione satellitari, produttori di satelliti, i fornitori di servizio di lancio, gli astronomi. E questa consultazione è finalizzata proprio all'adozione della famosa legge spaziale tanto attesa, che è stata calendarizzata entro il primo trimestre del 2024. Nel discorso di apertura della 16ª European Space Conference di Bruxelles, il commissario europeo Breton ha confermato che la legge verrà emanata secondo le tempistiche programmate e quindi immaginiamo che verrà rispettato il primo trimestre del 24 e che verrà concepita in modo da non limitare l'innovazione dell'Unione Europea, ma soprattutto di potenziare tutte quelle start-up europee che potranno usufruire di specifiche misure di accompagnamento. Lo scopo della legge europea sarà sostanzialmente quella di introdurre delle norme comuni proprio per evitare la frammentazione delle varie legislazioni dei vari paesi e di eliminare gli ostacoli in tutto il mercato unico caratterizzato appunto dalla eterogeneità delle varie legislazioni e dalla mancanza, in alcuni casi, perché alcuni paesi ancora non si sono dotati, l'Italia compresa, dalla mancanza di legislazioni spaziali nazionali, garantendo ovviamente nel contempo la competitività del settore spaziale europeo in un contesto commerciale internazionale. Cosa sta facendo l'Italia? L'Italia sta partecipando a questo tavolo di lavoro a Bruxelles per la legge europea e ci stiamo confrontando su quello che sarà il contenuto della legge. Anche noi stiamo spiegando quali sono il nostro contesto nazionale e quali sono ovviamente le esigenze che l'Italia intende rappresentare. E i principi su cui la legge europea verrà informata sono tre, i cosiddetti pilastri. Il pilastro della sicurezza per garantire un traffico satellitare sicuro che affronti il crescente rischio di collisioni e danni causati dai detriti spaziali. Il pilastro della resilienza per proteggere in modo coerente le infrastrutture e i mezzi spaziali dell'Unione Europea e nazionali dai cyber attack e l'ultimo, il pilastro della sostenibilità, cioè garantire la sostenibilità a lungo termine delle operazioni spaziali, assicurando la capacità dell'Unione Europea di fare affidamento sullo spazio come fattore abilitante dei servizi e della crescita economica nel settore spaziale. L'ASI in tutto questo svolgerà, per le attribuzioni che le vengono conferite dalla legge, un ruolo fondamentale in tutte le attività spaziali, aerospaziali e suborbitali. L'Agenzia, anche grazie all'indirizzo politico e al coordinamento del Ministro delle Imprese e del Made in Italy, che ha, come ho già detto, la delega allo spazio, conferma pertanto il proprio ruolo di leadership nella ricerca a livello mondiale e conferma altresì il proprio sostegno alle realtà industriali del comparto nella consapevolezza dell'attuale e ancora maggiore futura rilevanza del settore. Inoltre, e concludo, l'aerospazio è uno dei pilastri strategici del piano Mattei per la collaborazione tra l'Italia e l'Africa. In questa ottica si auspica che anche sotto l'egida delle Nazioni Unite il draft Agenda Space 2030 si possa arrivare ad un quadro regolatorio globale per le risorse spaziali sotto l'egida, ripeto, delle Nazioni Unite. Infine, come professore di diritto della navigazione e dei trasporti, non posso non rilevare che questo Dipartimento non presenta ancora nella sua offerta formativa l'insegnamento di diritto della navigazione e dei trasporti impartito da un professore ordinario dello IUS 06, raggruppamento disciplinare la cui declaratoria ricomprende tra le varie materie impartite proprio il diritto aerospaziale. Comunque accolgo con grande piacere a nome dell'ASI iniziative quali quella odierna dell'Università di Roma 3 che sono finalizzate allo scambio di idee e alla creazione di momenti di confronto, iniziative a cui auspico tutto il successo che merita. Grazie dell'invito e buon lavoro.
Excellent. Good morning. My name is Mirko Sosai. I teach international law in this department. Welcome to Roma 3 also from my side. And congratulations to our colleague Sirio Zolea for really the impressive number of distinguished experts that have joined us this morning for discussing together comparative visions in space law. Panel 1 is devoted to the topic of legal models in space law. And the group of speakers actually is composed of Italian nationals. But I think this is also a chance for us just to recall the importance that space law studies have been in the Italian School of International Law in the past and nowadays. Legal models have constituted the continuous effort of scholars throughout the decades for a variety of reasons, not only in institutional contexts, but also in the context of scientific organizations. Space model rules have been proposed to national legislators and to international regulators as well. And the purpose has been, and I recall what our vice president of the Italian Space Agency has just said, to offer uniform standards to be followed by states, by international organizations, in order to comply with international organization and also to pursue certain public policy objectives, safety, coordination with aviation activities, transparency, and the protection of the environment as well. Of course, I won't go into the details of this topic and the relationship between model rules, domestic legislation, and international law, because this is precisely the topic of our first speaker that is very well known to everybody in this room. Sergio Marchisio is professor of space law at Sapienza University of Rome and emeritus professor of international law. He has been member of a variety of institutions, including the United Nations Committee on the Peaceful Uses of Outer Space, and he has been a chairman of the legal subcommittee for between 2004 and 2006. And it has been one of the leading experts in the field in our countries, and Sapienza University has been one of the centers of scholarship and teaching in this field. The topic of Sergio's presentation is domestic space law, domestic space legislation and international space obligation, great variety, key aims. Thank you very much for joining us this morning, and you have the floor.
Thank you very much, Mr. President Mirko. I come always with great pleasure to this room. The last one was when we had this very interesting seminar on Gaetano Aranjo Ruiz taught in international law. And even before, I remember many others occasions in which you organized some events, international law events. Today is really to commend for commending Professor, the organizer, now. The first name is very difficult to remember, Sirio Zolea, but I would like to take this opportunity to thank him for opening this new sector of study and research here in Roma Tre University. My contribution deals with two aspects, which are, if I may say, traditional. I don't want to go into the novelties of the field of domestic space law, but I think that we should start from the basics, from the beginning, to understand the evolution of the sector. And these two aspects are, on one side, the obligations of international space law that require the enactment of national space legislation on one side, and the second, the typical contents of such law in more than 50 now internal legal systems. The space legal community has always had a clear understanding of what is meant by space law, loi spatiale. The fundamental aim of such laws at the beginning has been, as they have developed over time, was and is to adapt domestic legal systems of states carrying out space activities to the international treaties of the United Nations to which they are parties, which could be, in fact, outdated and old, but they are still the basis for any kind of regulation. And this is shown by the fact that some states didn't have accepted them, still accepted them, and not implemented them in their legal systems. Of course, besides implementing international obligations, there are many other reasons for enacting national space laws. I will shortly mention the most relevant one: promote science and research, provide a coherent legal framework for space activities, ensure predictability, transparency, and legal certainty for operators, both public and private, respond to privatization and commercialization, control space activities, promote the space industry and startups, ensure safety, security, and sustainability of space activities, mitigate and avoid space debris, avoid damage and liability, safeguard national security and foreign policy interests. And I could continue. All these reasons are specified in the most recent space laws as the objectives to be pursued or the principles to which space activities should comply with. But as I said, I will mainly focus on the implementation of treaties perspective in line with Article 27 of the Vienna Convention on the Law of Treaties, which establishes that a party may not invoke the provisions of its internal law as a justification for its failure to perform a treaty. As has been already recalled by Professor Turco Bulgherini, in Italy, the adaptation to treaties has been realized through ordinary legislation containing the order of execution 3 of these conventions, the 5 conventions of the UN, have been implemented through an order of execution. The 4th one, the agreement on astronauts, has been implementing through the presidential decree, because there was no need to change ordinary legislation. So we have these laws, but some of them are insufficient to ensure the correct and full implementation of the treaty, like, for instance, when we adhered to the convention 20 years after its conclusion, to the Convention on Registration in 2005, we had to enact also some ordinary rules, rules of ordinary legislation, to complete the implementation of the convention as far as it regards the authority in charge with the registration, which is the Italian Space Agency, the procedure and the obligations of the operators with regard to the registration of space objects they launch into outer space or beyond. Along the decades of evolution of international space law, we had a parallel evolution of national space legislation in many countries, starting from the United States, of course, and continuing with the phase from the 80s to the 20s, which was characterized by a sensible growth of private actors and the enactment of laws aiming at regulating commercial communication activities, remote sensing, the establishment of national registries, or more in general, national activities in outer space. The last and present phase has consolidated the growing trends in domestic space legislation. Several states have enacted new acts: China, Belgium, South Korea, the Netherlands, France and Japan, Austria, Kazakhstan, Nigeria, Denmark, etc. The last one was precisely Luxembourg, Slovenia, and others. And some of them have enacted specific law on sectoral issues concerning space activities, like the protection of satellite data and other data coming from the space, big data, Japan, Germany, Finland, high altitude operations, and utilization of natural resources of outer space, like the USA, Luxembourg, and Japan. Such evolution shows a preference for a comprehensive model to regulate space activities, a single act, but complemented by one or more second-level regulation that address details and technical rules that cannot be included in a law, because they also need to be revised at certain intervals. So this is the general evolution, and this regards also Europe, where member states of the European Union have some kind of space activities. I would include also Italy, because we have some regulations concerning space. And regarding the initiative of the European Union, I would say that it seems to me that the European Union is in line with the prohibition in Article 189 not to harmonize national legislation. This is not the aim of the activity that, as Professor Turco Bulgherini said, the Commission has started, but to cover some sectors which are not directly space regulation of space activities. In fact, the legal basis of this projected new law will be the article on the single market, not the article on the space activities. But we will see what happens when the draft will be presented for discussion and for the legislative process. Let me say a few words on international obligations that require the enactment of implementing rules in state legal systems. In a nutshell, you know better than I, the relevant articles are in the Outer Space Treaty, Article 6, 7, and 8, which deal respectively with state accountability for national space activities in space, state liability for damages, and registration of space object. I would limit myself to these three pillars because otherwise I will speak too much. On accountability, we know that the treaties contain a very special rule that is not applicable in other fields of international law, which is the assimilation of the private activities to the public activities for the purpose of their attribuability to the state. And this is something very, very important because not only the operations carried out by institutional actors like the Space Agency, the ministries are relevant for the state and imply their responsibility, but also the private activities, the activities carried out by independent private operators. This is why Article 6, which is, as it is known, well known, a compromise which was reached during the negotiation between the Soviet Union and USA. The first one didn't want any kind of involvement of private actors in space activities, while the others wanted to have open space for private actors. The compromise was, well, we will assimilate public and private activities in outer space for the purpose of the responsibility of state, the liability, etc. But the state, the appropriate state, should authorize and supervise continuously these private activities. This is why national space legislation have started to regulate this point, the procedure of authorization, like a driving license, something like that, in fact. And now that there are more private operators than government operators, the importance of this provision is growing exponentially. Because, you know, it is not something very new, but in the last time we had a huge quantity of private space tech companies in outer space against about 130 governmental operators. We have more than 10,000 private operators. So beside major companies, the corporate space arena is expanded to include several small and medium companies and startups, without considering the global space economy and what was totaled in the last years and which will grow in time. Two aspects are reflected in the main chapters of every national space law we find worldwide nowadays. First, the scope of application. Razione personarum, razione loci, the identification of the activities in outer space that qualify as national activities of a given state carried out by national of that state, but also in some cases activities carried out by natural or legal persons of other nationalities which become relevant for the state as when the territory of such state is involved. In other cases, domestic space laws use both personal and territorial criteria without taking into consideration new modalities like the releases of satellites from the International Space Station or the release of satellites through aircrafts in flight, and or as it was more in the past, the launch from high seas platforms or something like that. There are states like the UK which are specializing themselves in this kind of non-orbital operations, and they have enacted very, very complex legislation in this matter. So it is, my point is, it is the utmost important to regulate such activities in a flexible way to include these emerging space activities in the light of a space sector that is constantly evolving. Apart from traditional space activities, launch, in-flight operation, re-entry, remote sensing, communication, etc., we have to consider non-traditional space activities, the removal of a space object from orbit, the space awareness activities, the exploration and exploitation of natural resources, logistic support services in outer space. And this is why, as I said, there is a need to constantly assess the adequacy of a certain national legislation to the evolving situation of the sector. As for the second pillar, the Outer Space Treaty contains the important rule that the appropriate state, apart from authorizing and supervising space activities of private actors, is also involved as a liable state when it becomes launching state. Because according to Article 7, we know that the state that launches or procures the launch in outer space is liable. And the first element we have to identify this state, apart from the publicity and transparency instrument we have, like the Register of the United Nations, is of course the fact that the state registered, because the launching state is the state that should register the object launched into outer space. Normally, launching state and the state of registry coincide. And this is why we have to look attentively to the four hypotheses which are stated by Article 7 of the Outer Space Treaty in order to consider the content of the national space legislation. But the main point is that national space legislation are also used to, if you allow me to say in this word, to change the paradigm of international space law. In international space law, the state is the only absolute liable in case of damages, retained accountability for all its space activities, and, as I said, register the object. But the purpose of national law is to try to involve also the private operators and to reverse the paradigm, saying that in reality, when we have private operators, the liable subject are the private operators, not the state. This is not in contrast with international law, because international law doesn't say anything about this point. And it is known that the liability of operators under private law for damage is practically regulated in all these national legislation laws, because there is a need to make the private entities share the onus of compensation in case of damages that are the charge of the state. I said that under the treaties, only the financial responsibility of the launching state is involved and not that of private operators and or owners. I mention owners even though the main focus is on operator, not on owners. Can be, I remember some legislation, we had a study on that. The Russian one includes also the owners for some reasons. But the launching state may require private operators to share its liability through provisions of domestic legislation. With this in mind, the national legislation space activities in many countries requires the operator to obtain insurance to cover damages up to a certain amount, beyond which the state provides its guarantee. The limits set by national legal system do not, of course, affect the regime of international liability. The French law of 2008 is very clear in this respect, but also others. Austria, Denmark, France, Greece, Finland, they have set the threshold at around 60 million of euros. And now the tendency is to try to lower a little bit to attract, of course, operators. In cases where the operator must compensate for damage caused to third parties that exceeds the set maximum amount, the state guarantees to cover the part over this amount. The insurance covers the entire duration of the mission. Of course, there are many other details provision on that, but I also notice the possibility of reducing the amount of the insurance obligation or exempting even the operator from this obligation if the space activity is conducted in the public interest or to promote the emergence of new private actors. This legal framework is normally complemented by the possibility for the state to seek redress against the operator if the state has compensated, in accordance with the treaties, damage caused by a space object during unauthorized private activities, in line with the threshold defined for financial liability and obligation to ensure the claim can be exercised up to the maximum amount payable by the operators. The last pillar, and I would spend really few words on that, is the registration obligation. We have already, as I said, in Italy, this. Probably at the time, the associated rules were enacted very, very quickly without reflecting well on what was said. And I think that I hope that the new space legislation will try to adapt this regulation already existing to the new practices that are developing at the international level. First of all, presently there is no link between the authorization procedure and the registration. I think, on the contrary, that it is necessary to include in the authorization licensing process also the documentation concerning the registration of the space object and together with the information concerning the compliance with the ITU frequency allocation filing. This is shown by some recent national space legislation. Another point is the need for the operator to comply with a maximum time limit for providing the information required for the registration. Yes, I would try to find my last page. And sorry, I left it here. These are, as I said, the essential elements of a much broader and constantly evolving topic. Before concluding, I want to briefly address one emerging issue, which is also linked to the model of legislation that I think is adequate for any state, namely a model composed by a law containing the main provisions and principles and more detailed regulations of second level, setting out technical rules that are needed for addressing the complex world of international standard on space traffic management, on orbital debris management, on launches and re-entry operations, on collision avoidance, and so on. This new content concerning emerging space capabilities that cannot be addressed adequately in the base national space law need regulation that can be even adopted in form of guidelines, not necessarily in legally binding rules. This perspective is, in my opinion, necessary to support developing space business active in the field of on-orbit services, satellite refueling and repair, full rendezvous, proximity operation, docking maneuvers, assembly and manufacturing activities in outer space and celestial body. A speedy and modernized licensing regime is also critical for enabling the state to tackle emerging space threats and improving the integrity of space domain awareness effort. Probably this is one of the points where the EU space law will help so much. Safety, sustainability, and resilience, as we have heard from Professor Turco Bulgherini. And finally, even more importantly, space legislation should testify the commitment of state to protecting the space environment, including provisions for periodic review of orbital debris mitigation requirements. This represents a challenge because regulation on commercial space activities are to be strong enough to promote the safe and predictability use of space, but flexible enough not to stifle innovation. New legal frameworks should foster a competitive environment that attracts new investments, encourages innovation and novel space activities, and benefits the economy and national security. Space laws are no more sufficient. Objective rules and standards linked to access to finance, insurance, licensing, and market access of other countries. This is another perspective we should take in mind, will help ensure the integrity and usability of space for future generations and preserve Earth's green mantle, which protects our life in the Earth space ecosystem. Thank you for your attention.
Thank you, Professor Marchisio, first of all, for keeping 20 minutes allocated to each speaker and for the overview that he offered on the challenges posed by domestic legislation governing space activities. Professor Marchisio identified the classical pillars of authorization, registration, liability on the basis of the existing obligations under international law, and the new challenges posed by non-traditional space activities, including the exploitation of space resources, the new challenges posed by suborbital flights also as well. Maybe it's a matter that we are going to discuss later on, but also the legal techniques. So a good balance between hard law and soft law solutions. In this framework, I think the second speaker could offer additional thoughts. And I'm very grateful that the president of UniDroit is with us today this morning. Maria Chiara Malaguti is also full professor of international law at the Università Cattolica del Sacro Cuore. Thank you very much, and you have definitely the floor.
Thank you, Mirko. Thank you, Sirio, and thank you to everyone at the Roma 3 who invited me. I start with adding something to what Antonio Carratta said. There is also another new inside Roma 3 and the Department of Law of Roma 3. I can speak even if I'm not part of Roma 3, we just opened a center which is called Roma 3 UniDroit Center on Transnational Commercial Law and International Arbitration. And I'm saying this because it's connected to what I'm going to say today, in the sense that we will try to do our best to address all possible issues. And of course, space law will be one of these. So what is interesting is that the two will speak together and work together. Now, so thank you for the invitation. And even if I feel home, so it's sometime I can't say, I don't feel I'm invited any longer. I would say I'm part of the group of Roma 3. What I'm trying to do now, starting from what Professor Marchisio said, is try to propose nothing too imaginative, just to try to see what could be next in respect of the kind of landscape that Professor Marchisio indicated. When I mention the transnational law model, I do not mean any imposition of lex mercatoria or things like that in a sector like space law. That, in my understanding, would be crazy, would not make any sense in context of this kind. And it's also not the modern understanding of transnational law. So in any event, it would be in any event partial, even outside space law. What I will try to do on the opposite is try to see how you can have public international law instruments and other kinds of instruments simultaneously to regulate, in fact, the future of space law, to take care of non-traditional activities, but also to take care of a number of challenges that have emerged because of the new technologies, because of the new activities, because of the evolving state of the markets in general. So this is basically what Professor Marchisio described, with all the challenges that are involved in this kind of regulation that we have now. But try to see what indeed can come next because of the kind of challenges that emerged. They were all, one way or the other, already mentioned by Professor Marchisio, so I don't need to elaborate on them. But consider that transnational law takes care of commercial private law and commercial law for the most. So the point would be how we can address issues that are not fully addressed by international treaties at this point in time. One of the issues, the main issue that you all know very well, is the famous Article 6 of OST that Professor Marchisio already mentioned. Here, the issue itself is a policy, or I would say even a political issue, that cannot be solved through transnational law instruments. It is an issue that has to be discussed and probably solved at international level with treaties. But what comes next is, once you accept the concept that, of course, there is the possibility for private actors to become owners of something. The real issue is at that stage. So when the policy or political choice is already made, the next point is, when do you become owner of something? What does this exactly mean? Can you share ownership? Can you get entitlement or rights on something? I didn't mention IP here, but of course, one of the main issues is also, how do you protect intellectual property rights? You might say that the same solution that are used in other sectors can apply also to the outer space. It might be not, in fact. And I must say that recently we see more and more that traditional concept or traditional schemes might not be sufficient to address the new technological aspects. So it's not really directly a space issue. It might be an artificial intelligence issue. Where what you get is that you cannot always use the same legal concept we are used to. Just to mention one, digital assets, and the fact that at UNIDROIT, in the first place, we had to elaborate principles on how to functionally express or regulate the typical rights linked to ownership without directly speaking of ownership, because you know that in some countries you cannot have ownership on, above, over immaterial goods. So in order to cope with the differences in legislation, you do need to come out with a new concept. I've no idea, it's up to you to tell whether in the space economy and in the space landscape you would use with no problem the old categories or whether you need new categories. In any event, this is a work that is normally done through transnational law, which might come up with a treaty, so with an extremely traditional way of regulating the international landscape, or with soft law instruments, possibly model laws, which are soft in the sense that you are not obliged to exactly repeat the content of the law, but which is somehow hard in the sense that once you adopt those principles, you do have the same regulation all around, or you use at least the same terminology. Of course, this issue is particularly relevant when you get into all the issues that concern spice mining, because over there, indeed, the ownership of natural resources is indeed an issue. And I would say that over there, you do commingle public and private elements, which is the reason why I think that in the space law, the way of addressing these issues is peculiar. I do believe that even if you use the old concepts, you do need to find a way to balance and really sit together the public law aspects, or if you want, the common good aspects of the thing with the use of natural resources. Second kind of issue, which is related to what Professor Marchisio said in respect of national law. You do have a number of issues that you need to regulate for the way it works now at the international landscape, the international law landscape, which requires indeed that domestic law takes care of some core aspects of the general governance, which is something, again, which is a bit special in the sense that it's quite normal for us to have harmonization conventions in international law. But what I think is peculiar in the space sector, that the international conventions do give a lot of room for domestic legislation and the kinds, especially because, as Professor Marchisio said, everything which is connected to the commercial aspects are at the very end left to the law of the state. So you do need to find international governance solutions that are a bit different, because you do have to coordinate. And Professor Turco was mentioning this in respect of the European Union. One a relevant point in this context, so the way of making domestic law speak together in this kind of issues, is that indeed what unification of law or approximation of law is not necessarily harmonization of law. Especially at the international level, you do not harmonize necessarily, but you do try to find a way to make legal order speak, to find functional solution to the same issue through the specificities of legal order. So you can indeed reach this result without a 100% harmonization of legislation. You can reach the same goal by way of simply approximation. Which are the issues that might need to be solved? Licensing for commercial space activity, the issues of responsibility, and once again, as it was said, and I know that also there will be an intervention this afternoon by my colleague, Professor Pedrazzi, who will address the liability and responsibility issues. Again, you do have a public international law aspect of responsibility of states, but as was already said by Professor Marchisio, a strong aspect of responsibility of private actors. You do have to regulate those, also taking into consideration the private law aspects of the issue. How do you link the two together? Again, it's for the new way of regulating the sector. Finally, I can see I only took 3 slides on the core elements of what I think is, private most relevant for the commercial activities. Of course, there are many more issues that we can discuss, but these are probably the core issues that you might have when you have commercial activities, with probably the addition of IP, which I did not include. The insurance sector, I do understand that not only insurance is of course relevant, but I do understand from what I read on newspapers and articles that there is indeed an issue also on insurance and possible reinsurance because of the high cost of this sector. Once again, you normally have principles or some sort of common guidelines on how to solve not only insurance but also reinsurance of these specific sectors. You can have insurance instruments, or you can have alternative means to reach the same goal by way of different forms of financing that protect you. And it is the same functional role of insurance, but it gets, again, by way of pooling assets, the possibility of getting the same level of protection. What does it mean? When I say pooling, I again insert an international element. A pooling of companies, a pooling of financing, a pooling of commercial activities means the necessity to establish private law schemes for that kind of cooperation, with an extremely relevant element of applicable law, which is another issue that should be taken into consideration, or which is the applicable law in these kinds of situation. You see, once again, issues that are not addressed by current international instruments. So what kind of solutions? I would say I would start from one major point, which is what I think I can understand for what Professor Turco and what Professor Marchisio said today. Possibly today, when it is extremely difficult to reach agreement on international treaties, I think we would all agree that to have a treaty today is extremely difficult. States do not get to agree on almost anything today, unfortunately. We see it on IDRA little for the way we work, but UNCITRAL sees is at all possible stages. You don't get to the end of anything because there is no agreement. I understand in the space sector, it is somehow similar as a phenomenon. So what's happening? The most is dealt with at the national level. So here, the real issue will be, of course, you can have treaties with core elements, but you do need an instrument to have these national laws to coordinate. So if my assumption is correct, if it is correct that what is used at the international level is for the most soft law instruments and then domestic law to concretely regulate, then these are some of the possible solutions that you have on the table. Do we have a modern treaty like the Outer Space Treaty, the OST? I've read some articles of people that were considering the possibility of having a transnational governing body with a set of ground rules. But of course, I would prefer somehow, for the kind of job and life I do, possibly the simultaneous existence of national law and with soft law instruments plus, and here is where I think transnational law could give some addition to value added to the exercise, is possibly the use of the instrument of model laws. I think that if you have treaties and model laws, new treaties possibly, or upgraded treaties and model law, you might reach the possibility, the solution of finding a common ground for this sector. Let me mention only 3 possible ways. 2 already exist, and then for what can be for the future. First of all, you do have already some convention that can also apply to the space sector. Of course, these are not core activities that are regulated, but what Professor Marchisio defined as a sort of ancillary activities that need to be referred to. And here I do some advising, some publicity to the UNIDROIT instruments. You all know very well, people on this table do for sure, that UNIDROIT has a Cape Town Convention on asset-based international financing, which has the specificity of having an international securities and international registries for guarantees. This is the convention that works on the basis of protocols. Some protocols, one protocol, the one on airspace, that ENAC knows extremely well because they try really to have this finally adopted also in Italy. We have, which is already in place, we have one on rail, which is coming on, it was already adopted, but it will be enforced in a week, 10 days. And also, in addition to other, one on satellites. And this I'm saying, Professor Marchisio knows very well, not only because he negotiated it for Italy, but also because he was the chair of the group. So basically that protocol is his baby, if I can say. I don't know whether he's proud of that or not. I am, because it's an UNIDROIT project, but it is to show you, I mean, I don't want to sell the product. I want to show you how you can indeed have a number of satellite conventions that can help the sector. This is somehow traditional as a method because this is a convention, and this does not regulate anything specifically or what Professor Marchisio called non-traditional activities. We are speaking of financing, which is extremely relevant for any global activity, but it's terrestrial work one way or the other. But then you do have another instrument, which is a specific dispute resolution mechanism, which opens up all a sector of what can be solved in the transnational law way. The Permanent Court of Arbitration in Den Haag elaborated guidelines, I mean specific rules for the space sector that would apply to state, to intergovernmental organization and private parties arbitration. As far as I understand, it has never been used yet. So for time being, I could only say that it is an attempt to try to solve the issues, but it helps me to get in the last minute I have to get to the very end. Through arbitration, you do offer to transnational law a test branch where you can indeed try to use model laws, which is probably the most concrete result, to try to solve issues like third-party responsibilities, ownerships, or things like that. But also address the issue, which I did not, but I think we should at some point, also on contractual schemes for space. I proposed something that UNIDROIT did not take yet, but I see whether Sirio can hear me better than my people at UNIDROIT. I really would like to see something like UPIC on Mars, to see how you can apply transnational principles for contracts, for commercial contracts on Mars. Again, I'm not selling anything provocative. I'm not selling anything strange. I'm saying in the space sector, because of the new governance and the new structure, where you do have the private sector present 100%, you do need additional tools to what you have now. I think these, without being too revolutionary, do permit you the flexibility and dynamism that the regulation of this market might need. Thank you.
Thank you very much, Maria Chiara, for offering us not only a clear indication of the future challenges, but also some concrete solutions that can be taken into account. Also by taking a flexible approach that takes into account a combination of different instruments. And thank you very much for mentioning our cooperation, also possibly in the field of space law. Thank you very much. We definitely, I think that we all agree that it's a fantastic opportunity for our department. Maria Chiara Malaguti is the first woman to be appointed as president of UniDroit, and I take the chance in this respect to pay tribute to a scholar and a woman that was a mentor and a friend for many of us, including in this room. I see Professor von der Dunk, that is Professor Elisabeth Bachin-Palomeni from the University of Padua. I graduated with her, and I do remember very well the space law classes that I had with her in Padua, and I'm very happy that there are several colleagues from Padua at this conference, even though I never had the chance to be back in that university after my graduation, but I'm very happy to be in Rome in any case. So next speaker, sorry for this personal account, but I think that it was important to remember one of the pioneers of space law studies in our country. Marco Di Giugno is the next speaker, is the Juridical Analysis Director of ENAC, the Italian Civil Aviation Authority. And the topic of his presentation is a regulatory framework for the prospective commercial aerospace transportation operations in Italy. And you have the floor. 20 minutes also. Okay.
Thank you. Thank you to Roma 3 University and Professor Sirio Zolea for giving me the opportunity to share with this qualified audience the ENAC experience in regulation of suborbital flight. Several operations have started their commercial operation with space plan. In particular, on July 20, 2021, Blue Origin successfully completed its first crewed mission, Blue Origin NS-16, into space using its New Shepard launch vehicle. The flight was approximately 10 minutes and crossed the Kármán line. New Shepard performed 6 crew flights between July 2021 and August 2022. Taking a mix of sponsored celebrities such as Wally Funk and William Shatner, as well as paying customers. I'm usually open. My speech in this matter says that space activity now is at the same point that aviation flight is in the beginning of the 19th century. So we have to start this activity in space commercial activity, have the experience of the aviation Virgin Galactic conducted its first commercial Space 2 suborbital flight on June 29 on 2023. Virgin Galactic's Space 2 vehicles VSS Unity separated from its VMS Eve mothership aircraft at about 11:29 a.m. Eastern above cloudy skies in southern New Mexico. The vehicles took off from Spaceport America at 10:30 a.m. Eastern. Italy, also thanks to the ENAC FAA Memorandum of Cooperation of 12 March of 2014, recently renewed and extended to Agenzia Spaziale Italiana, and with the valuable support of Italian Air Force, has the potentiality to allow this kind of operation from the territory under an regulatory framework that can be set out in accordance with the Italian Air Navigation Code. According to recognized definition, IDES DICAO definition, a space plan involved in commercial space flight operation must be considered an aircraft. Moreover, it appears clear that in an European environment, future commercial spaceflight design, production, maintenance, operation, and licensing activities shall be carried out under the EU and EASA legal and regulatory framework that, in any case, for time being, hasn't been set up yet. Meanwhile, in order for operators to be allowed to start spaceflight operation from Italy in a relatively short terms, ENAC envisaged the possibility that the suborbital space plan shall be considered as aircraft specially designed or modified for research, experimental, or scientific purpose, and likely to be produced in very limited numbers and therefore operated under the Italian national rules as provided in Annex 1 of the present EU Basic Regulation number 1139 of 2018. In this respect, due to the fact that experimental aircraft are not normally allowed to conduct commercial operations, specific expansion could be used for space planes, and as an example, flight crew and participants should have to be duly informed before flight of the inherent risk of the operation and acknowledge the receipt of this information in writing and informed consent. In doing so, this paying participant will also acknowledge and accept that they will not benefit from the normal safeguard expected for the commercial transport. In this of paramount importance to be clear about the risk with the involved people, impact space plans cannot currently active the same safety standard on as commercial aviation, even if they will be able to do it. Therefore, before allowing a space plan to operate from Italy, the government should be aware of the accept that this kind of operation carry a higher degree of risk than most considered aviation operation, at least for the people on board. On the other hand, the risk for involving the general public, the third and the good on ground, should be protected against the risk coming from this kind of operation at the same level of the current commercial aviation, or at least at the same level of corresponding segment of manned aviation or similar approach that been following by ENAC about the risk of third parties on ground coming from unmanned operation based on the ICAO equivalence principle. So considering the development of commercial space travel with winged vehicles having takeoff and landing capabilities potentially from a consistent number of locations within the same country, engaging aviation space with suborbital paths and trajectories impacting the consolidated commercial and general aviation traffic, and providing a service for human and good transportation, ENAC, the Italian Aviation Authority, has considered it necessary to start a progressive involvement in the aerospace sector. The above has led to signing the non-binding memorandum of cooperation and commercial space transportation development between ENAC and the FAA on March 12, 2014, and the number of available meetings and workshops among ENAC, FAA, and AST, Office of Commercial Space Transport, and the Italian Air Force, the latter under an additional agreement for cooperation with ENAC for the scope of developing procedure and standard to support flight test activity of a commercial suborbital flight within Italian national airspace. The renewed Memorandum of Cooperation, FAA, ENAC, and ASI, signed in Rome last 3rd Jan of 2016 and actually enforced, and the associated continuing cooperation with the Italian Air Force provide further impulse to ENAC to become a qualified reference point for the prospective activity of suborbital space vehicle in Italy. The legal regime applicable to space plan depends on the definition of outer space and the boundary for where it begins. A useful convention would be considered outer space the region above the outside the Kármán line. But the issue whether it's possible or useful to establish a legal boundary between airspace and outer space has been debated in the doctrine since the beginning of a space mission. The conventional and informal limit of 100 km indeed is often referred to as separating an airspace operation. Some states have included in their national legislation, but there is no consensus of a global level. For the space community, space operation seems to release to operation aimed at going toward placing an object in orbit, the lowest circular unpropelled orbit beginning at around 100 km altitude. The ICAO Legal Committee at the UNCOPS have suggested to look at the purpose of the intent of flight to determine whether it is a space aviation operation. Flight, which is to be passing merely in transit through suborbital space in the course of an Earth-to-Earth transportation, would remain subject to air law. The implication of strict outer space delimitation on the sovereign rights and national security against the progress of space technology reflected on the fact that no agreement still exists on a fixed airspace outer space boundary, while alleged consensus has been reached on the 5 space treaties. I think, but it's possible to have a Chicago Convention for space activities is the one of the issues that we have to affront. Although space planes are not mentioned in the above treaties, it seems appropriate that for a portion of mission where a space plane behaves as spacecraft, the space laws is applicable. That implies briefly that each state is responsible that space activity carries out by state citizen organization and consistent with the international obligation of the state and do not jeopardy public health or safety of person or property. Moreover, the state must provide and update the register of space object launch and accept liability for third-party damage. Besides, according to the ICAO definition of aircraft, space plane can undoubtedly be considered an aircraft for the portion of the mission where they derive support in the atmosphere for the reaction of the air. Therefore, the existing set of civil aviation safety regulation would also apply to them and, generally speaking, to the space plane's commercial operation because involving paying participant or good on board. In the EU, safety aviation rules are prepared by EASA, European Agency Safety Agency, and used by EU institutions in the form of regulation covering aeronautical product certification containing airworthiness, personal licensing, aircraft operation, aerodromes, and airspace navigation. With this DIMS framework, since spaceplane used the spaceflight experience would be providing air transport, they would be expected to comply with the standard of the commercial transport, which are generally more demanding than those for general aviation or light aircraft. During last years, following a mandate by European Commission and with the support of a task force member state, EASA explored the preparatory action required for a future regulatory framework on higher airspace operation above flight line 550. This operation, which do not exist on a large scale of Europe, can easily be defined as air transport operation carried out by various types of aircraft or vehicles system in the volume of airspace above altitude where the majority of air services are provided today. Following the initial analysis of the impact of the future high operation on the existing regulation framework from a total system perspective, it can be concluded that while the EU treaties and the Basic Act allow for some of these operations and give a shared competence to EU to regulate some of them, notably those qualify as civil aviation operation performed by aircraft under the scope of the EU regulation. Most of the current implementation rules would have to be adapted and or new ones adopted. For instance, in the domain of airworthiness operation, ATM, environment, aerodromes, personal license, etc. Since some of these operations will be unmanned synergy with the drones regulation, we also have to be further assessed. This roadmap summaries the finding of the task force and well as the reflection of the various services of the agency and present them in the format of the pre-impact assessment for delivery to the European Commission in order to support in the decision of the follow-up on this file. To build a national legal and regulatory framework allowing a suborbital flight in Italy, a three phases approach is environed. The phase 1 experimental flight, the phase 2 flights with participants on board, phase 3 routine transport. It should be mentioned that Italian Air Navigation Code does not provide any altitude limitation for air navigation or object defined as aircraft, nor include a definition of spacecraft as flying object different from aircraft. A formal legal approach to the future scenario of commercial spy transportation, in particular for suborbital vehicles, performing horizontal takeoff and landing, will be needed in the future, but the present content on the Air Navigation Code is not considered as a legal obstacle for the development of phase 1. It has the experimental suborbital activity of space planes. For this purpose, a life supported space plane could be considered an aircraft in according ICAO definition, any machine that can derive support in the atmosphere from the reaction of the air. In the framework of the current Italian National Aviation Regulation, experimental aircraft are not allowed to conduct commercial transportation operation. However, exemptions might be granted that are subject to the specific condition and limitation permitted occasional suborbital spaceplane flight experience for paying participant and cargo. The proposal of exemption and definition of a condition and limitation should be based on and should take into accounting the following consideration. Spaceplanes operation should not imply a risk to an involved person and properties higher than the one caused by current aviation traffic. Presently, spaceflight is an inherently high-risk activity where both technology and operational experience are under development. Each person directly involved in spaceplane operation on board, on the ground, and any customers and contract for cargo transportation should have been aware of such risk by the operator and should in the conclusion. All these uses and handled in the understand a written acknowledgement such as a risk should be signed for each operation. Informed consent does not absolve the operator from liability claims brought by involved parties, their family or legal representative, and in event of death, serious injury following a spaceplan accident or serious incident. Nor informed consent nor absolve the operator from adopting policy aiming constantly improving to the overall safety of the operation. Modern aeroplanes in commercial operation achieve a catastrophic failure rate better than 10 at 7 for flight. General aviation standards are better than 10 at 4 for a flight. A figure of 10 for flight should be established and an acceptable target for short-term space plan suborbital operation. All these uses are handled in the suborbital and access to space operation SASO regulation adopted by ENAC in 2023-1214. The SASO regulation contains the requirements as a vehicle system operator has to comply with in order to be authorized to conduct suborbital operation or operation for access to space. Allora, questo lo saltiamo. SASO, the ENAC regulation will have to be consolidated by national legislation, which will have to codify the aspect relating the operator's liability. In particular, will be explored the possibility to introduce a regime of cross-waiver of liability at the US regulation, and as well as the insurance profiles, identify a limit above which the launch status will guarantee compensation for any damage that may exceed this limit. The draft of space law based on the study carried out by the Fondazione Leonardo in collaboration with Bocconi and the La Sapienza University, is currently being discussed at the ministerial level. Ministry of Business and Made in Italy, this law will be able to identify the competence authority for regulation activity, for pure space activity, and for so-called space access activity. Through publication of the SASO regulation and the new edition 3 of the Coordinated Construction and Operation Regulation of Spaceport, this regulation along the lines of what already happens at an international level, and as example in the USA, the UK and Norway in particular, ENAC can strengthen its recognition candidate to be recognized also legislatively as a regulatory authority for spaceport and the suborbital flight, access to space and the return from orbit, also taking into consideration regulatory activity already done. I want to leave my legal issues for this problem. It is the problem that we have to affront for the next activity of study of this next panel. Thank you.
Thank you very much, Marco Di Giugno, for pointing to the legal problems of suborbital flight. I know, Marco and Sergio, that at the ILA committee on space law, you're discussing precisely this kind of issues, including the very well-known problem of defining the boundary between space and air, and so the application of space law and air law. And it was definitely interesting for our viewpoint, definitely, to hear the recent ENAC regulation concerning both the issue of vehicles but also spaceports. So this is definitely a topic in which Italy can offer a contribution for future regulations also in other countries. So thank you very much. And our last speaker is Simone Benvenuti, who is a professor of comparative public law at our department here at Roma Tre University. He has extensive experience and expertise in the field of constitutional law, particularly with a focus on Eastern European countries. And today, Simone is offering a presentation on fundamental rights in outer space. Simone, you have the floor.
Yes, thanks, Mirko. And well, first of all, thanks to Sirio for inviting me at this important event. Well, I have to say that as a comparative public or constitutional lawyer, as you were mentioning, I grappled with the need to set the perspective of my presentation. I always considered, obviously, space law strictly a domain of international law and international lawyers, or possibly more recently of private lawyers or comparative private lawyers when it comes, for instance, to exploitation of commercial opportunities such as space mining, telecommunications, or in the near future, space tourism or private commercial suborbital flights, more exactly. So I considered space law only indirectly and selectively touching upon the constitutional dimension. And I think in this respect, the statement in Article 2 of the Outer Space Treaty, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, made clear the non-state or non-constitutional nature, at least in a strict sense, of the principles of space law and issues related to space law. In addition to this, many scholars have pointed out that the fields of fundamental human rights and that of space law ran parallel for many decades. So they just had the humankind-oriented approach as the only common but indeed very broad denominator. And the reason for that lies in the fact that in the very beginnings of the space race, the development of the relevant technologies and the purposes of their potential applications, which were limited to warfare, as we know, and scientific discoveries at best, showed a limited direct link to ordinary human activities and to the lives of the people on Earth outside exceptional circumstances like war. Nonetheless, a link does exist. I mean, with the constitutional dimension, not just because the principles of non-appropriation and the principled exclusion of sovereign claims do not entail per se the lack of any state jurisdiction in outer space, and with all consequences deriving from this. Think about the possible establishment of future space colonies, but this link exists because there is a huge impact of space-related activities today, nowadays, on fundamental rights, either individual or collective. And some of them are also internationally protected human rights. So I think first, to understand how space-related activities and fundamental rights intertwine each other, and how such intertwinement has become so intense today, it is important to first put it in the historical context, basically. A historical context, as we know, as it has been mentioned, very different today from what used to be 20, 30, or 50 years ago. So what has changed? I'm saying nothing new in this regard. Changes happened at two levels. First, as to causes and purposes of the space race, technologies developed, potential applications developed with them. So while at its inception, as I was saying, space exploration entailed essentially military use or scientific exploration, there is now a variety of aims that can be achieved through space technologies. So we can easily understand that the multiplication of space-related activities having direct and concrete effects on individuals and groups of individuals living on Earth, enjoying fundamental rights in the respective jurisdictions or in international law, poses problems in terms of constitutional regulation and protection of those very same rights. Second point, it has been mentioned, actors changed. While space law exploration used to be just a matter of states and state superpowers, first of all, the landscape is today much more fragmented. Not only more states are involved in space exploration, including regional organizations and agencies themselves gathering number of states. As we know, private business entered the space race and is now, an important component in it. We know that NASA itself nowadays relies on commercial resupply services by private operators, and recently also offered flight opportunities for commercial providers to utilize the International Space Station as a destination for private astronaut missions. And this is obviously a strategy to drive down the transportation costs and enable, as NASA put it, a vibrant low Earth orbit economy. So these changes all raise problems in terms of both the risks posed by private business rationales able to hinder or stretch to their limits, traditional principles of space law, and the ways how to protect fundamental rights against new actors. On the top of this, we should also add that the legal dimension in 30, 40, and 50 years has been strongly affected by these multifarious changes. This has been very clearly described by prominent authors. Fourth phase of space law is now ongoing. The legal landscape is now much more fragmented, with the general treaties and the UN soft law being complemented by international organizations, special legal regimes, bilateral or multilateral agreements of a specialist nature, and national law as well, which has been actually sparked by the process of privatization of space activities, as it has been mentioned in this session. So in a word, the legal landscape in the field of space regulation, in the space of regulation, is much more fragmented than it was decades ago. So based on these contextual changes, today fundamental rights, or at least some of the fundamental rights affected, are hugely affected by space-related activities. And I think it's important here to stress that the impact is negative sometimes, but can be also positive. So the negative impact, I'm stressing this different because the negative impact is often underlined. And this is, for example, the case of the threats to privacy. This right is in principle affected in relation to remote sensing technologies. Think about, for instance, to the availability and easy accessibility, especially of the very high resolution data. Its use from Google Earth search engine to law enforcement agencies. Some companies already provide commercial satellite imagery with resolution allowing the identification of objects as small as 30 centimeters. And by the way, and this has also been mentioned, risks are further aggravated by technological developments in the field, for example, of artificial intelligence. So on this side, again, the challenges posed by these new technologies and space applications does not offer, I would say, an effective protection, for example, on the right to privacy. So possibilities for redress for individuals only lie in national legislation, which, besides possibly not being up to date with such developments, bears in any case a fundamental asymmetry, and I'm quoting here, between, on the one hand, cosmic generation and principled global availability of very high resolution data, and on the other hand, localized privacy concerns and national means of protecting them. Another important field where the negative impact of space activities on fundamental rights is apparent is the environment. Threats to the right to a clean, healthy, and sustainable environment and to intergenerational equity, if we are to accept this legal notion, notably come from the problem of space debris or space junk, but also light pollution deriving from satellites overcrowding and hindering even the freedom of astronomical research, for instance. So what is involved here is not just the space environment with more than 30,000 trackable debris, but also the Earth environment. It's just 2 years ago, the news reported the fall from the sky of an object in the fields of Australia, supposedly from a SpaceX aircraft. So even though no damage was reported, this case questions the effects of space activity. And it's important to stress that in the field of environment, concerns, as you know, were already felt decades ago. Article 9 of the Outer Space Treaty holds that state parties to the treaty shall pursue studies of outer space, including the moon and other celestial bodies, and conduct exploration of them so as to avoid their harmful contamination and also adverse changes in the environment on Earth resulting from the introduction of extraterrestrial matter, etc., etc. So as a consequence, as a consequence of the importance given to the environmental dimension, whereas space law national legislation has been adopted, either of a general or of a specialist nature, regulating specific areas of space law, environmental protection has been actually incorporated by some states, by some legal systems. This is the case, for instance, in Ukraine, licensing and supervision of space activities must take into consideration the protection of the population and the environment. In Kazakhstan, the National Space Agency is in charge of issuing licenses and ensures environmental protections. In the United Kingdom, whose Outer Space Act licensing condition address contamination of outer space or adverse changes in the environment of the Earth and public health. Austria, where conditions for authorization refer to, among else, the protection of the environment, Australia, and so on and so forth. And also protection of environment is an important concern reflected in the model law of the ILA Committee on Space Law. Other rights can be mentioned, obviously the right to safety, which is concerned more generally by a variety set of space-related activity, especially so in connection to militarization and weaponization. These are just examples, but I think definitely an effort is necessary to somehow map all the implications of space activity on individual and collective rights, and this is maybe a research endeavor per se. So if these are anyway the areas where a breach of fundamental rights by space activities is possible, we should not underestimate the positive or at least potentially positive impact of space-related activities on fundamental rights. As I was saying, this is a point I would like to stress. Remote sensing technologies and satellites, which is, by the way, nowadays quantitatively the most important part of space technology, can hugely empower citizens' rights. This is the case of the right to education in the era of distance learning, for instance, when it comes to making internet connection available in remote areas, an island, peak of a mountain, the right to information through satellite broadcasting, and in this regard, the UNESCO Declaration of Guiding Principle on the use of satellite broadcasting for the free flow of information, the spread of education, and greater cultural exchange states that satellite broadcasting, which is, by the way, defined as a means of disseminating knowledge and promoting better understanding among peoples, shall be apolitical and conducted with due regard for the rights of individual persons and non-governmental entities as recognized by states and international law, and that its objective for the free flow of information is to ensure the widest possible dissemination among the peoples of the world of news of all countries, developed and developing alike. It is possible to mention here also the huge impact for agricultural development and the right to food. Article 25 of the UN Declaration of Human Rights in space application can, and again I quote here, deliver important information on climate and weather conditions, enable communications and data exchange, assist in efficient use of seeds, fertilizer, plant protection products, and water, be used to help food distribution and supply. Similarly, there are implications for the right to safety in relation to the prevention or the ex-post management of natural disasters, and in this regard, the UN principles on remote sensing mention the purpose of improving natural resource management, land use, and the protection of the environment. Think also about technological applications in the field of energy and the geopolitics of energy, the next generation solar power, satellite, and terrestrial wireless charging technologies. If we look at legislation from the promotional side of fundamental rights by space activities, the South Korean example is interesting, not only because it is a country that made some efforts to produce a comprehensive legislation in the field, but because this legislation contains a clear reference to such, as I was saying, promotional dimension. The Korean Space Development Promotion Act not only aims to promote the peaceful use and scientific exploration of outer space to ensure national security, but also to further develop the national economy and to raise the national standard of living through the systematic promotion of space development and the effective use and management of space objects. So just to conclude, what we see is arise in the intertwinement between space law on one hand and fundamental rights, but I would say also the difficulty to tackle such relation because basically of normative voids, not full normative void, but normative voids, but also I would say the context. The current geopolitical fragmentation that does not help, so to speak. The relevance of space activities for fundamental rights and of fundamental rights for space law is in general not reflected in legal instruments, with a partial exception of the environmental dimension, while expanding national legislation appear in general underdeveloped in this regard, and in any case, not always in the best position to deal with the transborder nature of the effects of space activities. The principles set in what can be termed as the space constitution, starting from the 5 founding treaties, are highly commendable, but general for our purposes, and their interpretation not always clear in front of current developments of space opportunities. In any case, today's geopolitical fragmentation is not conducive to build upon their collaborative foundations. The decision of Russia that was announced to pull out of the International Space Station is one example, but at a broader level, also the Artemis Accords challenged the multilateral principles of prior space agreements, being mainly aimed at stimulating the economic opportunities offered by state exploration. So this approach, the approach of the Artemis Accords, can have also positive implication, like the furthering of the economic accessibility of space technologies by lowering of costs, and can be also explained by US national security concern, but certainly is not favorable to the development of a framework of international cooperation that only is able to ensure, I think, a more effective protection of fundamental rights. And as you know, after the signing of the Artemis Accords, Saudi Arabia withdrew from the Moon Agreement 1 year ago, which is maybe not so important from a practical point of view, but is telling of the difficulty in such landscape to frame a more detailed and effective space law framework favorable to fundamental rights. But in the end, I think this is what we should look for. Thank you.
Thank you, Simone, for emphasizing this complex relationship between outer space activities and fundamental rights, and to mention also some key legal questions, including that of jurisdiction, for example. And you also emphasized the problem, or let's say the relevance of the principle of the peaceful uses of the outer space. And of course, this has to do also with the topic of what is peaceful and the military uses of the space and the possible application then of international humanitarian law. But I'm sure that tomorrow, if I've correctly understood, we will have the chance to further discuss this topic. I see from the organization that actually our new panel will start at 12. There will be a short break, but Sirio, if okay. In any case, we have space for one or a couple of questions, so I open the floor for the discussion, and I see already there. Yes, please. I don't know if there is any microphone, or otherwise at home. Maybe the easiest way would be that you come here and you use this microphone. Thank you very much.
Good morning. I'm Giulia Rossanigo from Thales Alenia Space Italia. I would like to thank you all for this very interesting intervention. And well, space, we know it's, let me say, a huge field, let's say infinite. And so many actors and interests are involved. So actors from space agency, private companies of manufacturer, operators, defense, and interests are from commercial to science, observation, and so on and so on. So if I may raise a question that may sound provocative, of course, I'm not looking for an answer, but I'm really interested in point of view. How hard it is to imagine a space law that can really protect all these interests, and how hard it is to imagine a national law that, given all the principles and pillars we have been going through this morning, it's at the same time in line with all these principles, but in line with the need to preserve the competitiveness of national companies. Thank you.
Thank you very much. I collect one more question, if there is any. Okay, I think so. Yes, please, come.
I'm Alessia Massi from the Legal Department of Thales Alenia Space Italia. I have a question for the Professor Marchisio regarding the definition of the operator, because we understand that the liability in the space for is the principle is not to maintain the ownership of the space object, but to be considered the operator. Of course, we are not considering in our world the operator or the space object, but the manufacturer. But we have a time during in orbit after the launch until the final upset that we have the responsibility of the operation of the satellite. So we would like to be sure that during this period, we are not be considered an operator. Oh, yes.
Okay, thank you very much. So I give the floor, maybe we can start with you, Professor Marchisio.
Thank you, Alessia. I should say that the definition of operator, of course, is up to each national legislation. So we don't have in Italy a space law until now, but we have discussed the issue of the definition of operator during the process for the drafting of this law that Minister Urso is very much publicizing in many events. Operator, in my mind, it's or the applicability of law and scope of application of the law is a key notion in the sense that it concerns not certainly the manufacturers, not the owners, but the subject, the actors of private law and a contract of private law or non-governmental, as the treaty says, that manage space objects and manage space systems in outer space, in orbit. In orbit. I don't go to the parabolic non-orbital activities because they can be very high, very speedy, but non-orbital in any case. So for us, it is not a matter to delimit space law and outer space because we know when an activity is in space, is in orbit. I don't think that, but I understand at the same time the idea of having a unitary system for launch, non-orbital, orbital, etc. But I think that for the time being, there is no need to spend time on the issue of what is outer space, what is, because my mind is that the main point is to define the external limit of the airspace, not where outer space begins. And this is the real problem because we know that some states don't want to limit themselves. Now can be 80 kilometers, 100 kilometers, but in the future can be 200 kilometers. Why to limit ourselves now when we can arrive at 2000? So, but coming back to your question, this is an issue of independence and a private law operator that independently manage space systems. So for the time being in Italy, we build space systems, but we don't manage them. There are few operators in this sense and this is why we don't have until now the law, because there was no need. There was one political person telling me, why, Professor, you are spending so time in dealing with space law when it applies to 4 or 5 industries or companies in Italy. There is no need. There are more important problems. I said, well, but they can grow. They should grow in the future, no? And this is important. I don't think that you as a manufacturer will be involved as operators for, as I understood well, the part concerning the re-entry of the space object. Well, but if you manage activities in orbit, you are operators. So you fall within the definition of operator. It depends on what you do, how do you do this, etc. There is no many manufacturers could be also operators.
I think we can continue the discussion also after the next panel, since there is a little change in the program. But if some of the speakers want to add anything, otherwise, I think we can conclude this very first panel. Thank you very much to all the speakers for the very interesting presentations.
So good morning again. My name is Marco Ferrazzani from the European Space Agency, and I first have to thank University of Roma 3 and Sirio Zolea for having invited me to enjoy the day. It's always a pleasure to come back to Italy, being an Italian expatriate working in Europe, and see how much the European and Italian landscape is getting excited and developing many discussions about the laws applicable to outer space. And for me, just as a small word of introduction, having worked as a lawyer at ESA for many years, I always consider that space law is not just one set of law, it's the compound of all pieces of law, be they private or public, that apply to space activities. Knowing, and that's from the treaties, that space activities start on the ground and are used from the ground. So any kind of space activity for me is space law. Of course, laws applicable in outer space, but also applicable on the ground for preparing, executing, managing, and exploiting space opportunities. And this means a lot. Very good lining with the topic of this panel, public and private in space governance. As the previous speakers have indicated earlier in the opening address, space is becoming more rich, more interesting. Not only public, but many private interests and operators are operating on the ground and in space. And this is good news. I hear some worry that there could be a normative lack or vacuum, which I consider not really a problem by itself. It's more than obvious and normal that in the evolution of space activities, the norms and legislation written years ago become incomplete. I would not say obsolete, incomplete, because the new phenomena, new facts are arriving, new actors are arriving. And so it's obvious that legislation has to evolve and to complete progressively, to adapt and to be able to regulate what we have today and what we'll have tomorrow. As our Roman law teachers told us since university, fact come first and then the law comes. Ex facto auditor ius. So I'm not surprised that the laws applicable to technology like space have to evolve and adapt progressively. It is our collective wisdom to be able to be good, smart enough, and keep up to the pace and to the speed of evolution. Now, of course, the last 10 years see a lot of private interest in space. I would say it's today more interest than reality. but this expects and requires us, the legal operators, to be up to the expectation of reality. And so I'm very pleased to have this panel today with distinguished international speakers. I have to say that unfortunately one of the speakers, Anna Veneziano, is unable to be with us today, and we have the three other speakers present with us. I will introduce them one by one and give them the occasion. We have enough time between now and 1:30, and I'll try to draw some conclusions and of course allow for questions from the audience and online. And online we have our first speaker, Li Huyan from the China University of Political Science and Law. Professor Yan is a professor in international law school at the China University of Political Science and Law, and he has been extensively studying and researching first in international economic law, that's his background and interest, and being a member of the China Space Laws Institute and the Beijing International Law Association. He's also been involved for a long time in being also a visiting professor outside of China in many different occasions, and we have met him in international conferences. He's also been used in the Chinese National Space Program as a training legal professionals to train the Chinese astronauts and to explain to them what are the laws applicable to human missions in outer space and on the ground. Do we need that? In ESA, we do that with our European Astronaut Corps also, because not only astronauts are envoys of mankind, but they're also legal actors when they're in space. Their acts, deeds, and even intentions matter. And that's what we tell our astronauts, to make them aware what kind of experience they're going, what kind of human and, of course, legal experience they're producing. Professor Li Yuan is online. He's been author of many articles on international economic law and also a book introducing space law and international legal commentary. So I'll give the word to Professor Li Yuan, who will be speaking about the China national space law making, difficulties, and model choice. That's very interesting. Hello, Professor.
Hello. Can
Yes,
you hear me?
we hear you well and clear. The floor is yours.
Yeah, thank you so much. Can I share my PPT screen? Is it okay to share my PPT?
Yes.
Let me try to
Sorry, Professor.
Yeah.
You should be able to share your slides by yourself, but if you prefer me to do that for you, you can just ask me to do that and just say change slide and I'll do it. But you should be able to do it.
Yes. Please do it for me. Currently I think it's not that easy to find to share that. Yes, please share it for me. Yes. Thank you so much.
Please go ahead.
Okay, thank you. Thank you, Mr. Marco Ferrazzani, and it is my great pleasure to attend this conference online. Unfortunately, I cannot attend the meeting on spot because this is the new year of the Dragon Eve today. So as you know, this is the traditional family union time. So I here wish you all happy new lunar year of the dragon. And also thanks to Dr. Cyril Zoli and thanks to the Roma University for organizing this very important conference. So it's a special day and we are discussing the special topic. My topic is China national space law making, difficulties and the model choice, as Mr. Marco Ferrazzani mentioned. So next slide. Please, next slide. Yes. Today I'd like to discuss three issues. First is the national space law making status quo. And second is difficulties of national space law making. And third is the model choices of national space law making. Next. Next, please. Yes, go back to the first. National space legislation status quo. Here I'm going to discuss three topics. First is the hierarchy of law in China. Second is the development of space activity. And the third is something relating to the space activity, but that is the undevelopment of national space law. Next. So the hierarchy of law in China, we can go back to see the legislation law 2000. Even China, after 1949, China began to enact many laws, but the legislation law comes out very late. That is in 2000, which is the legislation customs or practices has been summarized. And this law was amended last year that, in the National Congress. And according to this law, in China, the law can be divided in this kind of a hierarchy. First, always on the top is the Constitution. The Constitution is made by the Congress, and that's only can be modified by the Congress. This is the first. Second is the national law. National law is also made by the Congress, and it's standing committee of National Congress. Because the Congress have about 3,000 representatives, so it's very difficult to have the Congress General Assembly always. So during the year, during the time when the Congress is closed, and it's the standing committee instead of the Congress to make the national law. Next level is the administrative regulation. As you all know that China is a unitary system, which means that the central government play a very important role in the national life, including law making area. So the central government can make the administrative regulation. It can also apply to all over China. It looks like the national law, but the level is lower than the national law. And under that level, that is the ministerial and the provincial level. There are many ministries in China. The ministries can also make so-called ministerial regulation. Each ministry have this kind of law-making power. And for the local government, for example, the local Congress and the local people's government, they can make local decrees and the local rules, which means that the rules made by the local Congress and local government, they can only apply in their jurisdiction, not all over China. But the ministerial regulations at the same level, ministerial regulations can apply all over China. So you can see this is a hierarchy. Constitution, national law, administrative regulation, and ministerial and the provincial level regulations or decrees. So this mainly the hierarchy. Next slide, please. And if we take into consideration of all these kind of hierarchies and go back to see the space law and the space activity, we will find something very interesting. First, the space activity developed very fast. But compared to the countries who are advanced in the space activity, China's space activity is not that advanced. For example, the first manned satellite in China was launched in outer space in 1970. That is 13 years late than the first satellite. Second is the first manned spacecraft in China launched in outer space is 2003. That is 42 years late than the first man-made spacecraft compared to Soviet Union, former Soviet Union. And the first national space law in China now? No. Currently, it's very clear that currently there's no national space law in China. So you can see, compared to the first 1958 national space law in the United States, you can see it's 66 years later than that, and we should add more years. So generally, currently China is very active in space activity, but compared to the development of the first development of the space activity, the national space law is very late. Next list, please. Then, as we mentioned, that is the end development of national space law. No national space law in the activity area, and no administrative regulations on space activity area. And currently, the rules applied in China directly relating to space activity is the ministerial regulations or orders, mainly in this level. And if we go back to see the hierarchies, we can see this is a very, very low level of the legislation. So constitution, national law, administrative regulation, all this is the first three, but this is ministerial regulations and orders. It's a very, very low level. Usually it's the lowest level of the legislation. And what happened? So you can see if it's the lowest level, then it's caused a lot of problem. That is, other regulations of the laws, if they're relating to space activity, not directly, but they are relating to the space activity. Then when there is a conflict between these regulations and the upper level regulations or the laws, then these regulations cannot apply first. It means that other laws and regulations can override the space activity area ministerial regulations. So you can see it may cause a lot of potential conflicts. So this is the end development of space national law. Next slide. Next slide, please. And currently there are two ministerial regulations relating to the space activity. The first is the measures of the administration of registration of objects launched into outer space. That is a registration regulation. This is promulgated in 2001, and the issue authority is the National Defense Commission of Science, Technology, Industrial, and also another ministry is the Ministry of Foreign Affairs. Two ministries are involved in these regulations, and this is the first for registration of all the space object launched into outer space. And secondly, the interim measures on the administration of permits for civil space launching project. That is, usually we call it as licensing for a launching project. And this is promulgated in 2002. And the issue authority is also the National Defense Commission of Science, Technology, and Industry. It has been dissolved and is reformed into a co-site. And you can see that these two regulations, ministerial regulations, are applied more than 20 years. And the second one is interim. It's interim for 20 years. You can see that these two regulations relating to space activity is needed to be replaced by upper level rules. For example, could be administrative regulation, or could be national law. But till now, there's no such kind of internal regulation and national law. Next slide, please. So this is the situations for space activity and the space law in China. And why there's no national space law for so many years? Because there are some difficulties. Actually, there are two main reasons. First is the lawmaking procedure is very complicated. You must pass all the procedures. Secondly, that space activity involve many governmental branch. It means that administering organs are so many. They need to be balanced. So next slide. First, we are discussing the law-making procedure. According to the legislation law or under the legislation practice, in China, when the Congress make a law, make a national law, then first the draft should be on the agenda, law-making agenda, which means that someone should make the proposal. Someone can be a delegation of a provincial unit, or should be more than 30 delegates of the National Congress. They can make a proposal. Actually, this is happened many times. They make a proposal, and then when it's passed the national people's discussing agenda, then it can be on the lawmaking agenda, and then for investigation, for discussion, for make the draft. And currently in China, the national space law is on the secondary agenda, which means that also under research and under investigation for the draft. So this is the first. You must have put it on the agenda. Secondly, that a lawmaking process that when you on the agenda from the secondary and then to the first, which means that it could be make as a law in 5 years. Each session of the Congress is 5 years, which means that on agenda, first agenda, then it could be made in next 5 years. But currently, it is still on the secondary agenda, which means that we don't know when we'll have the national space law. When it's in the first agenda, then you need to have a draft. After have the drafting version, then it could be deliberate by the delegates, and after that it's voting. So you can see you need to pass all these procedures, all these national space law making procedures is quite complicated. It's not that easy to make this space law on this area. So next slide, please. And second, as I mentioned, secondly, that the space activity area involve many different branches. For example, they involve in the Ministry of Industry and Information Technology, MIIT. And it also involves a very special administration, that is the National Space Administration. And also another organ, the Sustained State Administration of Science, Technology, and Industry for National Defense, and other organs. You can see so many organs are involved, which means that different organs have their own consideration on what is important, what should be involved in the national space law. So it makes the procedure become longer. So this is the second reason. Next slide, please. But because the space activity now is more and more important, and China, as you all know, that plays a very active role in the space activity area. And we can see that in the future, we should have a national space law. Actually, because the national space law is on the secondary agenda, then we need to consider what kind of model we should follow. Actually, there are 3 models for this year's discussion. The model A is we should have a code. Model B that we can have parallel laws in different fields relating to space activity. Model C is that we can have a basic law plus some regulations. The three models. All of the models have their advantages and disadvantages. So next slide. Next slide, please. For model A. Model A as the code. If we have a space law, space activity code, then the advantage is that all problems can be resolved in one code. You need no other regulations or decrees. Just have one comprehensive code cover all the problems, and all organs will follow it. Then all the organs, their power will be limited. It can be a very good balanced law. So of course, we think that the code is desirable, but the code is also have disadvantages because, as I mentioned, the lawmaking procedure is very complicated, and when you want to have a code, then it's time consuming for drafting, for past procedures, for coordinating all the organs. It's a long time consuming procedures. Then we'll never know when we'll have the code. So the code is desirable, but it looks good. It's too good to have it. So next slide, please. And then model B. Model B can be parallel law in different fields. This is also a quite good practice in China for making the national law. The advantage is that when you make the law, when in this area, if something is mature, which means that it can be made as law quickly, then this area we make law. And then other relating area, when it's mature, you can make another law. So you can have many parallel laws when the situation or the conditions is fit to the current development. So we have many successful experience on the lawmaking during the reform and society changing in lawmaking area. For example, now we have the civil law code. But actually, before we have the civil law code, we have the contract law, we have the family law, we have the general principles of the civil law, many different parallel things added together, then we have a code. So parallel law is easy to make to be made in different fields, but it's also have disadvantage. That is, when some area the law is mature, you can make the law. Means that the parallel things, they don't care each other because the mature relating to different situations, different conditions, then it may make more conflict in the future. So it's difficult for modification in the future. This is the disadvantage for the parallel law model. Next slide, please. The model C that we can have a basic law plus some regulations. In my opinion, I think this is a feasible way, and currently this is also something we are going to follow. The advantage is that is when you have a basic law, you need to only have the general framework. It's quite easy to agree on the general framework. And then you can have regulations when there's something need to be regulated. Then we can have administrative regulations or ministerial regulations or rules or orders or government decisions. So basic law is just a framework. You can add many things on that. It can resolve the potential conflict at the first hand. So this is the advantage for the model C, basic law plus regulations. And for this kind of model, usually we need taking considerations of some main parameters. the elements should be taken into consideration to make this law. First, of course, it's the international treaty. As we all know that there are 5 UN international treaties on space activity. Second, that we should take into considerations of relative national law. And then we need to take consideration of the current rules, including the rules I mentioned just now. And of course, when we have a framework, we need to take into consideration of the further future development in the space activity area, not only China's own concern, but also the international society concerns. So in my opinion, I think the Model C is the desirable and reasonable and feasible model to make the national space law. As we all know that, as I mentioned just now, we all know that because we need to put the law on the agenda for the legislation, so it's not easy to have it now. When the lawmaking agenda moved from a secondary to the first, it need take time. So currently, we are not the space law. Space national law is not on the first agenda. So it means that in next 5 years, we will not have that law. We should probably wait for more than 5 or 10 years in the future. And as you may also note that when China makes the law, usually the draft of the law will be announced on the internet to collect opinions. So I think that in the future, when this draft is promulgated is announced on the internet, all the experts, including in this conference, you can make your opinion on your comments on this draft. Yeah, this is my report on this topic, the current status quo and the model choice. And hopefully all of the experts in this conference can take part in this process. Thank you so much.
Thank you very much, Professor Lee. Your intervention allow us to have a clear systematic way of looking at national legislation, space law. Very interesting about the different models and the comments you made. And I'm sure many national legislators went through that reasoning already, as many are doing now. Of course, it shows that law is a lively process, and law lives through times with our society, and there are different solutions and different effectiveness of the law when we apply it. So thank you so much. And yes, we will move on, and we will reserve questions at the end of the various speakers. Unfortunately, as I said, Anna Veneziano could not attend today, so I can move now to Antonia Eliasson, who is now an associate professor of international law at the University of Mississippi. She received a law degree from the University of Michigan, and most recently the master's degree in aerospace law at the University of Mississippi. Her research focused on international trade and investment law, particularly looking at the issues relating on climate change and sustainable development, which are topics, of course, more important for our space activity, and the idea of corporations in international law. And that's the topic today. She's introducing to us corporations and outer space. The floor is yours, please.
Thank you. And thank you so much for having me here at Roma 3. Thank you, Sirio, for organizing this. So I'm going to go on a little bit of a different approach than we've been seeing today. And I'm going to take a little bit more of a theoretical framework to talk about corporations and space law, and kind of talk and maybe push back against some of the rhetoric of the exceptionalism of space law that you hear a lot about, especially as space law gets more popular and as people are talking about this from without the profession as well as within it. So when we talk about corporations, of course, they are at the heart of most of these debates that we're having about the development and the governance of modern space law. But in that respect, space law is really not that different from any other aspect of international law today, right? International investment law deals with issues of foreign investment in many sectors, including, of course, space. Trade law overlaps with space technology. And in both of these areas, corporations have long played a significant role, right? You have in investor-state dispute settlement in investment law, the active dispute settlement participants being corporations and shaping the way that the rules of these bilateral investment treaties are understood. And in the context of trade law, we see this also in terms of shaping the issues brought to the attention of national trade authorities. So in this talk, I lay out first a kind of theoretical framework to think about the increased role of corporations in international lawmaking. And then I turn to talk about how space law fits within that framework. And then I talk a little bit about environmental engineering as an area where we actually do need some regulatory reform. So in a forthcoming article, I have a paper coming out about the role that corporations play in international lawmaking broadly. And I make 3 claims for why this is happening. So why are corporations becoming more active? So first of all, law, as we all know, is reactive. It's not proactive. As you said, it is about the facts first, the law afterwards, right? So we are always talking about law responding rather than creating, particularly in areas of cutting edge technological developments. You get corporations in the position of lawmakers, artificial intelligence, cybersecurity, all of these types of areas. The second reason is that international law is becoming increasingly contractualized. We've already heard discussion today about kind of the death of multilateralism and this turn towards bilateral, regional, more contractual type agreements, like the Artemis Accords. And then third, the financialization of corporations is also playing an impact. And so this prioritization of shareholders over the laborers, over the customers, over the actual product incentivizes corporations to shape the law in their favor so as to maximize their profit. So building from this theoretical framework, I want to talk now about space law particularly, because as I mentioned at the beginning, space law is a field where we're getting a lot of discussion about the ways in which corporations are influencing the interpretation of the Outer Space Treaty, the interpretation of existing legal instruments, and that are pushing, arguably, for legal and regulatory environments that are more favorable to corporate interests. I mean, the Artemis Accords, again, is such an example of this that feeds this perspective. We're moving from multilateral treaties to soft law accords. And depending on who you ask about this, this is either viewed as an important step and necessary for the commercialization of outer space, or something that is novel and frightening, an example of dangerous corporate intervention in international lawmaking. But my argument is that space law is in fact one of the most traditional legal disciplines, insofar as we have an existing treaty regime that is central to much of the discussion of how private entities operate in space. The nature of spaceflight today still necessitates government intervention and involvement. So we have a space in which core legal texts that have existed for decades are being interpreted by both states and non-state actors, which itself highlights the centrality of these legal treaty documents to the legal regime of outer space. Yes, corporations are involved in negotiation and lobbying, but that's not unique to space law. It's not even unique to international lawmaking in the 21st century. I mean, this is international lawmaking as long as international lawmaking has existed. You can go back to the East India Corporation, to the Hanseatic League. You can go back as far as we understand concepts of international law. And merchants, Lex Mercatoria, you think about this, have always played a role in lawmaking. So I think that's important to think about, that we are actually seeing in space law arguably more conventional development than we are seeing in other rapidly developing areas of law like artificial intelligence or cybersecurity. So in that sense, the commercialization of outer space seems to be a more traditional example of the intermingling of corporate and state interests. So even if we look at the negotiating history of the Outer Space Treaty, the United States contemplated private space exploration from the very negotiation of the treaty. I mean, we contemplated commercial satellites from the very beginning of any kind of interventions in space. And so if we view the current occurrence and involvement of corporate interests as a vanguard of a new and troubling trend, it diminishes the role that, maybe if you want to phrase it this way, capitalist values played from the very beginning in dictating how the United States shaped and viewed outer space. We have always, in the American sphere, viewed it as a place of potential commercialization. And so I think that's an important thing to bear in mind that often gets lost when people speak about the interpretation of the Outer Space Treaty articles, and definitely from certain sectors in academia particularly, that view this as something new and something unexpected. A lot of the disagreements over whether the legal regime has any merit often involve bringing up the Moon Agreement, which we all know is, nobody's arguing that the Moon Agreement's a particularly effective international treaty. Even 20 years ago, it wasn't an example of a successful international treaty. And then the other argument is those core provisions of the Outer Space Treaty that contain within them ambiguity. But what, if not a traditional exercise of public international law, is the interpretation of treaty ambiguities as you find in the Outer Space Treaty? That's what international law is, right? That's what the Vienna Convention on the Law of Treaties is all about. That's what we do. So this is not, what's happening is not an effort to bypass the treaty. It's an effort to work within the treaty and to find interpretive angles, which is what we all train as lawyers to do, on interpreting it in a way that makes sense. So this is such that I would argue this is not new in the space sector. As I suggested, it dates back to these earliest efforts to launch commercial satellites. This tension has always existed in the space framework. So going back to my initial theoretical framework, how does this fit with respect to the space sector? So as I initially said, one of the reasons for the increased role of corporations in international lawmaking broadly is the reactive nature of most laws, ex post rather than ex ante. And so the consequent lack of regulation that gives corporations a chance to shape the formation of new laws. But here, maybe space law is the exception that proves the rule. It's an outlier, because this is one of the very rare examples of ex ante lawmaking. Right? This is an example where the laws are not struggling to catch up with the development in space exploration and exploitation, at least in the treaty framework, but rather space exploration / exploitation, depending on how you view it, is developing within the framework of a pre-existing legal regime. And I think that's why we see so much discussion about the role of corporations in space exploration, because if we think about other areas that are often used as synonyms, artificial intelligence, cryptocurrency, cybersecurity, there the law comes late to the game. The law responds to technological developments. So here, international lawmaking with cryptocurrency, with AI, with all of that is very much ex ante, or ex post rather. With space law, it's ex ante. I mean, the Outer Space Treaty was created decades before commercial space exploration was viable, and now corporations are running up against interpretive questions in these decades-old treaties. And so maybe you can analogize this with a telecommunications company that has some new technological developments and runs into regulations that were designed for older technological milieu. So the second point that it is increasingly significant private entities because of the demultilateralization of international law. I mean, perhaps we can see that the multilateral age of treaty making was the exception in the history of international law, right? It lasted for barely more than 4 decades after the end of World War II, and we can see that as the anomaly. And we're going back to more traditional ways of lawmaking based on governance, on regional alliances, on bilateral agreements. And with space law, we see this, right? The space governance questions that I know we'll have some papers that discuss the space security aspects go very much back to a pre-multilateral system. And as for the financialization of the economy, I mean, that's as true for space law as for anything else. Profit is what drives corporations. No corporation is in it for benevolence. They're in it for the money. I briefly want to mention that while space law generally is not an anomalous outlier private sector activity, there is one area that I think is, and that is environmental engineering. This poses particular questions. And so geoengineering, environmental engineering, whatever you call it, it is, and particularly for my purposes, solar radiation management, which is what implicates space the most. That's where you are trying to either increase surface or cloud albedo, stratospheric aerosols may be injected into space reflectors may be deployed, all designed to combat climate change and to reduce basically the sun's effect on Earth. And it may seem far-fetched, it may seem out of immediate reach, but at least the aerosolization is not. And just the other day, like 2 or 3 days ago, the New York Times ran an article about a giant solar parasol that some scientists have suggested. So the solar parasol is so huge and costly that even with financial investment from countries, it's far-fetched, perhaps because it would cost trillions of dollars. I guess only far-fetched insofar as it's far-fetched how much money we spend on the defense sector. But when we talk about the aerosolization of outer space or near space, and again, that's where the Kármán line comes in, and there's debates over where space and where airspace comes in. But it is relatively easy to take action to try to do geoengineering or environmental engineering that has potentially irreversible effects for the planet. And it's relatively cheap and easy enough that corporations or even a wealthy individual who maybe can remain unnamed could take unilateral action wanting to save the world and go and do something that is ultimately irreversible. We don't have any regulation of this. There's nothing specific to geoengineering or environmental engineering. It's kind of piecemeal the way it would apply. But as the climate crisis worsens, this is an area where there's more and more serious interest being given. And we have an area of the law that, like with artificial intelligence or other cutting edge technologies, we just haven't conceptualized of it in the legal arena, and the Outer Space Treaty and similar rules just don't really apply to it. So with that, we have to think about ways to address that. Soft law has played a very important role in the development of space law. That could be a possible solution, but soft law is only as useful as the willingness of parties to actually adhere to it. And as we've seen with corporate adherence to corporate social responsibility standards, for instance, they're not the best, right? So leaving it up to corporations to self-regulate doesn't seem like a great idea. Recent ESG laws in Europe offer binding mechanisms to hold corporations responsible, but always the issue is you're holding them responsible after they act, right? Like it's punitive once you've done something. And if you do something that's irreversible, this is a problem. So I sort of leave this open-ended. This is an area that I think demands much more concern and much more look at. And I think it's been sort of understudied and not taken seriously enough, and environmental engineering is an area that the adequacy of the legal norms that exist is far from being adequate. So I will end here. Thank you very much.
Thank you very much, Professor Eliasson. I personally enjoyed your way of introducing and addressing the point, and to demonstrate to all of us that introducing business and profit in space activity has always been on the agenda. Actually, it's even reflected in the treaties already. We don't need to call it commercial today because it's always been there. And just one point, we've always done it since 50 years. Outer space has been used for telecommunication services, which is a very much commercial service, well recognized and regulated and working well. So we're not discovering commercial space today. We're just doing more, and we would like to do more. And corporation obviously want to do more. That's time. And also, it is refreshing from a U.S. Legal speaker to hear that the Outer Space Treaty is not obsolete. It just needs to be interpreted and addressed well, not to be bypassed, but to be interpreted and applied properly. Because, as you know, there's been a trend in the last years to try to make the Outer Space Treaty or space law in general less relevant in front of national laws. As to the rest, of course, there are many points in which we will agree in terms of fragmentation, and I personally like the reference to the Hanseatic League as an example of multilateral business cooperation. So thank you for that. It enlarges the view in our panel today. And now I have the pleasure to move to Maria Lucas Rimbassen, whom I know for some time, who's a researcher at Toulouse University in France today. She has a background of academic degrees, both in Montreal, HEC, and McGill. And I know she's working hard on space law and business. But today, she's bringing back to space law in Canada, to the pioneer lost in the polar night. So please, Maria, take us to the polar night. We are with you. Thank you.
Switch, yeah. Yeah, and I'm waiting for the control. Yes, thank you so much. Actually, molto grazie, Sirio, and all of the team for inviting me. It's great to be in Rome. Hello, everyone. Bonjour, bon matin, ciao tutti, salve tutti. Yes, I'm learning. So my challenge today is to bring you to the context of Canadian space law. Yes. Please, thank you so much. Yes. So my challenge is to present to you the context of space law in Canada. As you probably know, Canada used to be has a very innovative identity in the space sector back in the 60s with launching, it's the third country to go to space. So with satellites, science, exploration, we have this identity of innovators, of pioneers, so in the space sector, we're very strong. How about space law? Nowadays, the legal community would have the impression that space law in Canada is lagging behind all this scientific and robotic innovation and entrepreneurial initiative, the spirit behind the Canadian identity in space. So this would be a first impression to say that Canada is actually lacking in space law innovation, as we lack a comprehensive national space legislation like you have now in France, or our neighbor in the United States. They're so massively innovating in terms of space law. So is it the same in Canada? You'd say that, and that's the title, are the pioneers lost in the polar night, like nothing is really happening? What's going on? So that would be the first impression, and I wrote a chapter in there's a big book on commercial space legislation in Routledge. So I present the idea that even the legal sector in Canada were like, okay, nothing is really going on in terms of space law, or we are a bit ashamed of this like status quo. It's not really us who innovate all the time. And actually, that would be the first impression. But behind it, we have a strategy. And the next slide, our strategy, it's just smile and wave, boys, because you'll wait and see. this is all the space law policy reports, everything that we have, and I'll explain all this image a bit later. But the main strategy is let the others innovate, do their space laws, talk about new space, etc., etc. We will wait and see until the dust settles, until the blizzard, the whiteout gets done, and then we have the clear weather and we can see clearly, and then we will act, but fast. And how? We will not have this top-down approach. Okay, this is our national space legislation. Clé en main, like a toolkit. Here's the 1, 2, 3, and then you have your space company, etc. No, it's more bottom-up. Go big or go home. If you're a small startup and you want to make your business and then you complain that, oh, in Canada, we don't have a comprehensive legislation, it's very tough. Well, Canadians say, well, just go to Silicon Valley and then do your space there, or go to Luxembourg or whatever. If you want to stay in Canada, we have the toolkit, but it's very hard to, get through. But do your homework and then you'll go big or go home. And that's why we have, when our Canadian space companies, they get mature, they actually, have a big part in the market worldwide, like GHGSat, North Star, MDA before that. So that's the approach. You go big or you go home. So you have to do your homework before. So then do your homework. So that's the approach. It's more bottom up. And when I'm mentioning bottom up, what's happening actually is slowly, Canada is not implementing, this is the comprehensive national space legislation, very top down, no, but bottoms up in terms of will spatialize Canadian law, spatialize Canadian society from the ground, will tweak here and there throughout all the legislations. For example, what we do, Canadians, what do you know Canada for? Canadian Space Arm, Canadian astronauts who go there and play their guitar. So we're good at astronauts, okay? What do? We innovate the criminal code in terms of, like, if you commit a crime in Canada and then you go somewhere in space, and I have the excerpt of the criminal code. If you commit a crime in space flight or on a spacecraft, and in Canada, that would be considered a crime. Well, according to the criminal code, it's a crime in space and you're liable. So we modify the criminal code. What's next then? AI. So within our working documents, we have not laws, but reports, policies, strategies that, yes, we will do the same in terms of AI, cyber, private, IP, insurance, all of those. So it's organically, all these initiatives, they're growing, they're talking. There's panels, there's workshops, that all these people, they talk and they say, when the time comes, we'll be there and we'll make the modification to make liable Canadians in space. But for now, is it the time? Is it the time to act now? And then we'll be like, and she's like, now I live and teach in France. France has this, very comprehensive national space legislation on insurance, authorization, etc., etc. But will it crystallize, and then later on it will be hard to innovate once the new space sector and the activism will really, catch on? So is it really useful to legislate now, or should we wait a bit later, and then when it happens, then we'll act? So this is the situation today. You may think that if you enter, if you attend events and there's Canadian representatives, most of them will say, oh yeah, in terms of legal innovation, we don't do that much. There's talk that we'll have a national space legislation, we will do something, etc., but we don't as of now. So yeah, but it will in time. And it's a challenge because in Canada, all the challenges are considered opportunities. So the challenge is, now you could think that there's a status quo, that we're stuck, but actually it's, if you look at the other side, it's an opportunity to grow and incorporate the changes slowly when the time comes. So as I said, I'm just talking, give you some key points that when you walk out of here, you'll know you have some key takeaways. So The strategy is smile and wave. Until then, we do a lot of policies, reports, we talk nice, but a change is coming. Then go big or go home, because we have to do our preparations before we enter the new space sector. It's all a question of timing, not to legislate before the right time comes. And then, as I mentioned, we have human space activities. So in terms of human, we innovated in the criminal code. What's next? AI, things to look on, IP. And especially Canada will start really moving when the business case will be there. Because as of now, yes, new space, there's lots of momentum, etc. But once all the dust settles, what remains? And then that's where usually Canada, for example, mining. Is there really mining in space now? When it will happen, Canada will show up with some new legislation for sure, because now on the radar, you have the Ministry of Natural Resources, and they're already in their policy. They start mentioning space mining, but there's no law yet. There's nothing much, but now that they're looking at that. And when it will become concrete, Canada will act. So smile and wave, and then when it's time to act, they will have something on the radar. So next slide. Okay, so just to summarize, I can't really get up because then I'll lose my voice. But on Canada, in terms of policy and regulation, on top you have launching. Yeah, the Department of Transportation regulates the launching, but we don't have any space launching. There's not even a spaceport, actually. Now there's one being built with Ukrainian investment in Nova Scotia, commercial spaceport, very small. And it was very controversial because is there a business for that? Yes, no. Well, it's up to debate. But since there's no regulation on space launching in Canada, what regulated that spaceport? It's actually provincial level environmental law, not even federal. And the Department of Transportation, it's federal. Everything that it's space in Canada, it's federal. There was nothing really for space except balloons, like stratospheric balloons launching in Ontario and Timmins Base, or small rockets like fireworks, basically. And so for rockets, nothing. The only thing they could find was a provincial level environmental law, which said that, okay, you can build it if you comply with some environmental regulations. So it's being built in Nova Scotia. Now, with all the snowstorms, almost all the year, will that function, etc. And then in terms of exploration, operations in space and human travel, it's the federal level, Ministry of Science, Innovation, Economic Development, ISED. And ISED also has the responsibility of the Canadian Space Agency. And the Canadian Space Agency doesn't do regulation on its own. It's mostly, the implementation and conducting missions. And ISED always writes reports. Most of the policies are from ISED, the Innovation Canada. And then everything that's related to satellites as well, down, we have the ISED and also Global Affairs Canada, who's responsible for trade and complying with export and all of those. And then robotics is mostly, the defense sector. I'll mention that in the very end, because we talk about new space, but what about defense? It's mostly the bases, and Canada is actually acting a lot in terms of defense. And so I was mentioning, we don't, in Canada, we don't really regulate just for the sake of regulation. We act, there's like, we act when it's the right time and very efficiently. So that's why we don't have many space legislations as of now, but we have everything that, with regards to satellites, we have the Remote Sensing Act by the ISED, and then telecommunications. Because in Canada, what we do know, in terms of like remote sensing and telecommunications, and many of the space companies in Canada, they're doing that. So we have everything in those laws with clearer instructions, and they developed tools on the federal website. You go there and then you know the steps and the instructions on how to comply with the spectrum and everything. So those are mostly the main two laws that are very useful for now, because when the right time comes, there's the legislation there. But if you're a space lawyer starting now in Canada, you'll be like this guy, like, there's so many instruments out there and tools and policies. Where do we start? How do I manage a space company if I start now? Well, it's not very difficult. There's only like two main laws now that for remote sensing and for telecommunications. And then for launching, there's nothing really for now, but is there any launching in Canada? Is there a need? Are we going to launch anything? So in the end, it's not very complicated, and you get help from, if you want to start a space company, you get help. It's there. So in terms of regulation, you can start by reading the policies and sensing the identity of the Canadian spirit in space, entrepreneurial initiatives, and in terms of law, it's a bit more conservative approach. Wait and see, because I'm asking you, and probably I'll leave some time for discussion too, because I would like to have your input. What's going on for real in new space? And so that's basically what I just said. In terms of launching, there's only the provincial aspect in terms of environmental law. And then many policies. And if there's acts or regulations, they're at the small level. It's mostly for implementation. And that for satellite. And you see there's more and more reports on AI, on privacy, on other issues that are more interconnected between the society on Earth and space. So really what will happen in Canada is more spatializing legislation, like everyday legislation. We talk a lot about telemedicine because all the people in northern Canada don't have access to the health sector. So therefore, we'll have a lot of services by satellite. So then we have 5G in around the Arctic, and Telesat Canada is working hard on it. So it's very answering to real daily needs, very on a practical level. So that's why you'll probably see space clauses in whatever legislation pertaining to medicine, to healthcare. So who would think to that? It would not be very intuitive, but that's what will happen, spatializing the society. And then to end on a little bit of comparison between Canada and the difference with the US, we're watching, but we're doing a lot of competitive intelligence. We analyze and see what's going on, and then we will act when the right time comes, as opposed to like in France, for instance, it's a very top-down approach, and will insurance, if that would be addressed, do we need to provide Canadian space actors with further insurance instructions, or can it be limited to the contractual level or private law? So it will be studied and taken examples of what's going on in France. Also, what we actually do closely is see what's happening in the UK, because previously, back in the day, Canada used to give a lot of feedback to the UK, because Canada used to have like a lot more going on as opposed to the UK. Now it's the reverse. In the UK, you have the spaceports, you have the satellite catapult, and we're watching that and seeing what are the pros and cons. And also the space legislations in the UK are, it looks very nice on paper, and then in Canada they're actually analyzing the real pros and cons, because what's the business case behind and the return on investment. And then finally, militarization of space. Actually, we talk a lot in Canada. Are we doing enough in terms of new space? Yes, no. The small startups, they're all going to the Silicon Valley. Nothing stays in here. And during this time, actually, Canada does a lot in terms of defense. And you know, you have the Commandement de l'Espace in France, Space Force in the United States, and the third Space Division in Canada, who's actually one of the most steady growing sector. It's silent. It doesn't talk a lot. It doesn't make too much noise, but it's actually steadily growing. I'm actually going to wrap up, leave some time for comments. Thank you so much for listening. Grazie.
Grazie, Maria. Thank you very much for your insight. And I'm particularly happy to try to summarize the session and open for questions. We had very good introduction by Professor Lee about the different kind of models that exist already in space lawmaking, and the view from a US law professors speaking about interpretation and also the logical fragmentation that we have in the international lawmaking. And the example of a Canadian based experienced lawyer, whom I have to note, Maria, that your point about looking at a space company, a new space company, telling them to read first national space policy, and of course, read the national space law. And this gives an idea. In reality, there are many new entrants in space, new space startups, big manufacturer operators, and they tend to do that. They first read the national space policy, what is the government doing, what a national space agency is addressing in terms of programs, and then read if there is a national space law, or take a model as you did. Take the model of the French law, which is quite complete, comprehensive, and read that and relate, and then from there understand and get to the international space law treaties. So to complete the picture, I really recommend all of us, all of you space operators, to have that method. Look at all the components that give a complete picture. And the picture in reality is not complete, it's often incomplete. It is not obsolete, it's incomplete, because that's what it is in new technology, is bound to be incomplete. And by the way, for me, it's good news. It means we're moving a lot. Somebody used to say, realize if you're not doing all the things you expect, it means you're not moving fast enough. In space, we are moving, and we're moving fast. And this means the legislation lags behind sometimes. I take it as good news. At the same time, stimulus for legislators to prepare and work as the Italians are doing, and it's very good work. So I open now the floor to questions, both online and in the room. I see already some, and please you tell me if there are some questions from online. Please, from behind, please introduce yourself. No, because there are people online who will not hear you. Can you please come here? Come here and use the microphone so that the audience online can hear your name and the question. Put on the microphone, yes.
Hi, so I'm Riccardo, I'm a postdoc at the University of Groningen, and I'm also part of several standardization committees in IEEE and stuff, so on space law. So my question for all of you first, and then one specifically for the Chinese professor. So the general one is whether you are aware of specific standardization efforts beyond, let's say, the US dominated ones, because I guess most of what's going really on practically for companies and many actors, also, you know, hybrid actors, because NASA is mostly collaborating, for example, with a lot of space companies, SpaceX, etc. So it's really going on in the standardization field, not really in space law. Space law is really, really obsolete and taken not even really that much seriously, unfortunately, you know, by many actors. So Is Canada, for example, trying to invest in these standardization efforts? Because as far as my experience tells, most of the engineers, computer scientists, and people in these engineering committees are Americans. A few of them start trying to come from, very wealthy Arabian states and this kind of new power, space powers, but very few, from Canada or etc. This was the general question. One for the Chinese, I've actually studied quite part of my PhD at CUPL, but also Tsinghua, so I've really an interest in Chinese law. One of the main areas of interest for space law, I think, is really when it comes to the interfaces with cybersecurity, so communications, satellite. And I was wondering, because in China, most of space law, as I don't know if he's still connected, so I hope so. Anyway, I will talk as if he's still connected. Most of is all right, great. So as we have seen in space law, there is a lot of work still to be done. But in cybersecurity instead, China is an extremely, I don't know if to say innovative, but extremely strict, at least, jurisdiction where a lot of laws have been passed in the last 5 years. Data protection, trade secrets, cybersecurity, really, really, really strong. So I was wondering, are these interfaces being discussed for space law as well? How to apply the current cybersecurity regime in China to space operations, especially communication with satellites and these kind of things? Or it's still kind of in the background or not really discussed? Thanks.
Thank you, Riccardo. I will ask first to Professor Lee to answer specifically the question on China, and then we'll address standardization. Can you please intervene? Yes, please.
Yeah. Yes. Thank you so much. Thank you for the question. It's really interesting that, of course, the cyber security issue is very important in this year. So a lot of regulations related to that. But in my opinion, that it's connected to the space security. It's not a direct space security issue. So in the space law area, it's go back to the legislation. It's not easy to have space law further. But in the future, if there's a space law promulgated, then I think the cybersecurity issues will be covered in the space law. But it could not be many provisions relating to that. I think they could be mentioned, but it's not many provisions. So so this is my answer. I'm not quite sure if I answer your question or not. If and for the general question, my opinion that for the space is for all mankind. So some countries are advanced, some countries are lagged behind, but gradually, I think all the countries can be developed in this area. And of course, even if one country are not that advanced in the space area, it can be benefit from other countries' technologies for internal cooperation. So internal cooperation is very important for space activity. Yeah, thank you.
Thank you, Professor Lee. Now moving to standardization, and we do a significant work of that in Europe. I invite you to look at European space standardization. It exists in Europe. There's a whole system made up by ESA and National Space Agency, ASI, CNES, DLR, together. We have a European standardization system, which is published and used by all European space industry. But of course, you say it is dominated by US specialists. Yes, of course, it's an economic fact. If most of the launcher manufacturing used in the world, more than 100 is one company in the US, most of satellites sold to defense department are made in the US, of course, most of what you find in space is based on US standards because that's the largest market, 20 times larger than the European manufacturer can do. So as a result, most of the standards you find in space are US based, because these are the government contracts of defense or launchers. And the European standards exist, but the European market of national programs, ESA program, EU program, is 20 times smaller. So, but your question was about where are standards? So I'm going to ask to the US and Canadian colleague, how about your view on US on space standards?
I mean, as you noted, the Americans sort of dominate the standardization sphere. But when we think of it in sort of a broader global administrative law context, right? Like there are competing standardizations or complementing standardization efforts. But I pass it to my Canadian colleague.
Of course, and then if you take like the future of on-orbit servicing, I mean, they'll have to be the same standards. If not, you'll just have like crashing satellites. So, of course, there's standardization, and it's already going on. ISOs and all of these. So and then you mentioned the foreign students. They come, they implement, and then they just go back to the states, for instance. But absolutely.
And just a word of hope, we have now an intention of the European Commission to issue draft legislation also based on space standards. Whether they take ECSS or a modified version of that, we will see when the draft law comes out in a few weeks. But the idea is to do economic legislation in Europe so that European companies or whoever non-European does business in Europe will have to adapt to European space standards. That's the news, that's the regulatory news that we in Europe did not have before, because neither ESA has regulatory powers, of course not, no member states have ever agreed to have a common regulation on space standards. And that would be a changing factor, the new thing. And then we can discuss about the standards, whether the same as the US, Canadian, or Chinese, possibly in the future.
Yeah, and that's it's the main spirit behind interoperability, and that STM, space traffic management and interoperability, it's one key element.
Okay, we have another question here, please, Professor van der Dung.
Thank you. My question goes to Professor Eliasson. Correct me if I'm wrong, but I heard something of a contradiction in one element of what you said. On the one hand, you said that the Outer Space Treaty was concluded ages before there was any commercial interest in outer space. And on the other hand, you said that the US was from the get-go interested in the commercial opportunities of outer space. How do you square those two? And how do you square that with the fact that even in the champion of private enterprise, which was the United States in 1962, satellite communications was regulated by a federal statute creating a monopoly for a statutorily created company called ComSat, which was only changed back to a true commercial environment in the year 2000 by the Orbit Act.
So yes, I mean, I think you had a vision of, particularly with satellites, commercialization, but the broad scope of the outer space treaty and its applicability to things that we're seeing today, discussions of space mining, right? In the 1960s, they were so far from, even science fiction was just imagining it, right? Like it was not something that was at all viable or real, versus commercial satellites, which from the get-go, we were like, all right, we got to find a way to monetize this to some extent. But the way that outer space exploration / exploitation has caught up to the Outer Space Treaty is sort of what we're seeing, a rare example of ex-ante regulatory creations that had to effectively imagine, almost science fiction like, a future that did not yet exist with technologies that were so far afield. And I think a lot of the discussions today, right, are still looking forward to things that we're still some decades away, right? Like space mining, viable space mining is not about to happen tomorrow. I mean, we're closer, but
people disagree on that.
Yeah.
I think there are people who say it's going to happen within the next 5 years.
Yeah. But commercially viable, who knows, maybe a little further out. But at least in 1967, when the Outer Space Treaty was concluded, it was not a reality.
Okay, thank you. Any more? Do we have questions online? Even on the chat? No questions online. I see no other question on the room. I'm really pleased to have managed this panel, and I've enjoyed personally. And I can close it now. I invite you for lunch over here, and we'll meet back at 3 o'clock. Thank you.
Professor Zolea is sort of interrupting the conference. He has organized and is. Yeah, he can. Okay. Welcome back to the conference. I'm Vincenzo Zeno-Zenkovic. I'm professor of comparative law in this faculty. I wish to congratulate Sirio Zolea for having organized this conference. It's, as one says, you know, in disclaimers you put in at the beginning of a book. I mean, it's all his idea. So everything, if you have criticisms, you must put them to him and not to me. I'm supposed to be his mentor, but I didn't put anything in this conference. But having said that, my only title to be here is that as I've been teaching for many years, European Union transport law and devoted quite a lot to civil aviation. So we have seen this morning that there are some similarities, some issues that can be somehow picked up from the long history, the over 1 century old. I mean, sorry, can I 1929, 2029 is 1 century from the Warsaw Convention. And so if we look at, if we look at space law in this perspective, in sort of a longue durée, as the French would say, I think we can see the evolution of a very important area of the law, which is growing importance. Century ago, few people would have put a bet on civil aviation, and instead we've seen how much it has developed. And so I think it is very important that we as university, we look at the future and we look at also space law. Having said this, it is my pleasure to give the floor to Professor Franz von Dank, who teaches space law at the University of Nebraska and who's a renowned expert in this area, and the floor is yours.
Thank you very much. First, I'd like to thank the organizers for inviting me to the city of Rome, the wonderful city of Rome. It's one of my 3 favorite cities in the world, not least because my wife happened to have been born here, so it's always good to be back. I'm also grateful for the organizers for giving me the graveyard slot immediately after lunch, when every one of you is probably pining for a little bit of siesta. After a light lunch, it allows me to give you a light presentation. I added some pictures. Hopefully you have a bit of fun to make things a little bit lightweight. But off to that then. The topic that I was asked to address is property rights in space. Where does the law stand now? And off the bat, I'd like to make the point that if we talk about property rights, there are, from a generic perspective, a theoretical perspective, a conceptual perspective, there are 3 types of property rights. One is, of course, intellectual property rights. It has been briefly mentioned before, which is not mentioned in the core space treaties at all, for a number of reasons, partly having to do with the absence of a focus on commercial space activities at the time. For them, intellectual property rights is, of course, a big issue, a moneymaker sometimes. And basically nothing legally changes when it comes to outer space. There have been some adaptations made in order to make certain IPR rights, such as copyright, more effective when it comes to satellite data, but that's about all. And I'm not going to address that any further because it's not really a hot issue. It's an important issue for the commercial sector, but it's not a hot issue. The second property right is what I would call rights over movable property. Everyone around in today's society owns a lot of personal stuff, and that continues to apply in outer space. Whatever you bring into outer space, a watch, a piece of personal belonging, your own clothes, that still is your property in outer space. And the Space Treaty has simply referred to that in Article 8 by saying that you own what you own on Earth, you still own in outer space. And that may, of course, be important for some space operations as well, because if you bring a habitat in outer space which you built, owned, and developed on Earth, you may still own it in outer space. What is the hot issue, of course, is the rights over immovable property. Real estate, although I would somehow rather prefer the word surreal estate, because of course there's no real estate in outer space. But the idea is, what do we do with the potential to own part of the moon or Mars, to pose the two most important elements? This is the hot issue today, and that's what I will focus on for the rest of my brief talk today. So when we look at the international space treaties, the key issue here, the only article which to some extent deals with that issue, is Article 2 of the Outer Space Treaty. It has already been mentioned. It's the non-appropriation article, the prohibition to exercise territorial sovereignty over the moon or any other celestial body or any other part of outer space for that matter. So, for example, the fact that the United States astronauts planted a US flag on the moon could never mean and would never mean that the moon or parts thereof would become US property. Now, that's all the Outer Space Treaty basically says. So when it now comes fast forward to an area where space mining, space resource exploitation may be around the corner, we have to question ourselves, what does this mean for this particular area? And there are basically, and I'm oversimplifying, obviously, there are basically two valid strands of interpretation if you look at it from a theoretical perspective. One is the argument that since outer space belongs to all of humankind, all the resources in outer space also belong to all of humankind, which, by the way, comes close to what the Moon Agreement then determines to be the common heritage of mankind. Mankind, that's the old-fashioned phrase. We should say humankind right now. But this is the literal quote. Now, of course, we know the Moon Agreement has not been very effective in terms of its application and effect, certainly not when it comes to the major spacefaring countries. But what it suggests, in conjunction with the idea that the resources belong to everyone, is that there should be some form of an international regime, perhaps including an international license, before we can actually start commercial exploitation. And that license, you can think of analogies like the deep sea bed, where we have something like that in place. It should include notably insurances that all states somehow would have to benefit from that exploitation, that it can't be just for the rich countries, the developed ones of the world, to develop. That's one very valid logical interpretation. Of course, there's another equally valid and logical interpretation, which is going in a totally different direction, which is arguing that because outer space is some form of a global commons, and I am aware that's not a legal term, but it best captures the idea that all states would be entitled to use the resources for their benefit, and then by extension allow their private sector to do so, as long as they comply with international law, with whatever international arrangements we have made. For example, and I'm just listing here a couple of requirements that the Outer Space Treaty imposes on stuff going on in outer space. There has to be an avoidance of harmful interference as much as possible. There's a requirement of continuing supervision over private operators, etc., etc. But as long as any particular country complies with that, they can unilaterally license the commercial sector, their commercial sector, to go and harvest those resources. That's the other interpretation. So that's the theory. Now, what about state practice? State practice basically started some 9 years ago when the United States, not accidentally the United States, in 2015, forced by some lobbying from private sector entities who were at the time considering themselves pretty close to actually start harvesting operations, to do something about it. This Commercial Space Launch Competitiveness Act did a lot of things, but it included one chapter which is relevant for us now, Title 4, about space resource exploration and utilization. It recognizes the property rights of US citizens. Of course, it can't say anything about Chinese citizens or Italian citizens because this is a US law, to own the space resources once mined on a first-come, first-served basis. Calls for more regulation and to authorize and supervise, to align with Article 6 of the Outer Space Treaty, And it also calls upon the US president to promote the interest of the US industry by developing some form of an international agreement on how these activities should be mutually recognized. This unilateral US activity, there we go. Okay, so this, of course, created a lot of discussion on the international, in the international context. And just to give you the bare bones thereof, these international discussions first gave Luxembourg a push. Now, I should say, in the interest of transparency, that as a consultant, I was closely involved in the drafting of that US law. Now, Luxembourg saw its chance, and 2 years later, in 2017, they created their own national law, the Luxembourg Law on the Exploration and Use of Space Resources. It is, of course, taking a somewhat different approach because Luxembourg is a civil law country, the US is a common law country, and there are obvious other differences between the two. But again, it allows basically for the private ownership of extracted resources, provides for a system of mission authorization, and includes full liability for damage. And in the interest of transparency, I was a consultant with the Luxembourg government on this operation. 2 years later, again, in 2019, the United Arab Emirates came forward with a similar law, although the law was much broader. 2019 created a law on the regulation of the space sector, full stop, but it did include a possibility on obtaining an authorization for the extraction, etc., of space resources. Different words, basically same meaning, subject to conditions yet to be determined. In the interest of transparency, as a consultant, I was involved in this drafting this law. So then we had another state, Japan, who again 2 years later, in 2021, created the Japanese Resource Act to permit the possibility of extraction resource extraction activities under a license, subject to a lot of additional information that would have to be given to the government. In the interest of transparency, I was not involved in this. I'm like, okay, so now we have 3 countries who basically side in terms of state practice and opinion juris with the US approach of allowing unilateral licensing of commercial mining activities. That was not all. There were also countries who were not so happy. For example, the Russians. You would not be surprised by now, for sure, the Russians were pretty angry. They didn't like this one bit. They came up with arguments like this is disrespectful of international law by allowing the US private sector to go ahead unilaterally. It's a new interpretation of the non-appropriation of outer space, where I would say, well, it's the first national interpretation because nobody has done that before the US before. It has all remained a little bit in limbo. It was disregarding the discussions for the Moon Agreement, which I think is a hypocritical argument because the Russians didn't agree to the Moon Agreement either. And then they started to throw some Cold War language about the domination of space. This is all this classical capitalist imperialism all over again under the guise of private enterprise. And the freedom of outer space is not an Article 1. I wonder which translation the Russians read for this. Although there's a Russian version of the treaty as well. It's not in the treaties, which is not true because it is in the treaties. It is just an opinion of experts in specialized fora. Now, I should say the Russians were not alone in their criticism. Another country which was not happy was Brazil. Brazil was not angry. Brazil was sad, disappointed. They felt that this was an inconsistency between national law and which allowed for the economic exploitation of celestial bodies and the principles of the UN, where you of course have a little bit of a discussion. Are these principles legally binding, or are they merely political ideals which hopefully at some point in time should be abided by? There's no clarity on that, but at least this is an argument which I can really understand. There's a clear statement that multilateral interests should take precedence over unilateral ones, and this is something everyone needs to agree with, because if everyone finds their own regime, then of course that's a recipe for disaster, for conflict, and in the worst case, a war. The question is, of course, what should be the substance of that multilateral regime? If you go back to what the US said in their 2015 Act, they asked the president as the third element to communicate to the rest of the world and to consult and coordinate and cooperate with the rest of the world of getting such a regime going. Because also the US is interested in an international regime, as long as it, of course, sufficiently recognizes their commercial and political interests. So no one can find fault with this. And it is clear that as a consequence, domestic legislation is a poor substitute to a unilateral instrument. If you just take the US Act, it may solve any legal dispute between two US exploiters. But if there is one company from the US zooming in on a particular part of the moon interesting for exploitation, and you have another company from China doing the same, obviously the US law doesn't give you a solution to the dispute, because the Chinese company can say, I don't care what the US law says, that's not applicable to me. So these are all valid discussions. And as a consequence, since 2015, basically, we saw an international discussion developing on what is the proper interpretation of Article 2. It was a little bit broader than that, but it amounts to that. So do we have this approach, again, of allowing individual countries to unilaterally license as long as compliant with whatever international limits are provided by international space law, including the Outer Space Treaty? Or should we indeed create an international regime which requires all states somehow to benefit from the licensing? A few latest developments which I think give you a little bit of a sense in which direction we are going. They have already been mentioned today, the Artemis Accords. Now, Artemis is, of course, the female companion in Latin mythology, or in Greek mythology, I should say, of Apollo. The Apollo program was about putting the first man on the moon. Artemis program is about putting the first woman on the moon, but that's just a flag bearer, almost literally, for a much broader project which the US National Atmospherics and Space Administration, also known as NASA, wants to engage in, namely the preparation for and realization of permanent habitation of the moon, permanent settlement of the moon. The Artemis Accords are then concluded with like-minded states, because a little bit similar to what happened to the International Space Station decades ago, the United States invited anyone so interested on joining that Artemis project, in particular long-term habitation of the moon. So the more the merrier if you're interested in contributing your scientific and technical and engineering expertise and want to join us on this great effort for humanity. In principle, you're welcome. We should, however, agree on some rules of the road at the outset. It would be a little bit silly if if states spent billions on getting there, and then once they're there, they realize that they fundamentally disagree about some of the principles which are supposed to rule their joint operations there. Better, that's one rule where, and our professor from Mississippi referred to the ex-ante thing. This is a great reason for doing an ex-ante agreement. You want to have some rules of the road before you have an actual conflict, because then you have entrenched interests and it becomes much more difficult. So what the Artemis Accords do is set down a number of principles which NASA says that's the way we want to approach permanent habitation of the moon. And we think you should sign up to that, otherwise we will have a problem at the outset. It doesn't mean that they are written in stone. It is specifically recognized that the Artemis Accords are not supposed to be a treaty. It's not treaty law, but it at the same time has an important element. And that brings me now to our topic of my own talk. It includes the principle of freedom of mining of space resources on the moon. So the idea is that if you join us on the Artemis project, you agree that one of the best ways to make that happen is to allow, first of all, the mining of resources on the moon, because everything we can build from lunar resources is so much cheaper than if we have to bring it from Earth to the moon. And B, if we can get the private sector to do that better and quicker and more faster than we do, we should do so. So pretty much in line with what the 2015 Act says. So if you sign up to the Artemis Accords, it probably does not yet amount to state practice and opinio juris, making that customary international legal and customary international legal obligation, but over time it may evolve in that direction. So let's have a look at the states. And as we speak, more and more states join. I underlined Italy because, of course, we are in Italy right now. You see 3 countries in yellow, or in orange, I should say: Australia, Mexico, and the Netherlands. Why do I put them in orange? Because these 3 countries are countries who are signatories to the Moon Agreement. And if you recall, the Moon Agreement at least suggests some form of an international regime, but apparently those 3 countries do not consider their signature to the Artemis Accords as running contrary to their obligations under the Moon Agreement, i.e. they accept the possibility of private commercial exploitation of lunar resources as not necessarily being in violation of the Moon Agreement. We are not going to know where that ends up. Maybe at some point in time they will have to choose. They will have to find that the two are not compatible. The country in blue has already been mentioned. Saudi Arabia took that opinion. They were a long-standing party to the Moon Agreement, but last year they announced that more or less as of today they would be out of the Moon Agreement. It's the first time, by the way, in history that a country resigned from an outer space treaty, any of the 5. So that's already a token into itself. And apparently the Saudis didn't consider this compatible with their interest in joining the Artemis Accords. Interesting is also the country in red, Brazil, because you may recall that Brazil originally was one of the strong opposing parties to this idea, and Belgium is the second one in there. I didn't mention Belgium before, but Belgium was also very much worried about the fact that this might lead to unilateral exportation by a bunch of rich mining companies from a handful of states, or probably just from the United States, which is of course the worry that is behind much of this resistance against the US approach. We saw China and Russia is clearly in red as well, already discuss cooperation amongst themselves. Now, I think this is really politically driven. I haven't seen any substance of what this agreement says about the feasibility and the legal possibility to mine resources. But I would be hard driven to expect that the Chinese, in terms of substance, take any other approach than the US, namely, who comes there first to mine, as long as compliant with international law, gets the goods. And it might very well be the Chinese who are getting the first to be there. Okay, I have to wind up, I see, in view of my time. There are some bilateral agreements with Luxembourg. Bilateral agreements with the United States are sometimes for political purposes not a likely road to go, but you see that a number of countries have signed up with bilateral agreements with Luxembourg, not just Belgium, but also China, in order to cooperate vis-a-vis lunar activity. So that already gives me a token indication that China might, in principle, accord to this idea of the common global commons, where every state is entitled to, etc., as well. Even Russia, at some point, tried to negotiate a bilateral agreement, but frankly speaking, that must have been just as a bit of a window dressing, or as a bit of information gathering, trying to find out what these small Luxembourg smart asses would be going after. I will leave it at that, and I hope I didn't go too far beyond the time. Thank you very much.
Thank you, Professor van der Dank. You didn't go at all across beyond time. As a matter of fact, I was giving you 5 minutes more. But thank you for this.
You know, that's always a great risk, giving a law professor 5 minutes more to talk.
No, what law professors? You know, if you give an Italian law professor 20 minutes, it's just like giving a peanut to an elephant. That's more or less. I mean, he has started. After half an hour, he started more or less. He's still around Gaius and things like that, and Justinian. So he hasn't yet got into the things. But having said this, it is my pleasure to give the floor to Professor Diana Cerini, who teaches comparative law at the University of Milano Bicocca, and so as a senior myself, as a senior professor of comparative law, I'm very happy that younger professors of comparative law engage in this very promising area.
Thank you, and thank you for inviting me to this conference here, which gives me the possibility to talk about insurance, which is the field that, to tell you the truth, I know best. I'm a little outsider in space law, but of course, insurance is essential, and there are a number of issues that we are discussing in insurance concerning the space activity. And this is for the very simple reason that space activities are increasing at an incredible speed, of course, and as every other human activity, space ventures are risky. Let me say that space ventures are even more risky, of course, no need to tell you, because of many reasons. And for this, insurers have been partners in these pioneering missions, let me say, since the beginning. Even if there were some voices saying this kind of risk were not insurable because of the unknown that accompanied the space activity at the beginning, the market soon reacted. And let me also say that in particular, even Italian companies were very active in accompanying the space missions since the beginning. Let me just remember one of the greatest examples of Generali, who provided some of the first policies for early bird ventures. And then others, of course, work together. But the transformation of these space missions from an occasional activity into an industry, into a business, with public and private actors, as we have so well heard since this morning, increase the offer of insurance contracts and solutions, which nevertheless remain very special in the insurance business for many reasons. The first reason is that here we see the multiple role of insurers. In particular, they are risk taker, of course. They are risk takers, but they are also partners, sometimes in assessing the risk and in cooperating in preventive activities. The second reason is that insurers are also investors. We know that insurers are the biggest investors in the global finance world, and so we will say something about that. One other very technical reason is that space risks are considered of a particular magnitude, so we classify them as large risk or even more as catastrophic risk, which implies specific techniques for managing this kind of risks. One element that also is well understood, according to what we have heard today, is the fact that a sort of legal uncertainty remains in the field. And as we know, insurance covers property damages, but also liability damages. And if we multiply this in the landscape of the space activity, we can understand that there is a high legal uncertainty. And the insurance contract covers risk, that is to say, damages and liabilities, which of course has an impact on the coverage. In addition, we have to remember that space insurance is provided generally by co-insurance companies. Reinsurers, of course, are behind. And if we look at the insurance business at a supranational level, we heard that also from the colleague of UniDroit. I'm part of the group working with UniDroit on reinsurance. We know that there is no common insurance law. And so we have the legal uncertainty concerning the substance of the business, plus some aspect of legal uncertainty when we think of multilateral insurance umbrella agreement or master agreement that are used to cover this kind of risks. One other very essential element which we find in space insurance and also in some other types of insurances is the necessity of a strong dialogue among private players, the insurers in this case, and state, public governors. I will not go further, but of course it remains essential that insurance strategies are defined in cooperation with public entities and regulators. And this is essential for insurers, first of all, because they need to know and they need to have in any way a second level of coverage by the state, or a first level, it depends from what side we see it, but anyway, they have to cooperate with the states and the regulators. And for the other simple reasons that insurers themselves and reinsurers too are considered, as we know, the silent regulator, which means very easily that if we do not have insurance, a given activity cannot be performed in many cases. We see that in many, many areas of the law. And this implies that, of course, when a new venture or a new regulation is discussed, the insurance topic, the insurance matter is taken into consideration as the twin of the liability issues. And if we consider also examples of legislations abroad which have already dealt with and in deep with insurance, we see that, of course, there is a need to not only regulate the liabilities eventually and the insurance, but also the mandatory insurance, and so the content of the insurance, but also to give sort of incentives for the spreading of insurance coverage from the tax point of view or for many other aspects. So this is just to put on the table some aspects that make the space insurance so peculiar. Then, if we look at the business, we can say that in the history of insurance in this field, of course, these are all tailor-made contracts, but we can identify some specific coverage that recurs in the pre-launching phase, evidently, which goes from the construction and manufacturing to the transport, preparing, generally acquired by manufacturers, state, whatever it is, in the plan to pursue the space venture, the phase of the launching of the satellite, where we have a specific type of insurance contract, positioning, and then operating of the satellites or in orbit activities. And even in this field, the international markets have identified some sort of model contracts, for example, coverage for launch plus 1 year or in orbit coverages. Well, if we look at these different phases, there is no doubt that in many situations, the pre-launching phase and the launching phase are the more risky, but at the same time, if we look at the actual application of these space activities from the strictly contractual point of view of the insurance contract, we can say that the contract covering, for example, the operating of satellites has a number of complexities that relates to the use of satellites and other space activities on Earth. Let's just, for example, imagine how complex is to deal with the insured event and to decide in case of malfunctioning what is the notion of an insured event, a singular insured event, or multiplying insured events with many, many consequences. Or let's think about the types of coverages that are considered. We have direct insurances, which means insurance for the property damages. Here, the party exposed to the risk is directly insured. We have liability insurances, and we have loss of income, in particular, if it relates to activity connected to on-Earth use of space activities. And of course, we can immediately understand these aspects, especially liabilities deriving from agreements with final utilizers or loss of income, how important they can be from the contractual point of view. And this, of course, has led to a sort of diverging situation. From one side, there is a bigger and bigger interest for insurance of the insurance side for space activities. But on the other side, if we look at the global perspective, we have seen that the ratio among premiums collected and compensations paid remain in many cases not really profitable, as lead insurers and companies say so. And so just think, for example, that in autumn 2023, a single event absorbed 80% of the collected premiums in the insurance business. And so even one of the most promising area for from the economic point of view and also for the possibility to offer coverages is seeing opposing solution. For example, the low Earth orbit activities is one where we see from one side the concentration among competitors, which means that those insurers are able to provide a certain type of coverage, and on the other side, a fragmentation of operators, which of course requires also new strategies for offering and distributing these types of coverages. So what is going to happen now? Of course, we have also to look at what's happening outside the space law, so to say. And in particular, if we look from the insurance point of view, let me remind that we have two big sectors in discussion at the moment. One is, of course, cybersecurity, which is traditionally an under-insured sector, especially in Italy, but not only. And of course, space insurance operates in strong connection for many types of risk with cybersecurity risks. So we will have two different types of insurance models that have to cooperate. And secondly, we know what's happening in Europe about artificial intelligence. We are going to approve, practically we have approved the Artificial Intelligence Act. And you may know that, of course, in the Artificial Intelligence Act, there's a mention to the level of risk, and we have the idea of introducing mandatory insurance for the so-called high-risk activities. There's a list of high-risk activities, but there is no doubt that they are strictly connected to a number of application of space activity, or they operate in conjunction with them. Let me just mention, for example, the cases of autonomous vehicles, for example. And so if we think that maybe we will soon have a mandatory insurance for high-risk activities, that is to say activities that use artificial intelligence and are qualified as high risk, we will then have to counterface the functioning of space insurance, which, as we have seen until now, is not harmonized, not even in Europe. We have solution of mandatory rules in France, which is a country with a very strong tradition of mandatory or compulsory insurance. They have a law providing for mandatory insurance for strict liability, but we have many other different solutions. So the functioning of these two types of insurance will sooner or later we have to work in strong connection. Just to, I don't know the time, but I don't want to be the stereotype of the Italian professor you mentioned. So just to mention two more things. The new risks, so to say, or the increasing of a specific risk, for example, connected to space touristic activities, but I'm not going further on that. The other one is activities connected to new application, new among marks, of course, because we have, for example, application in geolocalization processes and so and so. So in all these cases, there will be a higher need for insurance. And I just want to close making reference to two aspects that are important. The first one, I mentioned it at the beginning, insurers are investors. They are the biggest investors in the world. And of course, they can invest either with their own resources or they are indirect investors, which means that they collect high quantity of money with premiums, and they have to give a direction to this collected money. And we know that the European Union has strengthened the position of insurers in particular in order to address them, to address the clients towards sustainable investments and to certain types of investments. So this is very important also for the space ventures because, as we know, these are ventures that may require a lot of money. Secondly, the space is in itself a resource for insurers because they use a lot of on-earth consequences of the space activities for many segments of their business. For example, for collecting information, for the claim managing, because once again, they collect big data and they are able, in case of multiple events on Earth, catastrophic events connected to natural disaster or also many other sources, data provided from space activities are essential to fasten the process of the claim managing. And of course, there's another issue, which is prevention. The activity of insurers is actually moving from covering the risk and paying for events to prevention. There's a big change in the insurance activity, and even the solvability process or the regulation on insurance should take that into consideration. But if we look in particular to the space business, prevention can benefit a lot from data collected from space activities, which recall immediately to me, once again, the sustainability issue, because both in prevention of catastrophic event or managing events following catastrophic events or in any other type of prevention activity, of course, there is an impact on the so-called social and environmental sustainability factors. This is very clear because if we can foresee a certain event and use communication, online communication, for example, to inform people, to save lives or to better manage environmental risks, of course, there is a strong impact on the E factor, the environmental factor, as well as to the social factor of sustainability. So I think that it's a combination of the role of insurers, not only as risk takers, but at the same time as users of space services connected also to sustainability, which will allow us to understand even more why insurers are so involved actually in the space, not only regulation to be, we have seen it also in the first draft of Italian legislation on the table, but also in a concrete and proactive role connected to the use and managing of space activities. Time.
Thank you, Professor Cellini, for this very important aspect and this presentation of the dual role of insurance companies, which is obviously puts a whole lot of further issues on the table. Now, I'm very happy to give the floor to Vanessa Vitti, who belongs to the Contracts Office of the Italian Space Agency, and I'm extremely pleased to give her the floor because Vanessa Vitti is a graduate from Roma 3, this law department, and so it's nice seeing that our graduates are moving and contributing in society with what they have learned here at Roma 3. Dr. Vitti, the floor is yours.
Thank you. Well, first of all, good afternoon to everybody. Thank you for inviting me. This is really in this really interesting conference. For me, it's a real honor to be here present today. So I want to thank you, Professor Sirio Zolea, for the excellent organization of the conference, and Professor Zeno Zenkovic for coordinating us in this panel, and also for introducing me. Effectively, the last time I've been here in this room was for my graduation, so this is kind of exciting. And also, I want to thank my colleague, Dr. Nicoletta Bini, for inviting me to be a part of this initiative. The topic I've chosen to deal with today is related to the procurement rules and execution of R&D contracts. I've been delving into this topic since I was a research fellow at the Italian Space Agency, and I was writing my doctoral thesis on contractual autonomy on the public administration in Italy. I currently work at the Italian Space Agency as contract officer specialized in procurement procedure of R&D contracts. And since this is my job, I hope I will be able to offer you a valuable insight about procurement rules and execution of R&D contracts managed by public buyer as the agency is in the frame of the European and national procurement rules. When I begin my experience in this particular field, but even more so today, in dealing with the research and development contracts applied to the space sector, I've always wondered how we, as a public buyers, can manage to reconcile the regulation on the procurement and execution of public contracts with the needs of research, in my case, research in the space field, and the research and development contracts. It seems to be an issue of particular interest, especially today, following the COVID-19 crisis and given the Europe's significant investments with the Recovery and Resilience Facility, aimed to promoting economic recovery and the green and digital transition in Europe. All these objectives can be achieved in large part with the innovation procurement carried out mostly by public investors. In this context, is it clear that public buyers become even more critical investors than in the past, and therefore they also become the ones who have to promote new procurement solutions. The European Commission's notice of 2021 about guidelines on innovation procurement begin to highlighting how innovation procurement for space application by public entities at every level, national and regional, can really make the difference to the implementation of the European Green Deal and digitalization. Public administration are the largest user of the space technology in areas such as public safety, protection of critical infrastructure, public transport, maritime, aviation, and rail operation managed by the public authorities. If we talk about procurement of contracts of development and space technologies, we can only refer to this issue in the context of the innovation procurement, which have at least one of the following aspects as their target. The first of all is buying the process of innovation, consisting the research and development services with a final outcome, which can be the creation of a prototype. And the second is buying the outcomes of the innovation on large scale as a result of a partnership. In this context, research and development contracts applied to the space sector are mostly related to the first of these aspects, and therefore the development of purchase of a prototype. So the public buyer must use the right procedures to ensure more flexibility to the process, as the European Commission recommends less bureaucracy, higher efficiency. And here are the reasons why we need this kind of flexibility when we are dealing with the R&D contracts. First of all, it's difficult to estimate the exact activities and costs in advance. And in this area, the administration only knows its own needs, but doesn't know how to meet them. So we must cast the market both for the project and the execution of the contract, and sometimes only being able to make a rough estimate of minimum technical requirements and costs. In addition, the execution phase of R&D contract, we also need to take advantage of more flexible regime, which allows to make it easier to make changes and variants during the execution of the contract, depending on the type of the product we are looking at and at the technology readiness level. It also can be needed to reduce or extend the delivery times, especially when operating in international cooperation scenarios. This can happen, for example, when several partners, whether public or private, appointed by their respective space agency or other public bodies, cooperate in the same mission. That's the case when it is necessary to align the timing of the implementation of the individual components and when we need to consider different launch windows identified by the launch providers. We also have to consider the different development stages in research project. For example, the life cycle of a space project in Europe is typically divided into 7 phases derived from the European Cooperation for Space Standardization, ECSS standards. The space program development normally takes place through several consecutive contracts defined at the end of every single development phase, therefore not predefined, normally managed with the same public-private collaboration. It is easy to understand we are acting in a context where high risks and increasing costs can occur, and that's why a greater level of flexibility is needed. The European Commission itself underlines these risks, calling for a cultural change not only among public buyers, but also within the entire ecosystem, among economic operators, political authorities, auditors, and even the academia. This is important to acknowledge, and here I quote, the fact that doing innovation procurement entails risk, for example, the unsuccessful delivery of the product of the services, of a mismatch between the expected result of delivery and the delivered solution. So public buyers are often skeptical about additional risk in their procurement procedures because they manage public money. So given these challenges, what can the public buyer achieve and to achieve, what can do the public buyer to achieve these required results? There are some different procedures we can use according to the European rules, but let's see which ones are the most innovative. First of all, we have the pre-commercial procurement, which is a procedure we know since 2007, which is elaborated by the European Commission itself. So what are the characteristics of this kind of procedure? It is the target of this kind of procedure is to cover the phase of study and the development of a solution, the development of a prototype up to the initial transformation of a prototype results before marketing, which means that the procedure is divided in different stages and the public buyers is directly involved in the development process. It participates to reach the final results, and there is more than one project that is carried forward to the final stage. The other characteristic of this kind of procedure is the risk and the benefits that are shared between the public buyer and the economic operator, such the cost and the results, which means that the ownership of the results will be shared, and there is the possibility that the results will be in the ownership of the economic operator itself. In specific cases, the European Directive and the Public Contract Code should not apply to this kind of procurement, which means more flexibility, especially during the execution phase. The other procedure we can use is characterized by its goal, which is the development of the prototype up to the large-scale production, which means that the final goal must be the purchase of commercial volumes and of the end products, not just the prototype. And also in this kind of procedure, there is more than one project that is carried forward to the final stage. The risk and benefits, such as the costs and the results, remains usually in the hands of the public buyer. The instrument allows to keep the intellectual property right in the hands of the public buyer, taking into account future needs as also regarding the adaptation, modification, or also transfer to different public buyers. The European directive, as the public contract code, shall be applied to this kind of procurement, which means less flexibility both during the tender phase than the execution phase. Then there is another kind of procedure we can use, which is the R&D procurement by negotiated procedures. Its objective is to develop and acquire the prototype only, not also the commercial volumes of the final product or services. And this procedure can be divided in different stages, and the public buyer is directly involved in the development process, and he participated to reach the final results. The risk and cost really usually remain in the hands of the public buyer, and the results also, but they must be shared by granting free licenses to third parties. And this is really important because it permits to protect the results when it's necessary, for example, when it is considered strategic, but at the same time permits to incentivize the innovation potential of the economic operator. Under certain circumstances, under certain conditions, the European directive and the public contract code shall not apply to this kind of procurement, which means more flexibility both during the tender phase than the execution phase. It depends on the regulation of the intellectual property, which is crucial to identify the procedure, the procurement discipline. Concluding the examination, what can be realized from the European legislation and evaluation on the subject is that R&D procurement, the fundamental element is the collaboration and co-design with the economic operator in charge of the research, whether public or private, which becomes an essential partner in the research and development process promoted by public buyer. What I want to point out is that the evolution of the rules leads us more and more towards the horizon of the partnership, in which the parties abandon the typical relationship of subordination where the public buyer and the client is the client and the contractor is the mere executor. From this point of view, it is clear that the relations between the public buyer and the contract will also have to manage through the use of shared pre-contractual and contractual instruments and more flexible rules, preferably in the form of guidelines based on the maximum expression of the contractual autonomy, especially of the public buyer, while respecting the principle of the European treaties. Thank you.
Thank you, Vanessa Vitti, for this. I think this is very important, especially from a comparative point of view, because when we look at public procurement and we see this very rich legislative and jurisprudential texture in Europe, depends very much on certain countries, but anyhow, we have a EU legislation which covers all 27 member states, and we start doing comparison with what happens in other parts of the world, typically the US, we see this is somehow of particular interest. So Professor Cerini said that insurance is a silent legislator. Well, public procurement procedures are, I feel, that play a very important role in shaping how we want to see the future of space activities, of European space activities. So it is, as Marco Ferrazzani was saying this morning, it is to go on far in outer space. You must start here from the Earth, and on the Earth we have to go to down to Earth public procurement procedures. Without them, we don't go very far. Now, having said this, it is my great pleasure to give the floor to Professor Marco Pedrazzi from the University of Milan, Professor of International Law, and so we return to sort of the pioneers of framework of space law. Professor Pedrazzi, the floor is yours.
Thank you very much, Mr. President, and I thank you. I thank very much Sirio Zolea and the Department of Law of Roma Tre University for inviting me. It is really a pleasure to be here. I know I am now the obstacle between you and the coffee break, and so I will try not to be too heavy, and I will also do my best efforts not to be the elephant in the room to which Professor Zeno Zenkovic referred before. Anyway, the topic of liability has been already touched by various speakers, in particular also by Professor Marchisio this morning. When considering the aspects of interplay between international and national law relating to liability, I was verifying that there are so many aspects that, I mean, one could speak for hours about these aspects. So I don't have any claim to be exhaustive in what I will be saying. I will try to touch some issues. But first of all, I need to recall what is, in very brief terms, what is the liability regime for damage caused by space objects. It is a regime of public international law liability which operates at the level of international law and not of domestic law. It is based on the liability of the launching state, which is liable towards a state which has suffered damage or towards a state which is claiming on the part of physical or juridical persons who have suffered damage. Now, such a liability regime does not per se require implementation in domestic legislation, does not formally require implementation in domestic legislation. Obviously, the Article 6 of the Outer Space Treaties requires implementation, but not the liability regime per se, because the launching state is liable in any case. So whether it has or it doesn't have a domestic legislation, the launching state is liable. Nonetheless, it is advisable, of course, for launching state to have a domestic legislation. And there are various aspects of interference between domestic legislation and international law relating to this liability. First of all, there is no doubt, and it has been mentioned several times, that the state is liable not only for damage caused by its space objects, but also for damage caused by private space objects. And we know that the liability of the launching state is identified according to 4 criteria. The launching state is the state which launches, or the state which procures the launching, or the state from whose territory the launching takes place, or the state from whose facility the launching takes place. Now, provided that each of these criteria may be relevant, and that taken all together, they may lead in certain cases to identify multiple launching states, there is one criterion that is paramount: the state from whose territory the space object is launched. It is paramount because the great majority of space objects are launched from the territory of a state.
And in many cases, this is also the state to which the object and the operator are most connected. This is not, of course, not always true, but it is true in many cases. This means that the great majority of private space objects in case of damage would determine the liability of at least one state. Obviously, there are the other possibilities that have been already mentioned, for which the answer is not so clear in relation to these criteria: launch from the high seas, launch from the international airspace, launch from the International Space Station. But I would like to point out in relation to this that the effect of, as recalled by Professor Marchisio this morning, the effect of Article 6 of the Outer Space Treaty is to attribute private space activities to the national state. Therefore, if a private operator launches a space object from wherever the launch takes place, the operator's national state qualifies as the state which launches the space object, which means that not only the territorial state, but also the national state are automatically launching states. This is certainly true, in my view, for the states parties to the Outer Space Treaty. And we know that most of the spacefaring states are parties to the Outer Space Treaty. But I think there are good elements to consider that the main provisions of the Outer Space Treaties have entered the field of customary international law. It is true that we are going towards a period of probably fragmentation of international law to a certain extent. But I mean, as by now, the Outer Space Treaties remains the general framework, which, in my view, corresponds in many respects to customary international law. There remains one case to be considered, that of a private entity procuring the launch of a space object, applying the same concepts that I applied until now. I would consider that also in this case, the national state is procuring the launch, as the private operator's activity would be attributed to the national state. And there are some national laws that provide in this direction. For example, just an example, the French law provides that any natural person having French nationality or juridical person whose headquarters are located in France, whether it is an operator or not, intending to procure the launching of a space object, needs authorization. Now, one has to be careful in this field to consider. I know this will be a topic which will be considered also tomorrow, I think, how much national legislations create international law in the field of space activities. I think that in the field we are considering now, one must be very cautious in desuming from national law either what is the interpretation of a treaty, which could contribute, it could be, according to the Vienna Convention on the Law of Treaties, a subsequent practice of states so forming what is the correct interpretation of the treaty, or even modifying to a certain extent the content of the treaty, or from the point of view of customary international law, practice and opinio juris. It is certainly true, as Franz van der Dunk mentioned before, that if a state is providing in its national law for the possibility of acquiring resources through space mining, that state is saying, I consider this activity as internationally lawful, or I wish this activity to be considered as internationally lawful. But if a state is authorizing a certain space activity, in my view, this does not necessarily mean that the state, it can be a policy option. This does not necessarily mean that that state considers that it is bound to authorize that activity, or that it considers that it is liable under international law for any damage caused by that space activity. So I think one has to be cautious in this on these aspects. Now, obviously, Professor Marchisio has explained very well this morning what is the main purpose of national space legislation in relation to liability for damage. Obviously, the state wishes to recover the burden of compensation paid by to recover the burden of compensation paid by the state from the private operator, which is responsible for the space object. At the same time, the state wishes to protect the space industry, and so to protect the private operators. And there we have the maximum cap of liability cap, and there we have all the insurance issues that have been very well considered before. So this is obviously the main point in implementing what are the provisions of Article 7 of the Outer Space Treaty and the Liability Convention in national law. Now, one has to notice that international liabilities, a second aspect of interplay. International liability, as devised by international law, is not exclusive, obviously. In particular, according to Article 11, paragraph 2 of the Liability Convention, nothing in this convention shall prevent a state or natural or juridical persons it might represent from pursuing a claim in the courts or administrative tribunals or agencies of a launching state. A state shall not, however, be entitled to present a claim under this convention in respect of the same damage for which a claim is being pursued in the courts or administrative tribunals or agencies of a launching state or under another international agreement which is binding on the states concerned. Now, this norm has two implications. First, that it is possible for the state to provide for a domestic system of operators' liability. Second, that the choice of the domestic claim excludes the other, or in other words, electa una via non datur recursus ad alteram. To specify better, the introduction of the international claim will not prevent from starting a claim before a national court, unless such a preclusion is contemplated by national law. But the introduction of the national claim will definitely obstruct the way for the international claim, unless the national claim is abandoned. And I say definitely because considering the normal times of domestic justice and the fact that under Article 10 of the Liability Convention, the international claim may be presented to a launching state not later than 1 year following the date of the occurrence of the damage or the identification of the launching state which is liable, it is highly unlikely that the national proceedings will be concluded before this deadline. As to the nature and characters of the domestic liability, it may fall under the general regime of tort liability or under a specific regime regulating liability for damage caused by space objects. One needs to add that the international regime excludes damage caused by the space object to nationals of the launching state and foreign nationals participating in the operation of the space object or present in the immediate vicinity of a planned launching or recovery area as the result of an invitation by the launching state, Article 7 of the Liability Convention. Passenger liability is equally excluded. So all these aspects shall be covered by national law. One obviously also has to note that in transnational situations, the national court will have to verify whether it has jurisdiction based on the applicable rules of international civil procedure, and the national law called to rule the case will be determined by the applicable conflict of laws rules. A further aspect, in my view, implementation is required. Implementation of international liability is required under one aspect in relation to this, if the domestic system is not ensuring what I'm going to say. In case of damage suffered by natural or juridical persons, compensation is meant to cover their damage, not the damage suffered by the state introducing the claim, such as in traditional diplomatic protection. So the national legal system or the national practice shall guarantee that if the state claims compensation from another state for damage suffered by natural or juridical person, the amount of compensation which is effectively obtained by the state will effectively reach the victims. This is, in my view, absolutely clear, considering the purpose of the international liability regime. National laws may do more than this. They may provide for redress to citizens or foreigners suffering damage caused by foreign space objects, even in the absence of a successful international claim on the part of the state. This is in part the case of the Italian legislation. We have heard that Italy does not yet have a full space law, but it has some sparse norms. And well, one relevant norm here is contained in law number 23 of 1983, 25 January 1983, based on which the Italian state will compensate Italian victims of damage caused by a space object launched by a foreign launching state, not only in the case in which the Italian state has obtained compensation, but also in case the Italian state has not claimed compensation, unless this has been obtained by another state, or it has claimed, but it has not obtained compensation. On the contrary, foreign victims may obtain compensation from the Italian state if they are resident in Italy, or in the case that only if the Italian state has claimed and obtained compensation from the launching state. So there is a discrimination between citizens and foreigners, which can cause problems under EU law, but I will not deal with this. A further problem which may arise and may affect the liability issue is the transfer of property and control of a space object in orbit. No doubt that the national state of the transferee, if different from the national state of the transferor, will become the responsible state or a responsible state based on Article 6 of the Outer Space Treaty. But the liability aspect is more complicated because the transferee's national state is not necessarily a launching state. Unless, so we should not even have a change of registration because the state of the registry should be it is not contemplated by the Registration Convention. So what can the national state do in its own legislation? Well, first of all, the state can authorize, as some states do in their national space law, they can authorize the transfer of property control of a space object. And they can provide for the consequences of liability in this kind of situation. I will just mention as one example introduced by Belgium in Article 13, paragraph 5 of its national law. When the transferee operator is not established in Belgium, the minister may refuse the authorization in the absence of a specific agreement with the home state of the third party in question, and which indemnifies the Belgian state against any recourse against it under its international liabilities or claims. So there can be a provision in the national law to protect the state's interests, also in this case. So these are really some of the main issues that relate to the interplay between a national law and international law. There are many other aspects concerning liability which we might consider, such as, of course, product liability is another very interesting topic and very important topic. But I will not deal with that, and so I will conclude here and leave open to the discussion any further aspect. Thank you very much.
Thank you, Professor Pedrazzi. As a practicing lawyer, and especially a practicing lawyer in the field of torts, I see a nightmare in the case of some kind of accident occurring, third parties during space operations. I really try to understand how I would be able to find a claim, and this somehow sort of can be, you fueled Professor Cerini's point of view. I mean, yes, it's difficult to ascertain what the risk is, but from a legal point of view, it seems that the risk is very, very low because of the fact that the international legislation doesn't make it very clear who is liable, and so obviously insurance will take advantage of the fact that the legislation is not clear. But having said this, as all the speakers have been admirably precise in their timing, we have there's time for questions and answers if you want to address questions to the panel, and we are here, but the only request is that you speak from the microphone, otherwise they can't hear us from home. Please always your qualification before you speak.
Good afternoon. I am Francesco Russo, a journalist from the Italian news agency AGI. I have a question for Professor von der Dank. And my question is, what is the possible outcome of the discussion towards a framework for the interpretation of the Space Act? Because the exploitation of the moon resources poses the first serious problem about this void in jurisprudence. Do you think that the most likely scenario is international body that could take care of the interpretation, or do you think that the US will use the strategic advantage in being the first to provide a comprehensive legislative framework? Thank you.
That is a great question. I would like to broaden it a little bit beyond the two alternatives that you sketched. What you see happening now is what I tried to sketch as a gradual development towards acceptance of basically the US position, which is now officially shared by 3 other countries. Excuse me. What I didn't mention yet, but what is important to notice is also, if you look at the list of countries that signed up to the Artemis Accords, with all the caveats in terms of what that legally means, and Professor Pedrazzi made a few remarks on that point too, it is very interesting to note that you see countries from all over the world. It's not like with the ISS, for example, that it was limited to a handful of technologically advanced countries, but you see Rwanda and Nigeria in there from the third world. You see 2 Arab countries in there. The main reason I dare say why China is not there is basically twofold. One is, politically speaking, China will never engage in anything where the US is the leading partner, just for political reasons. They don't want to be playing the second violin in any respect. And the other reason is a legal reason from the US side, because of the past, so to speak. The limitations for the US to work with China on any highly technical project are very limited. Every NASA exchange with a Chinese colleague has to be vetted through endless levels. So those two are the only rules, because I think that on the substance, the Chinese would basically in agreement with the approach of the US. So going back to your question, what I do see as the most likely outcome is not an international treaty for a number of reasons that have been addressed before. The political climate right now is not conducive to anything like that. What I do see is a gradual bottom-up acceptance of the feasibility and the likelihood, and presumably also the legitimacy of unilateral licenses, with one big caveat, and that is the compliance with international law. And I've made myself often the comparison in this regard that it is like the law of the high seas. Like high seas belong to no one, yet fishermen have for centuries been able to make their living and more by fishing the fish on the high seas, which they don't have to share with any countries or anything else. The difference is that we do have a pretty well-developed regime of international rules protecting overfishing, pollution of the high seas, and things like that. And of course, a de facto situation that there used to be, it's not anymore, but at least there used to be enough fish for everyone, right? I mean, now we are facing these issues as well. In space, we hardly have any rules considering what it means to not interfere with other space activities, what it means not to destroy the environment of the moon. There have been some efforts at. So my plea would be that we should develop some stronger rules there. I don't see, as to answer part of your question, I don't see an international body regulating that. That's also, given the political climate, I think is out of the question. What I do hope is that at least the major spacefaring nations agree on some sort of general rules of the road, like a reasonable amount of security on the one hand being given to operators who are supposed to invest the billions to make some money, but on the other hand also to protect the public interest, not just in security, but also in the environment, in some form of sharing. There have been a lot of interesting ideas. But I don't think that we will ever be able to go back to a situation where what was like the Moon Agreement originally envisaged, some sort of strong international regime which requires, unlike the law of the sea, for example, where we do have on the seabed floor now an international regime requiring an international license and all that. I don't see that happening. For that, there have been too many states now siding with the US, if you want to put it that way. And so either we see the rest of the world converging on the same point, and maybe 5 or 10 years from now, we will see that as a kind of customary international law, or we will remain to have fundamental differences in opinion about legal status. And I think that's the worst of the two solutions, because that means that that's a recipe for conflict. Then we will have some country who is saying, well, you are illegally exploiting the moon, whereas the country which is accused of so doing itself doesn't consider this illegal. And then it's just power politics which should play a role. And I think that's even worse than a situation where we have a basic agreement that unilateral exploitation is feasible, legitimate, allowable, as long as compliant with a more stringent set of rules protecting the environment, protecting everyone's interest, including, for example, in Neil Armstrong's footsteps, right? Few people would agree to a commercial operator just wiping out those footsteps, because those are an important part of human history. I'll leave it at that. I could go on for another hour, but I won't.
Thank you. Any other questions? Yes, Professor Barela. If you can speak from the Professor Barela, University of Salerno.
Yeah, thank you. So I have a question for Diana Cerini. So presuming that the risk assessment is quite important for insurance and of missions, all space activities. I wonder, how do you think the space law that everything is in progress will cope with the very unclear parameters of risk? So it's very difficult to understand which damage will be caused by a drilling or by exploitation activity. So, because of course, if we remove mass, the asteroids, for example, will move its trajectory. So, of course, there are many problems. So, but the parameters of risk are very unclear, difficult, and so I think it's a premise to understand how to measure also the insurance.
Thank you. I think this is exactly, there was an image in the slide that I used where there was a number of baskets, and this simplifies how the insurance techniques works. That is to say, analyzing the risk and dividing the situation of risk into homogeneous categories in order to set price, that is to say the premiums. So in order to do that, insurers from the very technical point of view need to know data about events, of course, and the other side is the applicable law, which determines a number of issues: prescription, limitation time, entity of the damages, subjects that can call for a compensation. So I think these two elements combined are exactly the reason why at the beginning there was a high worry about the possibility to offer concrete insurance. When I say concrete, I mean substantial insurance that would not only cover certain types of collateral risk, but at the same time, I think this is exactly the legal uncertainty I made reference. And for what I know, of course, the idea is that especially where these aspects are not so clear, there is the need to find strategic solutions where insurers could work together with the state, but also at the same time about new techniques for risk management, which implies, for example, the creation of an alternative solution to the simple insuring an event and giving compensation. For example, funds, collateral guarantees, but especially for the topics you mentioned, the idea is exactly to give a photograph, a clear picture of the risk in substantial term, and then tries to focus on the subsequent rules to apply. Let's also consider that, as has also been said, the complexity of the creating of tailoring an insurance policy is in a certain way reduced, so to say, by the fact that you can introduce caps or limits. So even this level of uncertainty can in some way be reduced from, I'm talking from the very point of view of the insurers which work on this side. But of course, the uncertainty of the legal landscape or complexity, maybe. Let's not use the word uncertainty, which maybe is not so liked, but the risk of the lack of a legal certainty can add to the insured risk a higher uncertainty element.
Thank you. I have the honor and the pleasure to moderate the last panel of our first day about space law, comparative visions in space law. I would like to start reminding the words President Mattarella said yesterday. He was inaugurating the academic year of Florence University, and he particularly spoke about space issues, and he remarked the importance of ensuring that space remains a collaborative realm of scientific knowledge in the face of attempts to make it a space of commercial intervention or commercial speculation, if not even, as some hints suggest, military competition. So, these words of President Mattarella push us to think about some fundamental questions, such as how to keep the outer space a collaborative and peaceful domain, while at the same time preserving national interests and safety. What balances are possible between specific interests of private players, the national interest, and the general interest of mankind? Which balance should our country and Europe pursue and support, also according to its constitutional values? And if we speak about Europe, according to its human rights charters, when speaking about long-term strategies in space. What should be what should be the European long-term approach to space according to the shared values of our constitution and of the European charters on the topic of human rights? Studies on geopolitics can somehow be considered as the balance of two different elements. One grounded on international politics, the other one on geography. Two poles, a complex synthesis between two poles. Space issues testify of the importance of a synthesis between these two poles, in the sense that both these approaches have something to say if one wishes to understand the maps of space power. The combination of diplomatic studies with the study of dislocation of industries, of natural resources, of natural barriers, of trade routes, of geographically suitable launch sites is an indispensable basis for understanding the mechanisms of access to space and thus for understanding the stakes of space law, the possible directions of development of the legal phenomena in space. This also in order to potentially be able to influence such directions of development in a humanist and peaceful direction, respectful of human rights, according to the mentioned principles of our constitution and of the European and international charters. So a lot of issues to speak about and a lot of possible and interesting interactions between geopolitics and law. So between international politics and geography and law. And now I would like to let our speakers present their papers. So the floor is yours. First of all, of Sebastiano Fulci, Ministro Plenipotenziario, who here speaks for the Italian Ministry of Foreign Affairs, which is, of course, the Ministry of Foreign Affairs is strongly involved and concerned by space issues and the interaction between the space law and geopolitics of space, of course, passes through and involves the point of view of institutions such as the Ministry of Foreign Affairs. The floor is yours.
Well, first of all, I'd like to commend the Vice Rector of Roma Tre University, Giorgio Resta, and the Director of the Law Department of this university, Antonio Carrata, for hosting this conference on common law in space. And I'd like also to congratulate very much Sirio Zolea, Alessandro De Nicola, and Cristina Frattone for organizing such an interesting international event. Doesn't happen very often to attend conferences that are in English in this city. So that's quite a nice effort that allows, I think, your faculty to open their horizons in cooperating with other universities abroad. So good work. I'd like to then talk about the dual-use nature of space technologies and the connected risks of weapons of mass destruction. So I will focus on space technology this time. And I thank you for giving me the opportunity to raise your awareness, or at least for some of you, reminding how space technologies, as well as their means of production, such as additive manufacturing, 3D printing, can nowadays be used as mean of delivery of weapons of mass destructions, WMD, both by terrorists or warrior states, dictatorships, and so on. So I will try in these following minutes to underline that some regulations do partially prevent dangerous space technologies proliferation, and that, as a matter of fact, I will develop this concept at the end, even universities with scientific faculties can play a relevant role to avoid that scientific discoveries, dangerous scientific discoveries, end up in the wrong hands. So, since the beginning of the space age, the development of rockets as space launch vehicles, known as SLVs, has posed dual-use dilemma. A dual-use dilemma, which is that the same technologies can be used for space exploration and can be also used to build delivery system of weapons of mass destruction. Well, both the US and the Soviet Union used ballistic missiles as initial rockets, from which they developed launch vehicles for sending their first satellites into orbit. Other states' SLV programs followed that path. That is why usually national space industries are strongly intertwined with aerospace defense industries. The technologies used in ballistic missiles, particularly in multi-stage intercontinental ballistic missiles, ICBMs, are virtually the same as those used in SLBs. However, that does not mean that an SLV can simply be used as an ICBM. Now, it is true that from a technical point of view, most components required for the SLV and the missiles are the same, apart from the payload and the warhead. But because of the difference in mission, in their trajectories, in their payloads, the performance characteristics of an SLV and a ballistic missile do differ, particularly in terms of required velocity, duration between rocket stage, and so on. So I'm sorry if I'm getting a bit technical, but still useful, I think, to understand, also with the late technological advancements, where we're going and the dangerousness of SLBs. So some of their technical and operational requirements may also differ because of their different missions. For example, a road mobile ballistic missile must be ready to launch quickly, must be robust enough to be launched in various conditions, which is not the case for SLVs, at least until lately. Because nowadays, small SLVs are being developed for lighter, smaller satellite payloads, use solid fuel rocket boosters, and have possibility of being road mobile to enable rapid responses, for instance, for satellite replacement and so on. So small SFVs are easily usable as efficient ballistic missiles. The difference of yesterday basically do not exist anymore. And the blurring, there is a blurring, therefore, of the traditional distinction between SLVs and ballistic missiles. So we can state that, unfortunately, the increasing dual-use nature of space technologies implies new proliferation risks. It's easier for proliferators to just acquire missiles, to acquire SLVs and therefore have missiles available. So no wonder that such transfers of FLVs are treated, should be treated with quite care and attention. States engage in illicit procurement activities. I'm talking about warrior states, usually by trying to conceal items of technical assistance destined for missile programs in order to circumvent export controls, sanctions. But what are the strategies that they adopt? It's interesting to look at them. They may mask the real end user of a transfer of SLV, hide a covert missile program, simply deny that they have missile activities. But they may also acquire relevant technologies, know-how, industrial capacities that could be repurposed to kickstart a missile program. Also, non-state actors in the space sector have increasingly engaged in manufacturing space technologies that pose proliferation risk. This is especially the case for the so-called new space companies. This was mentioned before by a previous speaker from Canada, Maria Lucas Rimbasel. But I'd like to try to give a definition to these new space companies. It's not always very clear what we're talking about. I would say that these are companies that are often startups, small startups, light, that have adopted a disruptive sectorial dynamic to make the space field more profit-driven and service-oriented. That's the definition I found, and I believe it's quite accurate. The emergence of these new space companies therefore means, in substance, a significant increase of private actors in the space sector, more states with space ambitions, with indigenous capacity, sometimes states run by dictators, and a wide variety of innovative dual-use space applications. Therefore, a totally new environment, space environment. Well, recently, for example, SpaceX developed the Falcon Heavy SLV. And many companies in various states are now developing, producing, and testing a wide range of similar small and micro launchers, such as the Rocket Labs Electron, the Orbex Prime rockets. Because of the similarities of these small and micro launchers with technologies used for intermediate and medium range missiles, warrior states and non-state actors can use that commercial space industry engaged in producing launchers to camouflage procurement and other activities linked to missile programs. So then you may ask yourself at this point, how and if such dangerous proliferation is being to some extent prevented? Well, the short answer is through legislation and law enforcement, I would say. And I can be a bit more specific to illustrate when this partial prevention activities from states started. Well, we have to go back to the adoption of the UN Resolution 1540 that asks states to adopt a series of measures aimed at preventing the proliferation of weapons of mass destruction, such as the adherence to regime systems. And in the case of space technology, the main regime referred to by Resolution 1540 is the Missile Technology Control Regime. Actually, we could also call it the Space Technology Control Regime nowadays, because missiles and SLBs are basically the same thing. So the MTCR was created in 1987, and it controls most of the technology. I mean, some of it is also controlled by export controls put in place by the Wassenaar arrangement. But the issue is that, well, not all the states are really caring about UN Resolution 1540. One may think, it's a UN resolution, all states should apply it or should make efforts. But the truth is that there are only 35 countries that are members of the MTCR. And some countries in the world do not even have national laws for adequate export controls. And actually, talking about only export controls is a bit reductive, because here we're talking about transfer control, transit control, transshipment controls, even ITT. By ITT, I mean intangible technology transfers. So because information can be transmitted in various ways, it doesn't necessarily mean that there has to be an object that needs to be exported. Technology can be exported in designs, and software can be exported through intangible ways. So the only positive thing is that these 35 countries do still represent most, I'd say a large part, not most, but large part of the producers and exporters countries. And well, the multilateral control regimes are intergovernmental organizations that give their member states indications regarding export conditions and limits, which each government undertakes to respect. Normally, this commitment becomes binding through the transposition of the regime guideline and control list, in this case, MTCR guidelines and control list, into national laws. But in the case of the European Union, its member states implement them through Regulation 821 of 2021. That's the most recent one, which is being updated at least once a year. And this guarantees a uniform application of regime guidelines and control lists throughout the European single market. And that's why it's so important. But as you can imagine, producers and exporters are sometimes quite annoyed by the regime restrictions. Although MTCR guidelines state that controls are not designed to impede national space programs or international cooperation, as long as such programs cannot contribute to delivery systems of weapons of mass destruction. Well, this reflects the aspiration of member states, of the certified member states, to limit the impact on peaceful space programs that need to, of course, progress and advance, while at the same time maintain their commitment towards their MTCR and the security of their nation, and recognizing the possibility that a transfer of foreign space program could contribute to a weapon of mass destruction delivery system. So that is why the role is quite important, because it has proven to be effective, by the way. The MTCR guidelines also lists the capabilities and the objective of the missile and space programs of the recipient states as one of the factors to be considered. That's quite a relevant one. So we look at which country the export is going to, what are the capabilities, and intelligence also help us understand what are the capabilities of that country that is destined to have these goods. I mean, they may declare them to be used for something else than the missiles. So, of course, intelligence has a paramount role in this case. Finally, the MTCR guidelines do not provide any general exception for transfer of items, but limited exceptions of technical nature. For instance, the MTCR Annex imposes control on SLVs that are Category 1 items, meaning by Category 1, I mean those that have to be forbidden, that cannot be exported to some countries, to the countries that are not member, basically, if they are capable of carrying at least 500 kilograms payload in a range of at least 300 kilometers, and if they include Category 1 subsystems. By Category 1 subsystem, I mean that they include individual rocket stage, re-entry vehicle, propulsion system, guidance system, and thrust vector control systems, and so on. Of course, there are all the other systems that the SLVs that range less than 300 kilometers, small SLVs, that, I mean, their control and as Category 2 items, which means that they are not subject to presumption of denials, but they have some licensing requirements that they have to stick to. So you can imagine the significant impact of space technology exports. Also the pressure that is put on the government, because we, on one side, this is a role of the Foreign Office, of the Foreign Ministry. Before it was the Ministry of Economy in Italy dealing with it. Well, we have to take into account both the security aspect and the interest of companies. And to tell you the truth, sometimes this is challenging, because the company that is unhappy because they really want to export an SLV to a country, they start, of course, complaining. They will go to court and say, yeah, we're gonna go bankrupt, and this is will be a huge damage, and so on and so forth. So I would even go as far as to say that maybe also the courts should be a bit more knowledgeable about what these export control regulations are. That would be helpful. But going back to what I was talking before, it is unfortunate that the new space companies, these small startups that are, made only a few people, often don't know about this regulation. I mean, at least they don't take them into account, and then they pay the consequences when they're seeing their exports forbidden. So the truth is that just like in the nuclear field, every of these new companies, tiny companies, sometimes not so tiny, should rely on an internal compliance program, so-called ICP, which is basically explains all about export controls and what it means, etc. And then at least one person knowledgeable on the topic that would actually be a point of reference for dialogue with the authorities, with the foreign ministry. So unfortunately, I can tell you it's not the case. And okay, maybe in Italy, it was mentioned there aren't that many new space companies, thank God. But I can imagine what a nightmare it must be in other countries when there are more, trying to make them understand that they're not, they forgot to follow some regulations. But sometimes export controls are actually not enough. So we have to try to think about means to complement export controls. So since we're here, I'm here among lawyers, I will just hint to one way to complement export control, which is the adoption of technological safeguard agreements. So in the nuclear field, the safeguard agreements are well known and they play a fundamental role. And now, why am I talking to you about technical safeguard agreements? Because, as you may know, there are nowadays a growing number of spaceports. This was mentioned in some of the presentations. And spaceports or other launching facilities are being established in various states, many states. And that is quite useful for those new space companies because they're tempted to, launch their products in this new spaceport in tiny states too. And therefore, signing such an agreement would allow emerging new space companies to use the spaceports abroad. And they are necessary because when you want to launch something in another country, something that is category 1, that is subject to strong presumptions of denial, as I talked before, well, you need specific export control authorizations. You need to give guarantees, and you need to have additional precautions. So establishing a bilateral TSA between the states where the launch service is located and that is providing the technology, and the one where the spaceport is, could guarantee such assurances. And so, it could help space companies to launch their products in other parts of the world. Up to now, only the US have signed such agreement with Brazil and New Zealand, establishing rules, of course, on limiting the access to launch vehicles, to payload, to flight data, and technical assistance data. And this is a model that is helpful. That's why I'm just mentioning it. Finally, I would like to go back to the ITT, the intangible technology transfer, because maybe I wasn't clear about what I meant. By that, I meant basically, I'm referring to emails and other means of transferring information that also can include scientific discoveries of research centers and universities that have scientific faculties. I'm sure some of you read on the press that all of a sudden North Korea has hypersonic glide vehicles. China too, and Russia. I'm pretty sure they got some intel from research centers abroad, in our Western countries. So it is important to realize that, unfortunately, the research scientific discoveries of universities that have scientific faculties can be stolen by, for instance, Syrian, Iranian, North Korean, Pakistan, and others students or professors or PhD professors that are in our universities. I'm not referring to this one because this one hasn't got a scientific faculty, so don't worry. It has, but I'm talking about like physics and chemistry, biology for other regimes. Anyways, it is something that should concern, according to me, the authorities of the faculties, at least, to say the least. So, like, the truth is, unfortunately, I would even go as far as saying that these regime control rules should apply to members of the academic community in the same way as they apply to business and other organizations involved in trade, which would mean basically have ICPs also in the faculties. It would mean screening the students that come, and at least do some awareness raising work with the students. Let them know that it's possible that research can be misused. Be careful to check what are the activities of some foreign students that come from the countries I mentioned before, and maybe others. Because these students can easily access to programs, to research activities, and then transfer the information to the foreign military interests, to their governments. The countries where they come from. So, in the regime, in the MTCR, we also discussed the idea that there should be some vetting of foreign students, and there are countries like the US, France, Germany, the UK and Netherlands have different system, but they do the vetting of students already in the phase when they do their visa application. So when they go to an embassy, let's say in Tehran, to the American embassy, and they say, okay, we want to go and have a visa for studying in the university so and so, American university so and so, the Americans check out, the profile of the person, and if there is a risk that that person may be a spying in their research activities, and so they block them. Now, guess what will happen to what will, not what will happen, but what these students that are refused by American, UK, German, French, Netherlands universities will do. Actually, there are also Chinese that are usually refused access to those universities. Well, to Italy, maybe other countries in Central Europe, and so on. And through those research connections, they will access activities done also in German, French, UK, and US. So, yeah, this is just to say that it is a concern, and I'm sorry if I've been too long, but I thought it would be important to raise this point, and I thank you for the opportunity you gave me to do that, dear Professor. So, thank you.
Thank you, Mr. Fulci, for introducing us to the worries on the dual use of some space technologies which might potentially be used as weapons of mass destruction. And from your intervention, I see the complexity of several layers of regulation: international law, European Union law, various internal sources of law, and there is, I see, a certain role of quite discretionary decisions, which are not perhaps always a priori predictable. So a certain complexity in where the enterprises may have some difficulties to orient themselves. It is really a topic of interest for us legal scholars because we legal scholars love complexity. So let us move to the next speaker, Ignazio Castellucci, who is associate professor at the University of Teramo. We know each other since the time I was teaching comparative law at Avezzano, which is a part of Teramo University, and now I'm glad to introduce you here in this context about space law, which I know is already your field of interest because you already wrote about space law in a recent publication. So it's your turn.
Thank you. Thank you very much. Good evening. Well, first of all, I have to express my gratitude to Sirio for inviting me here to this very nice conference, who by chance has been organized by someone whose name is Sirio, which is very appropriate. And of course, I have to thank the Roma 3 and the Department of Law. I'll be short, I'll try and be short, and well, I'll start explaining the title, The Dark Side of the Law. Obviously, it's nice, it sounds well. In this setting, I want to point at a couple of characteristics of the law in the space context, space law, which make it dark. First, the law has a dark side because does something, performs a function that we are not trained to associate with the idea of law. At least us Western lawyers normally have not been trained to think that the law can serve a political or strategic or military purpose. So there is a hidden facet of the law which I think it's interesting to explore. And another way, and another reason why there is a dark side of the law is it's more closely associated to the fact of state law, which is what we think when we think about the law mostly, it's relatively unseen currently in the space environment because there is still a lack of comprehensive sets of legislations worldwide in the different jurisdictions, except a few notable examples we have heard about this morning. I want to start with Professor Li Jujian. This morning he mentioned that making law about space is difficult. And to explain why China doesn't have a space law, a comprehensive legislative framework for space activities, he mentioned the difficulty of the legislative process. This could be, but we may also consider that it's not difficult to set a legislative process in motion if you have a political will to legislate, especially not for China. So probably the difficulty is a difficulty of a different type. Maria also explained that in Canada, there's not too much space law because you don't want to do it too early, basically. And probably this is one of the reasons why the space law can be considered dark. Because space, I use simple words just to make myself understood and because of time. But space is and will be for quite long a highly securitized environment. Maria concluded her presentation mentioning it's a highly militarized environment, which is true. And it's a can I say place? Well, it's somewhere where human activities occur in self-contained bubbles, fluctuating, so to speak, or traveling or existing in a wild, hostile environment, which is legally a vacuum. And at the same time, there is a growing competition of planet Earth actors wishing to get involved in those activities with a view to taking advantage of the big benefits that should come. So it's clearly politically sensitive. And if I take the conference leaflet and I check at the titles of the presentations in this panel number 4, you see that all the keywords of each and every one of the relations are related to conflict. Ambassador Fulci, weapons. Rafael Moro Aguilar, security. David Burrigana, diplomacy. General Cipelletti, defense. And myself, dark, which is because we don't normally associate law with making war or making conflict. Plus, we have tomorrow a couple of other presentations like hybrid warfare and cyber operation. So this is probably why we don't have that much regular legislation around on these matters. Law is an element of the conduct of conflict or competition between political, economic actors competing to gain advantage, to expand in this new environment. So it's probably too early to establish a rule of law environment. And Professor Li Jujian has been illuminating this morning, reproposing through his C model of constitution, basic rules of law and administrative action, what is the classic model of socialist ruled by law governance. So whoever is in charge doesn't want to be bound by too many legal rules because there is too much uncertainty. You cannot go and create firm rules which you still don't know whether they could be workable or useful or give advantage to you rather than disadvantages. So there are unique challenges there of all sorts and all with high political relevance. I go back to the Article 3 of the Outer Space Treaty and Weapons of Mass Destruction. If you put this term in the space environment, what is mass? it's very clear what is a weapon capable of delivering mass destruction on planet Earth somewhere else. But would sinking a spaceship, so to speak, amount to mass destruction? And what would be the difference between military activity in the outer space and police activity in the outer space? Because since day one, when you start having enterprises, corporations going back and forth, going around, you will need police. Because at some point, there could be competing powers, perhaps not signatories of any treaty, having a different political agenda, considering those merchant ships, enemy ships. And then you need to do, again, what has been done for centuries, escort convoys with space frigates to provide security. Would that be police? Would that be military? Would that be prohibited? An interesting parallel would be what happened in the Indian Ocean about 10 or 12 years ago, probably, with Operation Atalanta and Task Force 151, providing security against Somali pirates. Well, it's becoming relevant again in the Red Sea now, but those military assets from worldwide were arranged together to provide an activity which was not just the usual patrol, intelligence, escort activity to ships along the sea lanes, but also doing police activity, law enforcement, making something hybrid, which clearly needs to be regulated. So it's really difficult to imagine that the space environment will be regulated anytime soon. For a very long time, will be an environment like populated by more or less like Antarctica, by small communities of scientists and military personnel, basically. It will take long before that environment becomes, so to speak, desecuritized. Like perhaps in 100 years, a human community under a glass dome on Mars or on the moon, and then you will have some local rule of law style interaction, a human community, a civil society, a commercial insurance as well. Where is Diana? Yeah. Because at present, everything is new, everything is risky and costly and sensitive. So it needs to be conducted by major players with a political agenda and probably with their champions, big powers with their national industries, with their national insurance players, working together to develop the environment, to contribute expertise, to put together all the knowledge which is needed to develop the scramble to the space before there can be anything like a jurisdictionalized environment in the space. It's more like maritime law, the way maritime law developed in the high seas through the centuries. So you have those small communities going around. They seldom get in contact. You need to develop some rules, of course, but in principle, the environment is still very fragmented and will remain as such for a long time. How can you inspect space facilities to determine whether there are weapons of mass destruction being transported or developed? How can you make an unannounced on-site inspection on the moon? Or how could you make the inspection on planet Earth claiming it's associated with space activities? And then the hosting state would oppose all sort of barrage fire against inspection because it's violating sovereignty, classified information, blah, blah, blah. So clearly, there will be very little law, and at the same time, a small development of a large community of very professional, highly professionalized entities or individual states, public or private ones, developing slowly that environment. And that comes to the other facets of the law and why it's dark, because it's unseen, because it's still difficult to see the law emerging from that. But it's a complex, it's already a complex normative ecosystem made of many smaller ecosystems competing, working together, most of the times being indifferent to one another, but sometimes getting in contact, interacting, cooperating, developing frictions or conflicts. So the new environment is really something that classic international law cannot handle. International law as we know it, as we have been trained to understand in the university. It's a lot of different sources competing, whether public or private, international, state, the EU, and then a lot of private laws, private corporation laws, lex mercatoria, new transnational law of all sorts, as Chiara Malaguti mentioned this morning, and all sort of legal mechanisms taken from a number of sources have to be put together at work to make sense of the complexity and also to solve actual issues whenever they arise. So it would mostly be, I would say, place populated in legal terms of public and private mechanisms working together, as probably as it was the case in the early existence of the East India in this company, as Maria mentioned this morning, or Antonia, sorry, Antonia. And how can a lawyer make sense of this? Well, I'm a comparative lawyer. I know nobody's perfect, but yeah, but we have been told a few things. We have instruments we can try to use to make sense of this complexity. Not necessarily to develop a unique theory of space law. It's probably too early, and probably we don't need that. That would be probably misleading as well. But some theories could come and support us. For instance, like the old theories on legal pluralism that have been used in the 1950s or 60s, mostly from legal anthropologists to study the laws, the customary laws, and the interaction of different laws in developing countries, for instance. There you also had that complexity of many different legal systems coexisting on the same territory at the same time over a number of human communities which live together, and with many actors of those communities being part at the same time of more than one of those normative orders. And then we have theories there. Starting from Santi Romano, which is more than 100 years old, explaining that wherever you have an organized community, you have law. And then probably the reading of George Simmel, which is even older, making clear that whenever the reach of any normative system corresponds with the geographic space where the members of that community are located, or where their interests are actually regulated by those norms. And combining this with legal pluralism, and I think, for instance, of the famous article of Sally Falk Moore of 1973 of semi-autonomous legal fields, that would be useful to understand, to explain what's going on, and probably to produce, through careful observation, an accurate picture, not of the law, but of the dynamics at work producing new rules. And this would help the lawyers helping others involved in space activities, producing helpful legal assessments of the situations, perhaps solutions in some cases. So I think I'm almost finished. I will make my conclusive submission. Law and the different laws of the world are tools of geopolitical expansion, just like military power, just like the economy, just like diplomatic power. Northern American senior officers in the last 15 years have started learning this when they do national security courses at the War College. And they know well that there are elements of state power which now doctrinally in their handbooks include the legal power of the state, because the law has a enormous potential of reaching everywhere, wherever there is any human activity. So it's important to understand this function of the law also as a tool of power, not just to regulate property, family, criminal law, as we have been trained to think. And at the same time, the legal environment of space activities will be very, very complex. So clearly, no rule of law should emerge anytime soon, in my opinion. And lawyers needed for that brave new world will need to be highly skilled, and especially they need to be flexible, able to master complexity. So conversant with different types of legal systems. So we need comparative lawyers there, legal philosophers, legal anthropologists, legal historians, in addition to classic domestic lawyers and international lawyers. I'll stop there. Thank you.
Thank you so much, Ignazio. I will be particularly interested when I will read your paper, where I found two particularly suggesting points. One is the final idea of the role of the lawyers in the space society. And I find a strong complementarity between your intervention and your recent paper I read about the institutions of extraterrestrial liberty. So a fascinating dialectic relation between such two concepts, extraterrestrial liberty, so liberty in the future human space society, and the dark side of space law. And the rules could help harmony or could help create conflicts, depending on how wise, how balanced they are. So the need of combination of models, the need of combining international treaties with other approaches, hard law with soft law, harmonization of law, is probably in a complex world with geopolitical tense and complex relationships, maybe there is not just a simple solution, we can do this. But what is important is the idea, the need of synthesis among various different interests, the need of new paths which also include international treaties, but probably not only international treaties, and take in account, I think, again, such to pose the extraterrestrial liberty and also the terrestrial liberty as the development of the space society, first of all, changes, is susceptible to change our terrestrial society. And on the other side, the dark side of space law, and we hope that the future of space and the future of space law will remain in the path of the bright side of space law, which is the path of scientific exploration, of exploitation in the common interest of humankind. So, created it, and now let us move to the next intervention. Let me introduce Professor Rafael Moro Aguilar, who is adjunct professor of international law at Florida International University in Miami. He's also member of the board of the Spanish Association of Aeronautical and Space Law, and he's also a member of the International Institute of Space Law. Professor Moro Aguilar, do you hear me?
Yes, perfectly. Can you hear me? Can you hear me?
Yes. Would you prefer to share your slides, or you prefer if we share them?
I will try to share them on my side. Only if it doesn't work, then I will kindly ask you to to do it on your side. But I wanted to wish buonasera to everyone, good evening to everyone. I'm sorry not to be able to be today in Rome, such a wonderful city, but I could not travel, unfortunately I could not travel overseas this week. But I want to thank very much the organizers of the conference, the University of Roma Tre, and Professor and researcher Sirio Solea for inviting me to participate. So, do you see the presentation on your screen?
Yes, we see.
Perfect. Okay. So after Professor Castellucci enlightened us on the dark side of the law, I think it would be my task to try to show the bright side of the law, what the law has actually done so far, and what it can be doing in the next few years, or the latest trends. So my talk is on the actual law applying to security aspects in outer space. And the fundamental rule, when we're talking about international space law, is the 1967 Outer Space Treaty. This is the most important international legal text that applies to space activities. This is a set of guiding principles that provides a basic regulatory framework for all space activities carried out by all states of the world. That's why it is called sometimes the Carta Magna of outer space. The treaty was negotiated in Copios in 1966, mainly between the United States and the Soviet Union, which were the two space powers of the time. It was adopted by the General Assembly of the United Nations in December of that year, and it is in force since October 1967. So today it has 112 states parties. The Outer Space Treaty was first and foremost a disarmament treaty. It is an arms control agreement. It built on the precedents of the Antarctic Treaty, which saw the first ever collaboration of the United States and the Soviet Union during the Cold War, and which managed to demilitarize Antarctica. And it also took as another precedent, another important precedent, the 1963 Nuclear Test Ban Treaty, which banned nuclear tests in the atmosphere and in outer space. The initial purpose, at least for some people, for some scholars, in this area was the same as in Antarctica, to demilitarize completely outer space. That could not be achieved. It only achieved this goal partially. Why? Because national security implications are too strong, were already too strong and too obvious in the case of outer space. Particularly reconnaissance for spying purposes, or military reconnaissance, let's leave it at that. It is illegal if you are intruding in foreign airspace, but it was clear from the beginning that it was going to be admitted when done from outer space. That was the reason that was the basis of the open skies policy followed by the Eisenhower administration, the US administration at the time. What are the provisions in the article in the Outer Space Treaty that apply to security aspects? Most importantly, Articles 3 and 4. Article 3, application of international law in outer space. International law is applicable to all activities conducted in outer space. Activities have to be carried out by states in accordance with international law. And in particular, the United Nations Charter is mentioned. So in particular, the UN Charter is applicable in outer space. This means that prohibition of armed conflict and prohibition of aggression applies in outer space. Article 2.4 of the UN Charter. The right of self-defense also applies in outer space. Article 51 of the UN Charter. Arguably, international humanitarian law, also known as the laws of war, would also apply in space thanks to this. It is not a wholesale application of all of international law in outer space, but at least the basic rules, and certainly the rules that were already enforced by the time the Outer Space Treaty was adopted, would apply in outer space. And the Geneva Conventions, the laws of war, were certainly already enforced by then. Then we have Article 4, which is the one that most specifically addresses military and security issues. According to Article 4, moon and celestial bodies are totally demilitarized. Placing atomic weapons and other weapons of mass destruction anywhere in outer space is expressly prohibited. But, and here again we find this only partial demilitarization. Conventional weapons are not forbidden. And most importantly, military activities of a defensive nature are allowed in terrestrial orbits. The term defensive is subject to interpretation, but it is usually understood to mean non-aggressive purposes. So as long as there is no aggression, any use of space will be peaceful. And this is the doctrine in many countries, particularly expressed repeatedly by the United States government in their national space policy. How do Articles 3 and 4 apply in practice? Reconnaissance satellites and all other military satellites and activities in the near Earth orbits are allowed, provided that the activities are implemented in a manner that is compatible with international law and with the Charter of the United Nations, meaning non-aggression and self-defense only. This includes, in principle, not only reconnaissance and support to the military activities on the ground, but also several activities that are controversial, but that still have been experimented in outer space for apparently defensive purposes. One would be the development of anti-ballistic missile technologies. Another one would be the displacement and removal of satellites. And finally, the conduct of anti-satellite tests, which is perhaps the most controversial one, and I will devote some more time to ASAT tests. I will focus on ASAT tests. But let me first examine one last provision that would apply in this area. Article 9. This is not a provision that is usually associated with military and security activities in space. Article 9 provides for due regard, non-interference, duty of consultation among states parties to the outer space treaties. This is more usually or readily connected to the principles of cooperation and mutual assistance between states, and also to the idea of preventing the contamination of outer space. However, Article 9 is a substantive provision of the Outer Space Treaty, and it is equally applicable to all outer space activities, including military activities conducted in outer space. And this article is particularly relevant for activities that have the potential to interfere with the activities of others and to affect the outer space environment in general. And this is most notably the case with anti-satellite tests. Anti-satellite tests means conducting a test of a direct ascent anti-satellite weapon, usually a missile, or another type of projectile on a kinetic impact in order to destroy a satellite. Both the United States and the Soviet Union conducted several such tests until they stopped due to concern for the amount of space debris that was being created. Then China conducted, after a couple of decades without any tests, China conducted a particularly harmful one in January 2007. Things again stayed quiet for a while, and then India conducted another test in March 2019. Was conducted by Russia in November 2021. To prove that you are able, you have the capability to do such a difficult, complicated test, of course, gives you some kind of dark prestige, right? It allows entry in an exclusive military space power club. Note, of course, that this test always targets your own satellites. If the state were to conduct a test against the satellite of another state, this would be considered an act of aggression. It could even lead to war, or to at least to an open conflict. But even if it is your own satellite, these tests are very concerning, as they pose a threat to the outer space environment and to the safety of all other satellites. How would Article 9 apply to military activities and in particular to these ASAT tests? Article 9 establishes several obligations that are usually interpreted as limits to the freedom of exploration and use of outer space that is contained in Article 1 of the Outer Space Treaty. One of these obligations is the duty of due regard. While in outer space, states must take into account the legal rights and the corresponding interests of other states parties in their peaceful exploration and use of outer space. If necessary, states must adopt appropriate measures. Then there is a duty of non-interference. States may not obstruct with their activities the free use of outer space that is being carried out by other states. Then it also imposes a duty of consultation. Article 9 also obligates each state party to consult with others if one has reason to believe that an activity or experiment planned by it or by its nationals, by that state or its nationals in outer space, could cause potentially harmful interference with the activities of other states parties. Or if such interference is already happening, then again there is a duty of consultation. If there is an ongoing or a potential interference between two space activities, states must enter into consultations in order to find a solution. Well, an anti-satellite test is an obvious case of harmful interference in the activities of other states and other space of actors and operators. Each test creates tons of new debris that can endanger the space infrastructure. They put in danger private and public space activities alike, especially the presence of astronauts and satellites located in low Earth orbit. They are those orbits that are closer to the Earth. But as a test, as an activity conducted in outer space by states, would it be subject to the requirements of Article 9? You would think that it is, right? It seems so. The problem we find here is that the language of Article 9 is quite vague or ambiguous. Terms are not defined. What is a potentially harmful interference? What are appropriate measures? Even the concept of due regard is not exactly or precisely defined anywhere in the treaty or in any other of the other space treaties. The consultations, the way they have to be conducted, this is again not determined. The way states must implement the consultations and the desired outcome of these consultations, none of this is addressed in the Outer Space Treaty. In addition, if we look for state practice so far in terms of consultations, coming from Article 9 of the Outer Space Treaty, we find that there has been none. As a result, it does not seem that this obligation is being required from states under customary international law. Unlike other provisions of the Outer Space Treaty, which are recognized now to have become also customary law, Article 9 is probably not. It is not the case for Article 9. Article 9 allows states a wide margin of appreciation to determine whether or not their activities or experiments are so potentially harmful that they must trigger consultations. It is hard to think of a more destructive, short of destroying another one's satellite, it is short of thinking of a more destructive and a more harmful interference event than an ASAT test in outer space, but because it creates thousands of new pieces of space debris, which, as already noted, are dangerous to everyone's activities in outer space. It is impossible to ignore that fact when you are planning on conducting an ASAT test. And so any state that has conducted one of these tests should have had reason to believe that they would cause harmful interference with the interest of the other states parties to the Outer Space Treaty. But still, states have never engaged in consultations prior to conducting one of these tests. Neither the states conducting the tests have initiated them or other states have requested them. So again, it seems that this is not become customary law. In particular, there was no invocation of Article 9 ever during the Cold War time, when both the Soviet Union and the United States undertook ASAT activities. When China conducted its ASAT test in 2007, at least one country, Japan, declared that China had violated Article 9 with this debris creating explosion. But this has been about the only case we can find where Article 9 has been invoked. And never have, as I noted already, never have international consultations under Article 9 actually taken place. If you look at the graphs here, this distribution of space debris in altitude according to altitude, different altitudes around the Earth, also on the surface of the Earth. And you see that the left peak comes from the Russian ASAT test in 2021, while the right peak comes from the Chinese test in 2007. And here you have the ballistic missile that was used by India for its 2019 test. As already noted by previous speakers, we have the problem of dual use of technology. The same technology that allows us to launch peacefully satellites into outer space can also be used for missiles and for aggressive purposes. What are the international efforts to limit the militarization of outer space? Well, one of them we already mentioned, the 1963 Moscow Nuclear Test Ban Treaty prohibited conducting nuclear tests in outer space, and this has been followed so far. In the Conference of Disarmament, China and Russia promoted in 2007 a draft treaty on the prevention of the placement of weapons in outer space and the threat or use of force against outer space objects. However, the United States rejected this initiative due to the unsatisfactory means of verification that had been proposed. Then we have the initiative of the European Union undertook. The EU proposed a draft international code of conduct for outer space activities in 2014, but this again did not obtain the required level of support from other states. And the initiative got kind of frozen as a result. The UN General Assembly regularly adopts resolutions encouraging states to make political commitments not to be the first to place weapons in outer space. And the Conference of Disarmament also plays a role with the so-called Prevention of an Arms Race in Outer Space, its PAROS initiative. In terms of ASAT tests, we have some rules. They are non-binding, but at least we already have something. The 2007 United Nations Guidelines on Space Debris Reduction include a guideline against the creation of debris by means of the deliberate destruction of space objects. And this has been followed by all states, including China, which was the last one before 2007, with the exceptions of India and Russia, the only violators of that rule since 2007. But at least India made a genuine effort to avoid creating debris with their ASAT test, and They do so by choosing a low altitude target satellite. Then more recently, we have the initiative of the United States. In 2022, the US Vice President declared that the US commits not to conduct any more destructive direct ascent anti-satellite missile testing. Other countries since then have joined this pledge, and a similar pledge was included in a recent Group of 7 statement. The latest rule we can find in this area would be this General Assembly resolution, also adopted in December 2022 by a vote of 155 states in favor to 9 against, that calls upon all states to commit not to conduct destructive direct ascent anti-satellite missile tests. And the picture on the right shows you which countries voted in favor of doing so, of this sort of moratorium of new ASAT tests, and which countries voted against. And with this, I conclude. I thank you for your attention, and I'll be happy to engage in dialogue and ask and respond to any questions that you may have. Thank you very much for your attention.
Thank you, Professor Mauro Aguilar. Of course, we are honored by the presence online of another prominent expert of space law. Among the many interesting things you said, one I would like to pinpoint is the importance of the provision in Article 3 of the Outer Space Treaty concerning the applicability of the United Nations Charter in space. It is interesting, of course, in the context of your exposition, but I think it is very interesting that you remarked it also, also in a broader sense, because it also reminds and is complementary with other interventions we heard today, for example, from Professor Benvenuti about human rights in space, from Professor Castellucci about extraterrestrial liberty. It is a provision not so often mentioned of the space treaties, but in the perspective of the construction of a future human space society, this point is particularly important, somehow giving an indication about the direction towards which this space society could be oriented. At least the idea that the provisions, the fundamental provisions of the Charter of the United Nations also concern humankind in space. Now, let me introduce Professor David Busigana, who is associated professor at Padova University, and he's professor of history of international relations. And I'm particularly glad to welcome another professor who is not a lawyer, who is not from the legal field, but which helps us to pinpoint the complementarities of space law, space society, space issues, and law and geopolitics in space.
Okay, thanks so much for this invitation. I'm sure. Please let me play the role of a red fish, and please don't play the role you of a shark, because I am not a specialist of law. But frankly speaking, thanks so much. This conference is very interesting. This is not a simple diplomatic sentence. And I hope that we will arrive to launch the slides. But anyway, some words to present me. I am an historian of international relations. I'm interested in the evolution of the international context. I came in from the political science. Okay.
I'm very, very sorry. I'm very, very sorry to interrupt. This is just for Professor Mauro Aguilar. If you can stop sharing the slides so we can focus the camera on the current speaker. Thank you so much. I'm sorry.
Okay, we are lucky because if we were in this space now, we were dead, no? In space, we have no limits, no possibility for mistake. Anyway, okay, thanks. As you may see, I came from political science, but I am teaching also in the Department of Electronics Engineering of Information because I have a course about microelectronics and geopolitics. I, as a member of the steering committee of CISAS, the Center of Space Activities of my university, Padua, is at 15-17 place in the world for space activities, named from Bepi Colombo. I was in charge of several research projects because research need money as a space. And I think also, okay, not only for mining in space. Last but not least, we will launch a new platform, Space Diplomacy Point Italy. Then, the next slide. I am interested to the interconnection between science, technology, and foreign policy. In my research, the key point is the relationship between expert and stakeholders, or better, not stakeholders, expert as advisor and political decision makers, ministry, governments, and parliament. You have here Sally Zuckerman. This is the prototype of scientific advisors in 1960s of UK government, which was the problem sustained by cabinet minister Richard Crossman. Okay, it's impossible. We have no time to try to understand technoscience files. This is our problems, dear Sally. Sally reply, no, you don't use time. You have no time, you don't desire to use your time to try to understand. In my opinion, this is not only an historical case, this is also the case for present time, and above all, today. I am sorry, I don't speak about geopolitics. You had spoken since the morning about geopolitics. But we need diplomacy too. Diplomacy also during very critical moment. This is a very famous event of docking 1975 during Cold War. Frankly speaking, this is not the best example of techno-science cooperation. Frankly speaking, this was above all propaganda, political maneuvers during Nixon and then Carter administration in one side, and the other side we have the detente period. But anyway, the might resisted up today. I invite you to see this movie, Valérien et la Cité des Mille Planètes by Luc Besson, inspired by comic strips 1968. We have no time to see the first imaging of these movies, but this starts with this very positive way of space. The end is catastrophic. It's the dark side of law for space. But diplomacy is very useful also for some little minor country in the world. Very famous from space, thanks to his image. My country, Italy. Italy was a real little minor country after the Second World War. Also today is a middle country. Okay, it was not a superpower. Italy is not a superpower also today. But in this time, we arrived to have an agreement and to launch our space program thanks to several personalities. First of all, the Air Force officer Luigi Broglio, who stay in touch with the US and Italy. Je suis très désolé, mais l'Italie et moi, maintenant je parle en français pour notre professeur canadienne, l'Italie, c'était le troisième pays à lancer un satellite. Mais avec a missile, thanks to a US missile, but all operation was managed by Italian engineers. Change the satellite and to control the launch. Why? Because this was the condition of Italian government to learn how to launch a missile with a satellite. Then it's sure you have after Sputnik, Explorer, UK Ariel, and Canadian Alouette 1. But frankly speaking, for me, this is not important. I am not here to give medals to left and right, no? I am here to underline the role of politicians. We have no time to explain, but you have here the fathers of Italian republics, no? Coming from, above all, Catholic democracy, but not only from this party. This is only to underline the relevance role of politicians in our stories, and not only of politicians. February 1980, in Taormina, in Sicily, we have a very secret meeting with two, or better, one Italian astronomers, another Ludwig Voltier, the president of the European Southern Observatory, a diplomat, Umberto Vattani, a minister, Vito Scalia, and inspired also by Franco Pacini. The mission was the entry of Italy in the European Space Observatory. This was very, very important because Italy was able to participate, not only to spend money, but to participate to the development of these two very important telescopes. This is only to say that also in this case, we have a complex of actors in our story. Not only lawyers, not only scientists, not only diplomats, but above all, also the politicians. And behind this, you have a national interest. The Italian development of technoscience in astronomy is not a bad word. I'm sorry, it's not horse shit to say this. National interest. Whole countries have their national interest. And we have also other stories linked to Italian space development. One of these is the Italian participation. You have here Minister Granelli, November 1983, to the launch of Space Lab. Italy was a partner in this European operation, not US European operation, a very important part. And this was important, as you know, but I have, as you know, for the development of US-Italian modules, and today for the Italian capabilities to participate in Artemis operation. But this is only a little field of the story. No? Space has several fields, and also Italy has several capabilities in this story. But in this case, it's interesting to underline the role of political advisor. You have here Giampiero Puppi, physicist, but above all, advisor of several Italian ministers of science and research. For you, it's clear, it's evident. But this is to underline that when I explain the history of Italian foreign policy, for me, this is a relevant part in order to underline that you have not only Italian government, Italian ministry or diplomats, you have several experts in these stories, like you. We have no more Professor Marchisio, but Professor Marchisio is an historical witness of Italian space policy, not only of international laws, space laws. This is very important. You have also several advisors. And now I suggest you let me make a little joke and we go in the real Polar Night 2 weeks ago. You have here some infrastructure, not too easy to see. You have here this is antenna, and we are in Svalbard Islands. Why to put this image? This is a reality of geopolitics. Why space is a mirror of the present geopolitical situation. Because please, only for one moment, try to be not a Chinese citizen, but a Chinese expert. And why China must be obliged to be led by USA in space race? I have my answer for this, sure, because I am in Italy, I'm Italian citizens, European citizens, Western citizens. But this is only to underline that, above all, today, we are in a very geopolitical, difficult situation. And space is a sort of mirror of this situation. And this infrastructure is only one example, created, the beginning is 1966 by NASA and Norway. Today, you know very well, I think, that this is not a simple private company, because it's also private, with a share of USA and Norway. It's not only a simple company to receive data. This is the hub of a very important network at global level to receive and to transform data satellite in the best position on the Earth for this. 17 north. I was there 2 weeks ago. Very strange mission paid by Norway government, anyway, not by Italian. Then, but which would be, in my opinion, and as an historian, one of the best example of international cooperation in space, of a space diplomacy. This one, Halle Armada. I was young in March 1986, but not because this is based on US and Soviet cooperation, no. The very important result, and in this case for all mankind, was possible thanks to ESA mission Giotto. Why? Because these little probes arrived at less than 500 kilometers thanks to several data obtained by 4 other probes, 2 Japanese and 2 Soviet. But in Vega 1 and Vega 2, the 2 Soviet, we had also the French and Western Germany participation. Last but not least, the only place to calculate data was in Pasadena, California, the Jet Propulsion Laboratory. You have a real international cooperation, no? With our students, we present this example in order to underline that this may be the real space diplomacy for all mankind. Because I am sorry, when Sputnik was launched, Gagarin was launched, Explorer was launched, when also today our officer Villaday is in the International Space Station, I am sorry, it's not for all mankind. You have behind always international cooperation, yes, but also national interest. This is very important to have in mind, and to have in mind that we must to dialogue. Otherwise, as Bepi Colombo said in September 1981 in Padua University during a meeting with all space agencies interested in Halley Comet, including Soviets, this is the alternative, war, the clash between nations. We must dialogue. I am sorry, but diplomacy is not a tool for war. Diplomacy is a tool for the mediation of tensions. I don't know you, but I was obliged to not to dialogue, to make real diplomatic negotiations with my wife, with my son and my daughter, to stay here tonight, and above all, in the last week, to stay not in holiday in North Pole, but to work. This was very, very problematic. Diplomacy is to solve tensions. This is very important because we arrived from different point of view. I repeat, if I would be a Chinese expert, I want to see China on the moon. And if I arrive with this by using BRICS system, perhaps I agree, okay. And in the other way, if I was and I am a Western citizen, I must to deal with the fact that Artemis agreements are not multilateral agreements. They are bilateral agreements, USA with each country. It's correct or not? No, okay, but from the law point of view, you have one agreement. The agreement was signed, for instance, with the European Union, with the European Space Agency, or with each countries. But I agree with this because I understand, I think, to be able to understand the national interests of USA, and at the same moment, as in the past, I try to understand the national history, the national interest of our country, of my country, Italy. And Italy has a member state of European Space Agency, but also of the European Union. This is only to say that space now is a very nice example, I think, as a mirror to understand the evolution of international system and why I thank Sirio for this conference, but also I am obliged to thank also Roma 3 for the idea to launch an international center about space law, because we must to speak about this question not only among us, but also to public opinion. This is the reason why in Padua we organize, and you have on YouTube this very nice a theater play on about Bepi Colombo. Bepi Colombo, we have also some comic scripts, has an international scientist, not a diplomat scientist. You have diplomats and scientists, but scientists who is aware of the need, of the necessity of the international dimension of the research. Why? To try to have a continuous dialogue to negotiate the mediation of national interest. This is, I'm sorry, the idea of my country for global challenges, because sure, my country is not a superpower, no? But we have an history of diplomacy to try to solve our problems, European problems, and also to have in mind to search to participate to several global challenges. We have not only climate change, now we have several wars, several tensions, several economic problems. We must to solve this problem. And we must to share our idea, and I finish with this last advertising announcement. In Padua, we launched a special school on science diplomacy, starting from documents, history, oral history, the witness with the several witnesses coming not only from Italy, scientists, diplomats, politicians, also lawyers. Because the idea is to try also to share, to organize several schools about this, because our PhD students must not be convinced. They must participate in these reflections, and not only from political science, from law, but above all for STEM, science and technology disciplines. Another example, and I finish with this, in Erice, in the center created by Antonino Zichichi in 1963 for the dialogue between the scientists coming from East and West, we will launch another school on science and diplomacy in cooperation with 3 other universities, with the Italian CNR and with the Italian Center for Defense High Studies. Because, and I finish really now, I'm sorry, not only space, but also space, this is 4 dimension of human exploration after Earth, sea and air, is a place of security issues, defense, dual use. This is very, very clear. Thanks so much for your patience.
Thank you so much, David. Thanks particularly for highlighting the importance and the successes of the Italian mixed economy model in space. It is important to remember it. The presence of a web of private actors and of a centralized planification of investment through public or mixed public and private enterprises, which is one of the columns or one of the grounds of the Italian models of a mixed economy which existed in several sectors and which somehow partially still exists in the space sector. Another column, another ground was the attitude toward dialogue. Italy being a country within a certain geopolitical bloc, but with the attitude, with the capacity, with the ability to be in a relationship of dialogue also with other countries, with other powers, with other space powers. So the attitude towards dialogue is particularly important for the geopolitical projection of our country. I think that space is one of the fields where this model partially remains an important virtuous relationship between public and private. The presence of Thales Alenia Space today here is to help us remember it, and we should ask ourselves whether there is a European model different, of course, from the Chinese model, but perhaps also different from the United States model. Is there in a different within a different system of economy, in a different system of legal cultures, is it possible to conceive to still conceive the fact that in Europe we have a different, a peculiar, a particular, with its own strengths, a particular, different system of space policy and of space governance? Perhaps we should openly recognize it. We should affirm it. We should remember from where we come. We should remember the importance and the successes of that mixed economy model. We were speaking about Italy, but we could say the same about France, for example. And we should know that in the space context of today, there is an important role for private actors. We should also support our European private actors, but probably or perhaps a certain role for public initiative in coordinating, in deciding the strategic priorities is still important and still characterizes a certain European approaches that could be the key to a long-term success of Europe in space, perhaps. So let us move to our last speaker, who is General Davide Cipelletti of the Space Policy Office of the Italian Defense General Staff. We are speaking about geopolitics, so it will be particularly interesting to hear the last intervention, the point of view of the Italian Defense General Staff about the Italian defense space strategy. Thank you for your presence, General Cipelletti.
Thank you. Good evening to everybody. And let me start by saying thank you to Roma Tre University, the law department, and the organizer for inviting me to such an interesting event. It's quite a challenge to be the last one standing between you and a nice evening in Rome. So hopefully I'll be brief, but I will give you just some ideas on how about the Italian defense is looking at the space as an operational domain and what are the challenges we face, starting from the lack of law and the dark side of the space law, which is something we really feel as a need in order to fulfill our mission, and what we are in place of doing in order to fulfill our mission in space. It has been mentioned by Professor Diana, and I definitely do agree that Italy is not a superpower. But when we talk about space, apart from superpowers, I would say that Italy is not second to many other nations. We have a history, we have our heritage, which has been mentioned before. We have a very big industrial capacity to reach space, to produce satellites, to produce vectors to reach space, and all other assets that are in my slide. So that's a very good starting point also for the Italian defense, always to keep in mind. We put the first European astronaut, which was Commander Guidoni, on the ISS. ISS that today is made up by 40% of the modules produced in Italy. As a military, not superpower, but power, we are the second country in Europe as far as the number of operational satellites we are employing nowadays. And we are also the first provider to NATO for SATCOM communications from space, with the full autonomous capacity of the defense to operate our satellites. With that in mind, of course, we started out in the recent past seeing space as what we call an enabling domain. So space was a domain which was providing services in order to enable the operations in the standard domains. Of course, we're talking about land, maritime, and aerospatial domain. Italy is capable and was capable in the past to provide us our assets with ISR capacities, SATCOM capacities, precision navigation and timing capacities, and also some meteorological weather forecasting capacity. We do not have missile warning capacity or nuclear detonation detection capacity. And of course, we are provided with this kind of capacities by international agreements with our allies. But from the enabling domain, we moved on to space as an operational domain. Space has been nominated an operational domain by NATO, and Italy, of course, is following the same path as NATO, understanding that if not today, most likely tomorrow, somebody will try to fight in space. And I remember that we started out this very interesting panel with the quote from our President of the Republic, hoping that space remains a place for scientific endeavors rather than competition. And I would quote the Latin motto, "Si vis pacem para bellum." If you want to keep in pace, be ready for war. That's the meaning of the sentences by our Minister of Defense and the Chief of Defense and the Deputy Chief of Defense. We need to be ready to face war in space, not because we want war in space, of course, but we want to prevent war in space. Space is becoming more and more a competitive environment. A lot of countries are operating in space, and I much appreciated the first intervention talking about the dual-use dilemma, because of course with these capacities, many nations that do not have the heritage of the capacity that, for example, Italy has, then can still reach an operating space because of commercial endeavors that can be used in dual ways, of course, as been mentioned. Of course, I don't expect everybody to be able to read the numbers. It's just the dimension of the dots that is very meaningful to me. The value of money invested by each country in space. As you can see today, the United States by themselves are pretty much investing 50% of the global world resources in space, China being the second one, and Europe probably not being so big as you would expect it to be. Much more single nation from the European countries are actually providing more investments rather than the European community as a whole. Of course, we know that there have been several missions landing to the moon, and nowadays we are having 5 nations that have been proving capacity to reach the moon, and the moon will probably be the next place where people will be launching mission to retrieve precious resources. And of course, when you are talking about precious resources and economical competition, then of course there will be the need for the defense to be there and protect the interest of the countries and make sure that we can afford to participate in maybe policy rather than defense missions in space as well. And of course, there are a lot of scientific missions going to Mars with different nations that again are proving the will to develop their capacities. And again, dual capacity means that if they are able to reach Mars and if they are able to reach the moon, probably they have the capacity to use such systems also for not scientific or economical purposes as well. So we have to be ready and face this kind of challenge as well. As you can see, from 2010 to 2020, the number of commercial activities has been increasing dramatically. And the defense part of it is actually growing as well, but not as fast as the commercial part of it, which means that also is a challenge for all the world defenses to be capable of provide defense to all the assets that are working in space nowadays. And below you can see an Ukrainian soldier that is using an antenna provided by Starlink. And as we all know, Starlink is a commercial endeavor that is providing services to Ukrainian warfighting armed forces in order to provide offense and defense capabilities. And Russia has declared Starlink, even if it's a commercial endeavor, to be considered a legitimate target just because they are providing military capacity to Ukraine. And this again brings up new questions about how we should consider this kind of statement and what is the law that is actually ruling this kind of situations. As already been mentioned by Professor Aguilar, space is congested, and a very good presentation about also the space debris that are increasing dramatically, also because of the ASAT test performed by China and Russia, but not only them. A lot of the number of satellites that are increasing dramatically. Always when I give this presentation, I don't read the numbers because every day the numbers change by hundreds. So every day, 100 of satellites are launched and the numbers are changing very quickly. So space is becoming congested both because of systems being launched and used in space and also because of all the debris that are being caused by human activity in space, making more and more difficult to operate in space. And as been mentioned before, obviously space is contested. There are several systems that could be used and are used by different nations in order to prevent nations to use space capacities and space assets or space services and data, as mentioned before. So I won't go through all the capacity because of the timing that is left, and for the sake of you not taking here you too long, but just saying that it's much easier to damage a system in space, to provide a damage to a system in space rather than to defend a system in space. So it's much easier for people that want to prevent us to use space to do so rather than for us to secure space and provide a secure space for everybody, space services for everybody. We do not have to forget that space is also an extreme environment. So we are not just facing the challenges of getting ready for a war or trying to keep peace in space, but also we are doing so in a very extreme environment. That brings me to the first conclusion. That's the strategic context in which we are facing and moving for our operations. A space that is congested, that is competitive, that is contested, with space weather that is always a factor, and systems limitations, because of course technology is evolving, but also the opponent technologies are evolving as well, thanks also to the commercial activities. So it's a big challenge to follow the update of the systems. If you think that if I project a system today, most likely the system will be launched within 10 years from now, it means that the technology of today will be completely outdated in 10 years from now. So that's another big challenge. And that's the key point I want to bring to you. All this system in which we operate as at least what I would call a pool regulation, which has been mentioned by of course, who has been talking with me with much more competence than me. But what we see definitely the need for space law, both at national and international level, to definitely step up to give us some much more useful guidelines that we have nowadays. That's what we have been observing as far as regulations in Italy, but also at European and NATO standpoint. A lot of documents have been issued starting from 2019, as I mentioned, when NATO started declaring space as an operational domain. Our structure has been revised in order to be more efficient to respond to the challenges of the domain. And in 2024, this year, we are looking forward for the anticipated national space law that, of course, we will be more than willing to provide some comments or some contribution from the defense standpoint of view. Going to the capacities that we have in space, I mentioned Italy being the second nation, European nation as far as space capacity. We have a very complex and thorough constellation for radar Earth observation satellites, which are one highlight of the Italian technology, which has been many nations envy us. We have the Cosmos SkyMed first and second generation. We also have an optical satellite that provides us with very precious intelligence data. But we also have an international agreement with France, so we can exchange data provided by our constellation against the data provided by their constellation. So, of course, international agreements are very important to provide us and the other nations, of course, with all the information we need to operate thoroughly in space. We are part of the American GPS constellation that everybody knows and everybody uses on navigators and cellular phones as well. We will be part also of the Galileo constellation. So basically our defense system will be able to be receiving both signals. That means that if you are working in a jamming environment, for example, and one signal is not affordable, then you can switch to the other system and vice versa. And we also have satellites in the geo orbit, which is the most far away from Earth, SICRAL 1 Bravo and SICRAL 2, providing us and NATO as well with the SATCOM capabilities. As you can see from the flags, SICRAL 2 is an Italian satellite, which hosts also a French payload. And we also have an Italian payload on a French satellite that is Athena Fidus. Again, the international cooperation to share resources and also provide resiliency of the system, because if one of the two satellites goes down, both nations can rely on the system provided by the other satellite and vice versa. So we are working on improving our satellite communication capabilities, increasing even more what I just showed you today, because with the technology developments we are facing and the more digital need that all the world has, also the defense has need for more digital capacity. So we need to increase our satellite communication capacities, as well as to keep up with the intelligence, surveillance, and recognition capabilities that nowadays Italy is kind of a leading nation with this kind of services, and we want to keep up the lead in this system. Space situational awareness, we mentioned the space being congested. And we cannot work in space without having a thorough image and situational awareness of what's going on. Where are the systems that are not belonging to us? Where are the satellites, the debris, and where we can operate and how we can operate to avoid these systems for our safety and the safety of whoever is working in space, talking about, for example, the International Space Station. So it's the Italian defense together with the Italian Space Agency and the Italian National Astrophysics Institute we are sharing a sensor, radar, optical, laser sensor, and to provide us with a good space situational awareness in order to be always capable of maneuvering our assets in order to avoid the congested space they were facing. And I mentioned before the capabilities to switch from one system to the other, Galileo and GPS, for the future position, navigation, and timing requirements of our defense. But also we want to evolve with new capacities. Again, we are looking possibly to have a constellation for communication, satellite communication in LEO orbit. So I mentioned the one we already have in the geostrategic orbit. We want to see if we can achieve either by the defense itself or at the national level or international community level, something which would be similar with the scale of measure to the American constellation of Starlink. To provide us even more capacities. Space operations, and again, I go back to the definition of the dual use. space operations could be used to as a logistic tool in order to increase the capacities of our system, to replace them, to refuel them as we do in the air. We would like to do the same in space to extend the life of a system in space, which also is a way to provide or to prevent building more debris and inoperable satellites. But then again, any system that could operate in space for logistic purposes then could be used in not such a good idea or not such a good way of logistic, but could be used by for defense capabilities or for offense capabilities as well. So again, we want to develop this kind of capacities for at least defending our assets. Sieging from space. So as we observe the Earth from space with optical and radar satellites, we want to observe Earth from space also on the electromagnetic spectrum. So we will be developing satellites capable to observe the electromagnetic spectrum on Earth from space. Responsive space is the capacity to put quickly in orbit small satellites to increase or replace a capability that has been destroyed or maybe rendered useless by the opponent. And finally, space-based situational awareness, because I mentioned before, we have sensor from the ground observing the space, but then of course you can imagine how big space is. So it would be much more efficient to have sensor from space looking at space and providing us all the information we need. I mentioned before that we already have a defense space strategy that was issued in 2022, basically with three main goals. That is providing space support to the operation. So again, space that is always a domain from which we can provide support to the standard operational domains. Achieve what has been defined as space domain awareness, which is space situational awareness, the capacity to see everything that is in space and understand what the systems are doing, combined together an intelligence capability of understanding the capacity of the systems of the opponent, what they can do to my systems, what my system can do in order to defend themselves. And finally, develop the ability to conduct defensive space operations. Again, I go back to what I stated before. If you want to live in peace, be ready for war, at least on a defensive standpoint of view. I will just focus very quickly on the three main areas of intervention: synergy and national level. I started out by saying how big Italy is as a country with space capacity, industrial, university, research, military as well. So we want to invest on the synergy to put together all the capacity we have in order to maintain our lead in specific areas of space. And to do so, we cannot afford to do it by ourselves alone. So we need to increase also our international cooperation with our historical allies. And of course, looking always towards the technological innovation to make sure that the systems we are designing today will be efficient also for space of tomorrow. Basically, going back to the legal and policy framework, there are several areas where we're working on. You probably are aware of the COMINT, which is the Intergovernmental Committee for Space and Aerospace related subjects. And I'm very honored to be one of the 5 experts of this committee to provide all the ministry with an insight from my standpoint of view, of course, for the defense needs, also for any kind of legal and policy framework that Italy needs to develop in order to fulfill our missions in space from the defense, commercial, or national interest as well. The comment will be analyzing the new government guidelines and for space and aerospace, which will be an update for the document I presented before. So, of course, things are changing rapidly, and also the regulation needs to be updated very fast, as well as the national security strategy. And I've already mentioned we are looking forward to see the national space law, which is in progress right now. And we have been working also together with Fondazione Ronaldo, which I understand was here this morning, that has done a tremendous job in order to provide whoever is in charge of providing the new space law as a baseline with all the comments and the needs to be sure that new space laws takes into consideration all the aspects of various actors that work in space. I mentioned the cooperation. These are not to be meant to be all of the national institutions with which we have some kind of agreements or cooperation, but definitely the numbers are increasing much more day after day. We have international organizations we are part of. We have some nations with which we have bilateral agreements to work in space. The green dots you see on the maps are also officers that depend from my office that are deployed abroad, both working on a bilateral or multilateral agreements in order to have the right people in the right place to provide the Italian perspective in such environments. And of course, we keep on updating this kind of international environment just because we need, again, as I mentioned before, all the collaboration we need in order to make our capacity increase. We signed at the beginning of last year a memorandum of understanding with NATO in order to provide the new Center of Excellence for Space with Italian officers as well. We signed an agreement with the United Space Command in order to provide them with an Italian officer that will be working with them in Vandenberg Air Force Space Force Base and providing us with liaison information from the Space Command. We have signed agreements with France in order to increase even more the cooperation we already have to develop new systems together, following the Quirinal Treaty, of course. I mentioned before that our capacity are given also to NATO, and Italian being the first contributor for UHF channels of SATCOM capacity. And because of that, Italy has been chosen to be the leading nation of a multilateral consortium that is providing space capacities to NATO. And last but not least, with very good honor, Italy has been invited to be part of the Combined Space Operation Initiative, which is a very, let me say, elite group of a few nations. We are in 10 nations talking about space from a military standpoint of view, trying to find a common way to operate in space, common requirements, but also common ideas on developments or of regulations that might help us to work in a better and more regulated environment. With that, I conclude and open to any questions you might have. Thank you.
Thank you so much, General Cipelletti, for exposing all these issues, which are very interesting, military issues, which are interesting for all lawyers and jurists trying to deal with space law. So now there is some time for questions. Questions, remarks, please.
Thank you so much for the panel. Very, very interesting. Since all of you mostly mentioned the dark side of space law, Canadian songwriter Leonard Cohen has a song. It says, "You want it darker." What about if we leave darkness aside, we go a step ahead and talk about opacity, financial opacity? Let me explain. Many states, they had their state-owned corporations. For instance, Canada with Telus, many countries. So they started, with their state-owned corporations that after some time became privatized. And then more and more we saw investments of private capital and more actors from the financial sector, from pension funds or, other examples. So in terms of security, what challenges do you see if we lift this corporate veil? What's behind with all this financial opacity in the space sector? In terms of security, hurdles, challenges, please elaborate. Thank you so much.
Ministro Pulci.
Maybe I have like a reaction referring to my presentation. You're absolutely right. I mean, FDI should be monitored better in this field. And I have a feeling that banks could do more, foundations, and I mean, banks, institutions, financial institutions, because after all, these startups, what we're talking about, this new space economy, they don't have usually such great financial means. I mean, I'm not talking about Elon Musk. Musk, of course, he's a special case. But usually they will have to ask for a loan to banks. So I'd say what's important is that banks are aware, of regulations. They need to know who they're dealing with. If the investment they're gonna do by giving that loan will be fruitful, or if it will be a failure, because it has no way of being exported, of being implemented like the company, the small startup ones. So my feeling is that banks could do a lot more. I noticed that here in Italy, IMI San Paolo is very interested in space. I've followed, like, I know that there was with I don't know if it was with ISPI or EI, there was a whole conference call organized on space activities and space financing of space activities. So I think in each countries there are serious financial institutions that would like to do more, know more, do more in general. Thanks.
Which might also depend on the capacity of hegemony of the public, of a form of public program, of public planification on the scattered world of the startups, of the space startups, to the capacity of strategic planning. Any other questions?
Yes, this question of financial, the financial security for our country, also in Europe, is an historic problem. No, I saw this since 1960s up to the common market. The idea to launch the common market is not hazardous that, for instance, in microelectronics, you have the creation of ST Microelectronics, 1987, after the launch of common market, the first enterprise in Europe for microchips production, Italo-French, which is the problem. After, in my point of view, from an historical point of view, European Union has decided for the liberalization, deregulation, totally, and first of all about the intergovernmental cooperation. In which sense? We have no a common financial policy in Europe. I don't know, but we have no an industrial common policy. For this reason, it's impossible to make a comparative analysis with the USA market or North Atlantic market, the linkage. And this is a real problem. And also for this type of investment, I know also in microelectronics, 2022 European Union launched the CHIPS Act with also a panel for space, but about the first was less than 10 times less than US public investment, not all investment, private and public. In this situation, okay, you launch this torpille, and in fact, this is a real problem, historical problem also from this point of view, because we all, several European countries, also the France, has obtained very important successful targets in high technology, but thanks to international cooperation, not only European, but also a very important bilateral relationship with USA in the past, 1970s, 1980s. And this was not only from the technological point of view, but also for the US market at global level, last but not least, also for the financial security.
Well, the question is much better than the answer, I'm sure, because I don't have the answer. But I think 15 years ago tomorrow, February 10th, will be 15 years ago tomorrow, the Iridium accident occurred. It was 10 February 2009. So there is a mess over there, and certainly the debris could be weaponized, but that's my objection. I'm not really into the technicalities, but debris is by definition a piece of junk floating around. When you try to direct it and weaponize it, then it's no longer debris. It's just a projectile. It's a weapon. So clearly you can do that. I'm not sure it can be done easily or without being noticed. So probably the question on the technical side should be asked to General Cipelletti, who's in a much better position than me to answer this. Of course, there is a risk. On the other side, the debris is just floating around, and the issue should be how do we remove those? Sorry, I don't have a better answer than this one.
I don't have the answer either, but I can give you the perspective of Davide Cipelletti, not the general, but the person. China is challenging us, yes, in different ways, not with the debris issue, to my personal perspective. The debris issue, why am I saying so? Because when you have a lot of activities in space, the debris you cause will be a weapon against your opponent, but also against yourself as well. So China is showing the need and the will to increase more and more every year the number of satellites they have in different orbits. Therefore, I don't expect them to be using the debris as a weapon just because the weapon will be against themselves as well and their interests. Maybe in the past, I would have a different answer, but today and looking at the future, my personal idea is that they will not use, they're not challenging us with the debris as a weapon against us. They are challenging us in different ways.
So I cannot, of course, I cannot really conclude this day of work, not only because we're going to have another day about space law tomorrow, but also fundamentally because so many issues have been raised during this day. Issues concerning law, not only law, issues concerning geopolitics, issues concerning international politics. Tomorrow we will speak also about space economy. So all these are hints and suggestions for a path that have just started and that will go on with the International Research Center on Space Law, which has been announced by this morning by the head of department. What I would like to do now is to thank in particular the director, Professor Casata, for supporting this kind of space law adventure in Roma 3. I would like to thank Professor Zeno Zenkovic for all the strong support I had all during the preparation and the organization of these 2 days about space law. I would like to thank also Professor Rest for his support. I would like to thank Dr. Alessandro De Nicola and Dr. Cristina Frattone, who helped me very, very much in the organization of the conference and during the conference today and tomorrow. I think I could not have organized anything without their support. I would like to thank all our speakers and in particular the guests coming from outside, from other countries, coming from Europe, coming from the United States, coming from Asia. So coming from Canada, from Canada and France. So I'm so glad that you all came here to speak and to intervene in this conference. Of course, I hope and I'm certain that this conference will not remain just a scattered day reflecting about space law. I'm honored of the presence of the major Italian players in space, the Italian Space Agency, Thales Alenia Space, and of the presence of Unidroit this morning. I think all of them are hopefully partners with whom we should organize in the next future other conferences, other kind of research paths in space law and space law and what is around space law, space society, space economy, geopolitics of space in all these relationships. So it is not going to remain a single event, but we are starting a path of research aiming to develop through the creation of a specialized center the convergence between comparative law, international law, administrative law, private law, transport and maritime law, open to non-legal expertise. This is the idea of this kind of the center of research we want to create. As there are already also in Italy some groups of internationalists in particular who are doing a very good job. So what we are going to do is something of different and something that allows us to work together with all the other groups which already exist in order to go on with the research, exploring new paths and new convergences in legal research about space law. Open to external expertise, so from other universities, from other research institutes, and I'm so happy today to see people coming from other universities, other centers of research in Rome, and from other cities and from other countries. I would like to remain in touch with everyone and to support each other in our researches in space law. Open to civil society and wishing to explore forms of partnership and collaboration with institutions, with the institutions of the state. And I would like to thank the Ministry of Defense and the Ministry of Foreign Affairs for the presence of today. And I hope also, that also in the next events, we'll go on with the synergies between institutions of the state and involved in the space in the Italian space adventure and our research in the academy. And this is why I would like really to remain in touch with everyone who is here today and who will be here tomorrow. And finally, to remind that there will be a publication of the proceedings of this conference. It will be published by Roma Tre Press, the publishing house of Roma Tre University. You will receive soon information about the deadlines, the length of the contributions, the editorial criteria. So you will receive soon information about this publication with Roma Tre Press. So now let us have our dinner to finish this interesting and happy day, and let us have our dinner and meet here in this same room tomorrow morning.